Committee will be in order. Good morning, everyone. Welcome to the Joint Standing Committee on Veterans and Legal Affairs. Good to see that everyone was able to arrive safely. There are some folks who were believing that we probably would not start until noon. So here we are at 10:25. We have a quorum. There will be people back and forth because we have people on this committee that are on other committees at this point in time. We'll talk about the agenda in a minute, but we'll have our committee introductions while we have a quorum. Representative Faircloth, you may begin.
Sean Faircloth, District 24.
Good morning, everyone. My name is Ian Fredericks. I represent House District 143. That's in Sanford.
Representative Grant.
Yeah, thank you. Good morning. I'm Representative Annie Graham. I serve the people of North Yarmouth and Gray, House District 105, and I want to apologize in advance. I need to get back to another committee.
Good morning. I'm Representative Parnell Terry. I represent District 108 in Gorham.
Good morning. I'm David Boyer. I represent the individuals of Poland and Mechanic Falls.
Madam Chair.
Good morning. My name is Laura Supika, and I represent District 22, which is a portion of Bangor.
And we have our committee clerk with us, Michelle Hebert, who will help us as well. And of course, Ms. Rachel Olson, our analyst, who will get us through our work session schedule today. So there has been an update to the work session schedule that was released day before yesterday. The session that we are in now will include 1814 and 1902. We will take those up in that order. Our noon work session will be 1847, and that is no sooner than noon. It's entirely possible that it starts a little bit later than that, depending upon the first two work sessions. And we'll be taking breaks today. We'll be at ease quite a bit, just because that's what we're going to do today. The 2 o'clock work sessions, 2007, 2048, and 2080, are going to be canceled for today. And we will notify folks about when we reschedule those. It's slightly possible we'll take those up Friday afternoon, but it's more likely that we'll take those up next week. So if you are here for 207, if you're listening and you are a stakeholder for 2007, 2048, and 2080, we will not take those up at 2 o'clock this afternoon. So we'll work these first 3 bills up until at least 5 o'clock today. That is our plan. Senator Dusan, would you care to introduce yourself?
Certainly, I am Jill Dusan. I represent Senate District 27, which is part of Portland and part of Westbrook.
Good morning. If you are standing and you can't not find a seat, I'm going to ask you to find a seat, just because we can't have people standing at the door. There are a few seats that are still in here. And if we need an overflow room, we'll make that happen so folks can listen into our proceedings. So, Ms. Olson, did you have anything before we begin language reviews of any kind? She laughs. The answer is no. Now, what's your question? And with that, the chair will open the work session on LD 1814, an act to increase transparency in state government by amending laws regarding persons attempting to influence the competitive bidding process and lobbyist reporting during rulemaking processes, presented by yours truly. Ms. Olson is handing around a sponsor's amendment that has been released, I believe, 2 days ago to the IP list and to the committee. Director Wayne, you may as well come right forward if you are in the room and sit next to our analyst, since Director Wayne drafted this amendment at the request of the chair, because this is his specialty. And Ms. Olson, I don't know if you wanted to say anything about this before. You may as well remind us where we are on this piece of legislation, since this is the first work session since last session. How about we do that first?
Yes.
Thank you.
That is good. The committee held a public hearing on April 28th of 2025, last session. Voted to carry over the bill with the intent of the sponsor working with the Ethics Commission on an amendment. The committee asked for an extension to the deadline for carryovers in order to allow additional time for the sponsor, Senator Hickman, and the Ethics Commission, specifically Director Wayne, to work on that language and to accommodate different scheduling. I do have a bill analysis, but it's for the original bill, and so I'm not sure there's much value in handing that out. But you have now a copy of the proposed amendment that was drafted by ethics staff for the sponsor. Because it's printed essentially in black and white on color. I did attempt to go through and sort of star where the language was red, although there's also track changes, so I tried not to duplicate that information. But this was also sent to you via email earlier in the week, I think, or last week. And you have that version, which has the highlighting, but probably of greatest interest in terms of digesting the proposal. The Ethics Commission put together a summary of the proposed changes, and those are on the back of your packet. And at that point, I think I will turn it over to Director Wayne to talk about. the
Thank you.
amendment.
Thank you, Ms. Olson. I appreciate it very much. Director, if you could please introduce yourself.
Good morning. I'm Jonathan Wayne, the Executive Director of the State Ethics Commission.
Thank you for being here, Director, and thank you for helping your staff, helping to draft this proposed amendment at my request. I think the easiest way to go through this would be for you to walk the committee and the public through the 4-page summary that you have at the end of the committee amendment or the proposed committee amendment language, because it's got background, which I think is very important for people to hear. And then there may be some questions about where in the statute some of these provisions are and what could be some of the consequences of them. So I will let you proceed, Director, with your summary
Okay,
as presented.
pardon me, Senator. Didn't mean to talk over you there.
That's okay.
I'll try to be brief. If you want more detail, less detail, just signal and I'll do my best. Right now, Maine already has a system of lobbyist disclosure. This applies to lawyers or consultants who are hired by a client to influence legislation only. So right now, lobbying just means communicating with officials in the state government of Maine to influence legislation. And that could either be communicating with legislators, or it could be communicating with someone in the governor's office or in the executive branch agencies. But the goal is influencing legislation. Right now, someone who's hired to do that can either be a contract lobbyist, like they're part of a law firm or a lobbying firm, or they can be an employee of the client. So there's lots of nonprofits around Maine and outside of Maine that have their own employees who lobby to influence legislation. So they are also lobbyists because that's part of their jobs. They register with us at the beginning of each year, usually. There's a trigger. They don't officially become lobbyists until they have lobbied for 8 hours in a calendar month. Once they do that, they're required to register with us on behalf of that client. And then they file monthly reports with us. When the session is over, they can ask for a waiver so they don't have to file any more monthly reports, because if they say, I'm done lobbying for the year, that we take them at their word and they don't have to file any more reports for the year. And then next December or January or February, whenever they hit the 8-hour trigger for the next year, then they register with us again. There is a fee. The lobbyist is required to pay a $250 fee. I mean, I've always assumed that ultimately somehow the client pays the full cost, but I think it's, we either get it from the lobbyist or the client, but I think the client ultimately pays. Lobbyists can lobby as a team. So the lobbyist will register with an associate or more than one associate. And there's an extra $125 as a part of the fee, if they register with the associate. And then if they register with an associate, then all of the monthly reporting thereafter relates to the whole team. It's not about the individual anymore. It's about what is the whole team of lobbyists doing. So I can stop there if you want and see if there are any questions, or I can move on to what would be new under the bill.
Are there any questions for the director about the background of the current statute? Chair recognizes Representative Boyer.
Thank you, Mr. Chair. Could you remind the committee, the 8 hour, is that of an aggregate 8 hour of different bills or 8 hour per bill?
Different bills for that client. Yeah. So
Thank you. We have some committee members who have joined us. Representative Frost.
Good morning, everyone. I'm Sharon Frost. I represent District 58. 6 wonderful towns of Belgrade, Rome, Mount Vernon, Vienna, Fayette, and New Sharon.
Good
Thank you.
morning. Senator Timberlake.
Jeff Timberlake, 17.
Representative Hines.
Good morning, Representative Benjamin Himes from House District 38, 9 towns in the middle of Boulder County.
Great. Director, you may proceed with the proposed changes that are in the amendments.
Okay. So I'm walking my way for the new members who just came in. I'm walking my way through a 4-page summary that I had written and that was distributed at the end of last week or early this week.
And it's on the back of the amendment itself. It's the final 4 pages. So if you just joined us, you just turn to the back.
So the overall intent of this bill,
We're on page 2
Up the back.
yeah, of the
of the
last.
back, of the back of the summary.
So at the end of last session, Senator Hickman in this room said, I'd like to have the Ethics Commission draft a bill to sort of import provisions of the federal Lobbyist Disclosure Act into Maine's existing lobbyist disclosure law. So this is the reason I'm here giving you an overview rather than your excellent analyst is that I drafted this and provided it to the Senate chair. And so I'm giving this overview here for you right now. So under the bill, like I said before, until now, or as of now, lobbying disclosure only refers to when lobbyists or consultants are hired to influence legislation. But under this bill, the definition of lobbying would be expanded to include communicating with officials to influence a rule or the adoption of a rule, or the award of any contract, like a procurement contract when somebody wants to sell goods and services to the state. If there's an outside consultant or lobbyist involved in that effort and is paid over a certain threshold, that would count as lobbying. Same for a grant. It could be a grant to a nonprofit. It could be a grant to a construction company to do low-income housing. Rate making, that would be in the utilities context, or permits or licenses. So that could be an environmental permit. It could be a routine license, like, you want to sell liquor or whatever. Or it could be something very complex, like a complex environmental project. So lobbying would include those types of interactions with the government.
Chair recognizes Senator Timberlake.
Thank you, Director, for being here. So as I'm listening to you talk, I'm trying to understand exactly what lobbying, because when you talk about procurement, back in the day when I was selling equipment, we were selling equipment to the state of Maine. And no other way to beat around the bush, but you'd lobby after you've submitted your estimate or whatever you was trying to do for work. We did roadside mowing and stuff on the turnpike and on state highways. So if my salesman was in lobbying the state, does that count as to hire my company? Does that count as a lobbyist, or is that count as just a salesman out doing his job?
That's a salesman doing his job. And that's because Senator Hickman specified to me that he did not want to see the employees of a company or nonprofit that is trying to influence the state in a procurement context, didn't want to see that employee turn into a lobbyist. So as it's written now in the version that you have before you, it's only lobbying if the client hires an outside person, like a consultant or a lobbyist, to help with the procurement process. If the company or the nonprofit is relying on its own employees only, those employees are not lobbyists, because that's what the senator wanted.
You may proceed.
Thank you, Mr. Chair. So my question is, I heard you saying that, all right, so I think I understand that part. But you said nonprofits are excluded from this?
No, nonprofits are included. So nonprofits are covered just like businesses in this law. So if there's a nonprofit agency who wants to sell or wants to get a grant to provide some sort of social services, to needy people. They want a grant, they're applying for a grant from the state for that. If they rely on their own employees to help them with the grant application, their own employees are not lobbyists. But if the nonprofit hires an outside consultant or fundraising person to help them with the application for the grant, and they pay them, that outside person, more than $3,500, then that outside consultant would be a lobbyist.
Good to follow up on that.
You may.
Thank you. So if I'm a nonprofit or even a for-profit organization and I'm applying for a grant for the state of Maine, and I hire a grant writer to write my application for a grant, and I send it in, and I'm sending it in. I'm really not going into the state to lobby, but I paid a grant writer pretty good money to write me an application for a grant. Do you have to disclose the grant writer if they're only writing the grant to get the grant, whether it be a nonprofit or a for-profit organization? Because for-profit organization hires grant writers.
Well, that's an excellent question, Senator. I believe the answer is yes, because the definition of what is lobbying would include communicating with officials, but it would also, I might need to give it more thought, but my preliminary answer is yes, if that would be covered, because lobbying would also include preparation and planning activities, research and other background work that is intended at the time it is performed for use in contacts with officials. So I tend to think that preparing an application would be, a kind of activity that, it would be covered because it's being submitted to the agents or to the procurement people.
Thank you. Director, I'm going to ask you to just walk through the 3 pages that you had on that. And then if there are more questions about the specific language in the bill, we'll take that up then. Thank you, Senator. You may proceed, Director.
Okay. So I'm on page 2 of the summary.
Yes.
One of the things that I wanted to caution this committee and the legislature about is that if businesses and nonprofits want to bid on a procurement situation, or they've hired a consultant to help them communicate with the state for a permit, a lot of them don't think of themselves as doing lobbying. Those aren't like lobbying situations. And a lot of them don't even know that our agency exists. So if this were enacted, there would probably be a lot of inadvertent violations where a business or nonprofit paid someone more than $3,500. That's the threshold, $3,500 in a calendar quarter to help them with one of these administrative decisions. But they don't, it's new, it would be brand new. There would be a phase-in period where no one would know who's the ethics committee. I don't have any ethical problems. Why do I have to register with the ethics commission? I'm just trying to get a contract or grant, and I hired somebody outside. So there will be folks, I guess it would technically be the contractors who would be sort of unintended. They would unintended violate this law because they wouldn't even know they'd had to register and file reports. And that's a matter of concern for us because of workload for us, but also because you have to think through, is that what you want to be part of the procurement? I'm not trying to, it's just a trade-off. Disclosure is good, but when you precondition certain free speech activities or business activities on having someone filing some paperwork with the state, then that's always there's administrative work involved in having to go through that process because they have to register with us. They have to file bi-monthly reports. They also would have to pay a fee of $250 to us but you can change that. That doesn't, this is just a first stab at the legislation, but as written, they would have to pay a $250 fee because they hired some outside person to help them with the contract or the grant. So I'm not trying to sink the idea.
Oh, it's fine.
It-
This threshold is from federal law,
Yeah,
the $3,500.
yeah. And so all of this can be modified. This
Yeah.
is my first attempt to produce what the Senate chair wanted. But it deserves to be part of the conversation.
Absolutely.
The threshold I've already referred to. So with regard to rulemaking, if there's a business or an association or a nonprofit that wants to influence an agency rule, the threshold for who becomes a lobbyist is the same. Now I'm moving on to the top of page 3 of the summary.
Mhm.
Would be the same as it is now, which is 8 hours in a month. So if a client hires a lobbyist to influence legislation or rulemakings for that client, and they go over 8 hours in a month combined for those two types of target activities, then they would have to register with us and file reports. And then with regard to the contract, with regard to communicating on to influence a contract, grant, rate making, permit or license, the threshold is paying some outside person $3,500 in a calendar quarter. Once that happens, the outside person has to register with us, pay a fee, and file bi-monthly reports as it is written now. And, you can set it up however you want. That's just an initial suggestion. I think for brevity's sake, if the committee's okay, well, there's one other thing that deserves note that the two other things in here. Well, one is that we think right now we have one position that handles all lobbyist disclosure and also the campaign finance disclosure by the PACs and all the party committees and the ballot question committees. We think that person has her hands full and she could not take on this additional work. So we believe if we were to be given these responsibilities, we would have to go from a 6-person agency to a 7-person agency. And it would be, under the way our budget is written now, it would be appropriate for the general fund to pay for that additional person. So as it's written now, we would, if asked by the fiscal people here at the legislature, we would say that there's a general fund cost to this bill as it's written right now.
Thank you, Director. And for the committee, if you recall, when we had this work session a week or two ago, I had thought that we might move ought not to pass. And since then, committee members said, I don't want to vote ought not to pass. I would like to vote for the bill. So I'll ask any committee member, I won't put anyone on the spot. Questions. I will ask you to talk to the director about which parts of this proposed amendment you like or don't like, because that's going to be the report that is ultimately suggested to the legislature for review instead of a straight ought not to pass. So who would like to take a stab at the provisions as they are outlined in the summary, like or don't like, want to change or not change? And we'll go from there. Chair recognizes Representative Boyer.
Thank you, Mr. Chair. I think the director made, a valid, acknowledgement about the technical compliance that's going to happen if we were to do this. And I would expect, that the Ethics Commission, operates with some grace regarding these folks. And to that end, I don't know if we could add some language in the bill or unallocated or something. Just couldn't we help alleviate some of those issues by putting in some boilerplate text in the state's RFPs and other stuff that goes out and say, hey, if you get paid $3,500 or more in a quarter to work on this, you got to tell us, you got to register with ethics. Do you think that could be helpful?
Yeah, I think people in the executive branch would be better at who are involved in the procurement, the state procurement office or DAPS would be better at that. But yes, I don't see why that couldn't happen. And there could be guidance on websites. There'd be a number of ways you could do educational work. You could also structure the enforcement process for like 2 years where we're directed to show more grace. We could do that too. So.
Chair recognizes Representative Fairclough.
Thank you, Mr. Chair. My question is to help me understand whether I'd be feeling positively inclined toward this without further information. When was this completed, the terms here?
The drafting?
Yeah.
So I provided the Senate chair with a draft in November. And then after the session started about 10 days ago, he let me know there was an unintended consequence in the bill. And he asked that it be drafted a little bit differently. So I provided this revised draft to him on February 5th.
So for me, informationally, I noticed before in the earlier version, there was testimony in opposition from Maine Municipal Association, actually including from my own, separately from my own city manager, Maine State Bar Association. So I'm curious to know if there's been kind of a discussion process there to understand, and maybe they say hunky-dory to this in triplicate, but I don't know that yet. So I'm just curious.
Yeah, to be honest, I didn't look at the prior testimony. I was sort of taking my marching orders from the senator, which was take the Federal Lobbyist Disclosure Act and bring aspects of it down here into Maine disclosure. And so I can take a look at it if you want, and I can look at some of that testimony and see whether I feel like it's being addressed or not, and send you some bullet points on that. If you
I
want.
appreciate
If you don't
that.
want it, then-
I'd also be interested in making sure they have reviewed it and what their response is.
Yeah.
Chair recognizes Senator Timberlake.
Thank you, Mr. Chair. I think my concerns was I was actually thinking that I could maybe find a way around supporting it, but after listening to the director this morning and I don't think the bill's ready at this point in time. I think there's a lot of variables out here. I think one of the things that really concerns me is grant writing. I mean, I know farmers throughout the whole state and businesses throughout the whole state who hire grant writers and people to do all this. And I think they would not intentionally break the law, but could be caught with breaking the law. And then, they got to register and they got to pay a $250 fee to even register. So now you've added, for anybody that wants to file for one of these, now has to pay $250 to even file for a grant. And that might be getting a $50,000 or $60,000 grant or something. And I don't know. I don't feel right. I don't think I'm not saying that it's bad, but I don't think it's ready for what I guess the better word of saying is prime time at this point in time. And I think it needs more work.
Chair doesn't actually disagree with you, Senator. I saw the draft. In any event, I would believe that the substantive changes presented here require a public hearing, because the other version of the bill was not this. And that is why I didn't distribute the version. I had to look at workload. As we talked about a few weeks ago, life happened in the intercession. And so we weren't able to meet. This would have been something on that agenda. All of that being said, we brought this forward for this work session because there were people who wanted to vote for the bill. And so I'm ready to do whatever the committee wants to do. And I thank Director Wayne for putting this together. It's instructive, and it would probably need to change even for my support of my own legislation, given some of the pieces in it that are troubling. Senator Timberlake?
The only thing I just wanted to add and the other thing I think that probably makes this very hard at the end of the day is listening to the director, and it's going to come out with a fiscal note on it.
Correct.
And that fiscal note is going to be, I think in this session, it's going to be the death
That's correct.
trap anyway. So
That is correct. Chair recognizes Representative Boyer.
Thank you, Mr. Chair. For clarification, a nonprofit or whatnot, they'd only have to register if they're being paid $3,500 or more in a quarter to do the thing to write that grant or whatever. It's not their salary if it's right.
So the nonprofit in this case is being hired to help, or they're the client that's hiring somebody else?
They're hiring a consultant. If they pay the consultant less than $3,500 a month or a quarter, they wouldn't have to. And then how would it work for just an employee whose responsibilities are to write grants?
Yeah, so this was specified by the Senate chair. As written right now, if a nonprofit is paying its own employees to apply for grants, that's not lobbying. They wouldn't have to register or file reports.
That's helpful follow-up, Mr. Chair.
You may proceed.
I think I wholeheartedly support the policy. Because right now, for example, a former administration official, maybe 2 years ago, if they were hired by a nonprofit for the purposes of procurement or rulemaking, there would be no disclosure whatsoever.
Not to our office.
Right, and I obviously sounds like that's the point of the
Yeah,
bill, right? And I'm just giving an example of why it's important that we do have some reporting. In my opinion, rulemaking is where the rubber meets the road on a lot of policy. And we've had a lot of issues with procurement in our state recently. And so the idea that a lobbyist can lobby the executive branch on rulemaking and procurement and grants and not have to tell anybody or report anything is not the standard among other states and our federal government. And I think it does need to be addressed.
Could I make a comment
You
on
may.
that? When this bill was heard last session, and maybe this is a point of view that's not acceptable to some of the committee members, but I'm just going to repeat what was said, because I spoke with another person in DAPS in the commissioner's office recently. And both of these people had the same point of view, which is they believe there isn't a lot of lobbyist contact with departments for purposes of influencing procurement. And some of you may be skeptical, but the concern that was expressed by DAPS Commissioner Figueroa was, could this lobbyist disclosure bill actually sort of permit or give a blessing to the idea that there are lobbyists who are interacting with departments for purposes of procurement? I'm not saying that's my point of view. I don't know what the reality is, but that's what the testimony was before. So I'm just sharing that.
Yeah, thank you,
Yeah.
Director. That was a testimony. And then there were lobbyists who said, we do that all the time in the hallway. So, you know, if it's in the
Yeah.
Federal Lobbyist Disclosure Act,
Yeah,
the activity happens.
Yeah.
And it's in other state laws, the
okay.
activity
That's true.
happens. And
Okay.
Maine is not so special that it does not happen. And when lobbyists tell you to your ear that they do this and they don't have to report, then it's clear that it happens. And so obviously I support the policy, otherwise I wouldn't have proposed the bill. But this is a big change in Maine if it were to happen. And that is why I offered that we don't take this up this session, especially when the director gave me a fiscal note possibility that this would increase their staff. And so what's the trade-off? The status quo or not the status quo with lots of questions and more money being spent, which the state doesn't necessarily have right now. So that is why I have requested that we move the bill to die. But people wanted to vote on a piece of public policy, so here we are. Chair recognizes Representative Boyer.
Thank you. I'm just going to read the last paragraph from the testimony from the commissioner, and I'd like you to tell me, I'd like a clear answer as much as possible. DAPS urges the legislature to take a stronger stance and make it clear that lobbying with respect to an open or anticipated competitive procurement is strictly prohibited, rather than signaling an open season for such lobbying by establishing a mechanism for it to be reported. Is it legal to lobby the executive branch regarding rulemaking and procurement today?
I don't know. Is the honest answer, because we procure IT companies, we procure auditors. I can tell you that the whole procurement process is heavily regulated. It's like there are all sorts of rules.
Mhm.
I'm not, if we were to have any contact with an actual bidder, it would be under very prescribed circumstances. Like you have to have a bidders conference, they can submit questions. So I don't know, Representative Boyer. I'm not trying to duck the question. I
understand.
don't have the breadth of state government activities to know the answer to that.
Is there violations for it?
I don't know.
Thank you. There are none because it's not required, so there wouldn't be violations. I think that, and I'm going to call on Ms. Olson in a moment to provide some clarity. I think one of the really interesting things about the Federal Lobbyist Disclosure Act which would be included in this bill, is that it's also about influencing rate making, permitting and licensing. And these are not small things, and they're not procurement. And we know that we have issues with our rates right now. And there's been a lot of conversations about it. I don't know if anyone is trying to influence those outside of the public view. But if it's in the Federal Disclosure Act, it probably is action that happens. And again, I would like to see more transparency in state government regarding this. I'm just not so sure that this is the right time to do it because this bill is complicated. Ms. Olson.
In terms of, Director Wayne is correct. It's the procurement process is heavily regulated in statute. When you're talking about the competitive bid process, if a member of a evaluation team, the people responsible for reviewing and scoring bids that have been submitted, proposals that have been submitted, they need to, say that they have not been contacted by or tried, been influenced by an outside source connected to that. They affirm this, but if it was, if someone believed that to be untrue, they could challenge the award of the contract through that process. So I think that's the sort of provision within that. And I'm not an expert on that. I just am aware of that exists in that process.
Well, we have an expert in the room on that if the committee would like to hear from her. Are there any questions for Director Wayne while he is still with us? Seeing none. Thank you very much, Director Wayne, for putting this draft together and the summary, which is very helpful today in our discussion. So for the committee, does anyone want to hear from DAF about procurement or any other thing that is not in the testimony that we got from former Commissioner Figueroa? Seeing none. What is the will of the committee on LD 1814? Chair recognizes Senator Timberlake.
Mr. Chair, I'd make a motion not to pass.
It's been moved ought not to pass. It's been
Second.
seconded by Representative Frost. The motion is ought not to pass. Is there any discussion of the motion from the committee? Is the committee ready for the question? Madam Clerk, please call the roll.
Thank you. Senator Doosan.
Yes, to ought not to pass.
Senator Doosan votes yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Timberlake.
Yes.
Senator Timberlake, yes. Representative Graham absent. Representative Terry.
Yes.
Representative Terry votes yes. Representative Frost.
Yes.
Representative Frost votes yes. Representative Chapman absent. Representative Boyer.
Yeah.
Representative Boyer votes yes. Representative Supika.
Yes.
Representative Supika votes yes. Representative Hines.
Yes.
Representative Hines votes yes. Representative Fredericks absent. Representative Fairclough.
Yes.
Representative Fairclough votes yes. Representative Mallon absent.
9 members voting in the affirmative, 0 in the negative, with 4 members absent. The motion prevails. Absent members will have until Friday at noon to cast their vote. In absentia, the chair closes the work session on LD 1814. Thank you, Ms. Trundy. And thank you, Mr. Sultan. You didn't have to yell at your state senator today. The chair will open the work session on LD 1902, an act to support nonprofit organizations by authorizing the operation of electronic Lucky 7 devices and similar sealed ticket games sponsored by yours truly. Ms. Olson, however you would like to begin this part of our work session. Please pray.
All right, Michelle is handing out printed copy of the sponsor's proposed amendment that was distributed this morning by email.
Thank you, Ms. Olson, very much. Thank you.
During the previous work session on the 28th of January, the committee tabled the bill to allow the sponsor with stakeholders additional time to consider some of the points brought up in the bill analysis. some of it technical and other substantive, and to potentially address some of the concerns of members of the committee. The sponsor and stakeholders worked on the proposal before you, and I can walk us through the changes that are provided in the bill. And attempt to answer in the amendment, and attempt to answer any questions, although there are certainly people in the room with more technical experience for this type of gaming, who could answer some other questions. It's drafted as a strike and replace largely. Well, there are some changes, but also because we had to go back and use what is now current law, which is different than what was in the bill when it was printed. So section 1 still makes a couple of technical adjustments and expands the period of time that a Beano game can be operated. That's less specific to the bill before you. And then section 2 will dive into the proposal related to electronic field ticket games. So it does have a new title. It's an act to authorize the operation of electronic sealed ticket games by certain qualifying fraternal, patriotic, or veteran organizations. So the proposal is changing some of the terminology, but not necessarily it doesn't change the idea of what the type of game is, but it is adjusting some of the terminology to try to reflect what actually is out there in the business practices. And then it does additionally narrow the scope of eligible organizations and we'll talk about this, but to fraternal, patriotic, or veteran organizations that are already eligible to offer games of chance. But it's a smaller subset of those eligible organizations. And then there are additional requirements for those organizations in order to offer electronic sealed ticket games. So as last session, Lucky 7 or other similar sealed ticket game or any variation of that phrase was amended in statute to now just refer to a sealed ticket game. And so using that as the model, we are now going to offer the definition of an electronic sealed ticket game. And that means a sealed ticket game as defined in subsection 14B, where the tickets or cards, which are discussed in the definition of sealed ticket game, are represented digitally, and the digital tickets or cards are displayed on the screen of an electronic sealed ticket game terminal, which we will also define. Additionally, as the conversations with the stakeholders progressed, it became clear that we were not just talking about the gaming terminal, but that these are actually entire systems. And so what I mean by that is that it's the terminals, but it may also be a point of sale system or redemption kiosk, and it also includes software and other hardware. So when talking about regulating this activity, this proposal expands the scope to also include all of these subsets, all of the system parts. And so you are provided a definition of electronic sealed ticket game system, which means an electronic sealed ticket game terminal, electronic sealed ticket games, and any electronic devices used to facilitate the operation of electronic sealed ticket game terminals, including all related hardware and software. So that's meant to encompass anything that might be used to operate these games. And some of this gets at the concerns that were brought forward by Director Champion around auditing. So the systems provide, I think are intended to provide better financial tracking and reporting and the ability for auditing as they speak to like point of sale systems or redemption kiosks. And these are a part of the package that come with your terminals. The proposal also regulates electronic sealed ticket game system distributors, which is defined as a person, firm, corporation, association, or organization that leases, or otherwise distributes electronic sealed ticket game systems. The terminal definition is more detailed and is intended to try to put up some of the sort of guidelines or guardrails that help to distinguish these terminals from other electronic gaming devices. The definition is electronic sealed ticket game terminal. That means an electronic device that upon the insertion of cash or a voucher allows a person to play an electronic sealed ticket game. That's the defined term from earlier. The element of chance must be provided by the electronic sealed ticket game tickets and not by the electronic sealed ticket game terminal. An electronic sealed ticket game terminal may only issue to a player a printed voucher for any prize, including a monetary prize or single set of prizes won by that player, or for any remaining value due to the player at the end of play. The intent there is, I think if you put a $20 bill into the machine, if you only played 10 of it, it could issue you a voucher, which you would then have to redeem with the operator for the remaining $10. Or you could take that and move to a different machine and insert it and play that $10 on a different machine. That's the voucher terminal. An electronic sealed ticket game terminal may not dispense cash to a player. Electronic sealed ticket game terminal does not include a dispenser as defined in section 314A, subsection 1A. These are the dispensers that are authorized for high stakes Beano when it is being conducted. These are electrical or mechanical, and that is potentially different than electronic. But making clear that these are not the same things. And is not a machine as defined in subsection 9. Subsection 9 of this chapter defines machine, and the definition could be interpreted to include these types of devices, and machines are not prohibited to be licensed under this chapter. So they are clearly excluded from the definition. There are a few adjustments to the chapter. So the overall Chapter 62 outlines the provisions for games of chance. Within Chapter 62, there are specific sections that provide more guidance or extra regulation for certain types of games of chance. Raffles, internet raffles, super cribbage, card games, tournament games. So those are all sort of pulled out. They're all games of chance. But for some of them, we have these extra regulations than other games of chance. And sealed tickets they do not have a special holdout section. So they just sort of fall with all of the other provisions related to other games of chance. So in some cases, like in section 6 on page 2, we've added the term electronic sealed ticket games because this applies to all games of chance, and just making sure that, because it does specifically also cite card games and certain tournament games. This provision about the age is also included in the new section for electronic sealed ticket games, but it's also added here. In section 7 of the proposal, also on page 2, this is section 1832. 1832 provides for licensing and registration for persons or organizations that are eligible to operate games of chance. It's establishing a new subsection 9 for electronic sealed ticket game licenses and requires an application. And this provides who's eligible for this type of license. And so this is the section that provides the narrowing of the scope. So now the Gambling Control Unit may issue a license to operate electronic sealed ticket games to a bona fide fraternal, patriotic, or veteran organization that is eligible for a license under subsection 2 that's the eligible organizations that we've talked about. That also includes agricultural fairs and firefighting and auxiliary groups, and also some other nonprofit charitable organizations. But this is saying this is only going to be available to that much smaller subset of those eligible organizations. So fraternal, patriotic, or veteran organizations. They have to be eligible for the game regular games of chance license or registration, or license in that case, to also be eligible for this. But this license isn't open to all of them. It's only open to fraternal, patriotic, or veteran organizations. And then in addition to that, those organizations also have to have restricted social quarters on their premises designated for use predominantly by members of the organization for social and recreational activities. That is accessible, so let's just say that is accessible exclusively to members of the organization and their guests. And that is not advertised or open to the general public. So if you don't have a if you are a fraternal, patriotic, or veteran organization and your physical premises doesn't have restricted social quarters, then you would not be eligible for this license. Then an organization has to submit an application to the Gambling Control Unit signed by the duly authorized officer of the organization. That has to have their full name and address of the organization. It must include the number of electronic sale ticket game terminals to be operated, and the section outlining the operation does have maximums. So we'll look at that in a second. A description of the restricted social quarters on the premises where the electronic sale ticket game terminals will be located. And any other information determined necessary by the Gambling Control Unit for issuance of this type of license.
Thank you, Ms.
yeah.
Olson. We're going to take a question before we move on. Chair recognizes Representative Boyer.
Thank you, Mr. Chair. Is there a definition for patriotic organizations, or how do we wrap our arms around, what that looks like, and how many eligible organizations there are now with this amendment versus the previous one?
There is not a definition in statute for that, but my understanding is that the Gambling Control Unit does have an understanding of what that is and could provide you with information about how many entities this might be. They may not know if each of those organizations also has a restricted social quarters, but they, I think, could answer the first question for you. But then these are the ones that are already eligible, so we're not expanding it to anyone that's not already able to be licensed for a game of chance under this chapter. So it would be from that subset, or from a subset from the list that we were previously provided.
Representative Boyer, would you like to hear from Director Champion?
I would, and as he comes up, thank you, Mr. Chair. I was just Googled patriotic organizations, and there was a federal kind of list, and it included things like Red Cross, Big Brothers Big Sisters, American Chemical Society, Teachers Union. So I didn't know. Yeah, I'd love some guidance on that. Thank you.
Director Champion. Good morning. Please introduce yourself, sir.
Good morning, Bill Champion, Executive Director, Gambling Control Unit.
You understand the question, sir?
Yes, I do. So right now, we have roughly about 400 and some eligible organizations. And of those, the ones that actually registered, and they not only have to register with us, but they have to establish their organization. And so, to my knowledge, up to this point, they designate themselves as one of these particular areas. So there's no real definition, there's no separation, it's just how they file their organization.
Representative Boyd.
Thank you, Mr. Chair. And is there anything in the amendment that would preclude an organization performing for the sole purposes of raising money this way?
Well, I mean, they would have to meet the requirements, they'd have to have a designated building, an area within the building and so forth and so on. So it's not like they could just come up and, you know, this will be like comparing to like a snowmobile association that has a building that they only use twice a year. They're not going to be eligible to put these devices in.
If I may
You
also
may.
add, as it is currently drafted, you have to be eligible for a license under subsection 2, and that, which is of 1832, subsection 2. That provision does require the organization to have been, I don't have it right in front of me, but I have my notes from the bill analysis, but it does say that they have to have been founded, chartered, or organized in the state for a period of not less than 2 consecutive years prior to applying for the license. So there is a little bit of a time buffer.
Thank you. That's helpful. Thank you.
Thank you. You have another question? Chair recognizes Representative Fairclough.
Thank you, Senator. Just to clarify, when you were giving the answer, was that patriotic and fraternal? Fraternal is separate, like there's definitions for each?
No, I don't think it's real clear. It's in the statute. And when they apply as whatever category they're applying for. Okay. And then we go through our process. They have to register federally or develop their 401(c) or whatever. So that's all established before they even apply. And of course, they have to be chartered and operating for at least 2 years before they need the license.
See,
And you said cumulatively, whether it's veteran, patriotic, or fraternal, the grand total of all of those is whatever, 400?
Yeah, I think the estimates we produced in another session or at the public hearing was the numbers actually went from a total of around 400 and some eligible organizations, and of those, only 120 are actually falling under this category. And then from there, we'd have to actually go out and see the facility, do our inspections of the facility to see if they meet the other requirements as well.
so 120 are currently licensed to do some form of charitable gaming?
Correct.
Thank you.
Correct.
Ms. Olson, you may proceed. Thank you. And Director, you may as well stay put. I'm sure there'll be other questions for you as well.
Okay, we're still on page 2. Section 8 establishes the license fee for the operation of the games and for a distributor. So Section 8 has the fee for a license to operate electronic sealed ticket games as $1,000 per electronic sealed ticket game terminal in a calendar year. And then Section 9 establishes fees for the system distributors. That license fee is $5,000 for each calendar year or portion of a calendar year. This proposal also includes language here regarding the ability for the director to charge a one-time initial application fee in an amount equal to the projected cost of processing the application and performing any background investigations. There is not other language in the proposal that specifies that the director may or shall conduct background investigations for distributors. So this is the only mention of that. If the committee would like to make sure that background investigations are conducted for system distributors, additional language may need to be included in the section for distributors. They're under the application section to make it clear who's required to have the background investigation and a couple of other, provisions related to that. Currently, internet raffle operators are required to have a background check. That's really the only section in Chapter 62 that specifically identifies background investigations. That's not to say that they're not happening for other entities within the games of chance laws, just they're not specified. So we might want to look at that.
Director Champion, can you address that in this moment?
Yeah, well, I think it's probably addressed in the section regarding the sealed ticket game system distributors.
Mhm.
Talks about in 1840-A1, distributor license,
What page are you on?
page 6.
You're jumping ahead to page 6 to see if this is addressed somewhere.
So it's not specifically mentioned in this section.
Okay,
The gambling control unit is allowed to adopt rules regarding the licensing of electronic field ticket game system distributors, which are routine technical rules.
so the
Yeah.
question that I have is, Ms. Olson said, Director, that statute explicitly talks about background investigations for internet raffle operators. But that's the only place. So the question is, do you require background investigations of other folks involved in systems or operations in the charitable gaming side that are not in statute, but that are made in rule? Or just normal course of you approving a license for someone?
No, I don't think so. I mean, the only other device we have is electronic video machine devices. Distributors have to be licensed, but there's not a caveat cut out for actually doing a background.
And as far as this particular bill is concerned, what is your input around that? Do you want to require background checks for the distributors of these systems?
Yeah, I think it's as part of the application process. We talk about service agreements, lease agreements, and all that sort of thing. So I think the background investigation would be appropriate in this situation.
And Ms. Olson, if that is the case, the committee will decide if we want to do that or not. We can flag where that language should go. You propose a new section or something similar to the internet raffle background section of statute?
Yes, I think it would be most appropriate in the section regarding the licensing applications for the distributors. And I would be able to use the internet raffle operator language to draft an appropriate section, which the committee could consider upon any language review of any proposal voted on by the committee.
Thank you. Then you may proceed. We were in section
10
10.
on page 3.
Thank you.
So this section provides for the operation of electronic sealed ticket games. And it does a number of different things. So it first starts by providing a definition of eligible premises. And this, because we use the term throughout, and so basically make it easier. But what we mean by that is the restricted social quarters on the premises of the licensed organization designated for use predominantly by members of the organization for social and recreational activities that is accessible exclusively to members of the organization and their guests, and that is not advertised or open to the general public, and was included on the application for a license under section 1832 subsection 9. So that provides and gives you the sort of context for the rest. So then subsection 2 requires that the licensee lease an electronic sealed ticket game system from a licensed game system distributor. That the system must include a method for players to redeem vouchers issued by an electronic sealed ticket game terminal. That an electronic sealed ticket game system may only be operated by duly authorized members of the licensed organization or by persons employed by the licensed organization for another purpose within the eligible premises. Intent of this is that currently bartenders are, for example, are allowed to sell the paper sealed tickets. So this is, again, presumably that if this is a space that has the social quarters and you have someone there who's doing the other social activities and they are an employee, that they can also run the system because they may not be a member of the organization, but they could be both. They could be a member and an employee, but And then that a person under 18 may not operate an electronic sealed ticket game system. So to operate is different than to play. They're both prohibited for people under 18, but I just want to be clear here that in this case, to operate is what the licensed organization is doing by offering the game. Then subsection 3 establishes that the game terminals must be certified by an independent laboratory approved by the director, and that these terminals may only be moved into, out of, or within the state by a licensed distributor. Systems distributor. And then subsection 4 establishes the number of terminals allowed per premises of the licensed organization, per eligible premises of the licensed organization. So no more than 5 electronic sealed ticket game terminals for a licensed organization with up to 100 members, or no more than 10 electronic sealed ticket game terminals for a licensed organization with 100 or more members. These are per premises, eligible premises. So if they had more than one location that also had restricted social quarters, they could operate it at both locations with these numbers. That's how that's drafted. But no more than 10 at each physical location. It does allow the director to authorize additional electronic sealed ticket game terminals based upon benchmarks established by rule, as long as no licensed organization operates more than 10 per eligible premises of the licensed organization. That is a carryover from the previous version. It establishes hours of operation. So these terminals, they are connected to a system. And that system has the ability to be programmed to turn the terminals off at specific times. And that could be like pre-established, always the case, and also in certain situations. And then my understanding is that the licensed organization, the operator, can also disable the machines. So it can be done at both levels. But the hours of operation established are that an organization can operate the terminals for 12 hours during any day, except that they may not be operated between 2 a.m. and 10 a.m. And they may not be operated during any time when the eligible premises is being used for an event where the majority of participants are under 18 years of age, or when the majority of participants are members of the public. So if they opened up their restricted social quarters to a public event, the terminals would need to be disabled. Or in the other case, let's say a member is using that space for a bar mitzvah or bat mitzvah or a quinceañera where, they might all be members, but it's a party for people who are under 18 and the majority of participants they're probably under 18. So that's the reason for the 2 phrases, is to kind of get at both situations. It establishes the criteria regarding the number of tickets or cards per electronic sealed ticket game. It does authorize the electronic sealed ticket game terminal to offer more than 1 electronic sealed ticket game. So you might sit down and have a choice of which kind of game you want to play. I use this example, it dates me, but Pirates of the Caribbean version versus a Jumanji version. And that is apparently not the target market though. So, so you can pick, but each of those games, will contain a fixed number of tickets or cards, which may not exceed 25,000. That number is also carried over from the previous version. An electronic sealed ticket game may only be played by a member of the licensed organization or by a guest of the member of the licensed organization. Presumably, they're the only ones allowed in the restricted space. And a person under 18 years of age is not permitted to play electronic sealed ticket games. It establishes, or it establishes a wagers maximum, although it relies on the current games of chance provision in section 1835A, subsection 1, paragraph A, which is $5. It also outlines the use of revenue. So electronic sealed ticket games may be operated only for the exclusive benefit of the licensed organization, except that up to 20% of the gross revenue from the operation of electronic sealed ticket games may be used to compensate those members or employees of the organization who operate electronic sealed ticket games. Up to 30% of the gross revenue may be paid to the systems distributor as a leasing fee under a contract approved by the director. And the director may collect from each licensed organization a fee equal to 1% of the gross revenue, which has to be deposited in the GCU Administrative Expenses OSR funds account. It's a non-lapsing dedicated account. And those fees are due on the 10th of each month for the prior month. It also provides that any payments not remitted when due must be paid together with interest, and that the interest on the unpaid balance is 1.5% per month. My understanding is that is a requirement for other fees submitted in other sections of gaming law. And we'll talk a little bit about records of reporting in a moment, but to understand how that process will work. Licensed organizations shall keep records and submit reports in accordance with section 1839. So it's just tying to that, which we have made a few adjustments to. You'll see that momentarily. And then that you may not operate these machines in a way that meets the definition of illegal gambling machine. And then allows requires the gambling control unit shall adopt rules to facilitate the operation of electronic sealed ticket game systems. Rules must include, but are not limited to, rules regarding the registration, certification, auditing, and shipment of electronic sealed ticket game systems. And those rules are routine technical. Any questions before we move away from the operation provision?
Chair recognizes Senator Jim Lake.
Just because I was doing some quick math, as
Yeah.
I was reading on page 4 on the revenue compensation fees 9. I total up to about 51%. Where's the other 49% go?
So that is the licensed organization retains
I
that.
thought they only retained 30%.
No, that goes to the distributor.
Okay,
So up to, so you would
and
enter into
20% goes to the,
mhm. Yeah, so you may use 20% to compensate an employee or a member. So you can take some of your.
okay, so the
of
other
your revenue.
49% stays with the organization?
Yes, and
Okay.
it's supposed to be used.
I
for
say,
the-
and now, I didn't understand what the 20% was at first. I'm sorry, my mistake, sorry.
Yep, and it's,
Thank you.
those are just up to as well, so they may not spend up to that amount, but.
Okay.
And that provision, paragraph A, the 20%, that actually comes from a current provision regarding the use of revenue by these organizations conducting games of chance. So that is the name. That section also includes the ability to use revenue for, I don't think it's actually a workers' comp claim, but something kind of similar to that. Help me out, Mel.
For injuries.
For injuries.
Yeah.
Thank you. This doesn't specify that. So we could examine that if you'd like. Okay, other questions about operation requirements? Section 11.
Representative Boyer
Sorry.
has a question about something in this section.
Okay.
And my apologies, I had to step out for a call. What's the tax rate?
There is
1%.
Oh, well, there's the 1% administrative fee, but there's no additional tax rate or cascade.
And the 20% was confusing me. It sounds like I caught the tail end of it. 30 go up to 30 to the distributor, 1% for the GCU, and 69 for the organization.
Yeah, Yeah, if you add the 20% in, yeah.
But only up to 20% can be used for the employees?
Yeah, for the employees who are specifically operating them.
Was this a policy rationale to prevent like high salaries from this revenue or something, or?
I don't know why the legislature chose that at the time that it established that provision for other licensed organizations conducting games of chance.
Thank you.
It's what's currently provided, so.
Mr. Champion?
Yeah, and if I may add, I mean, essentially, they're looking at, forget the 20%. The organizations are gonna look at, they're gonna pay the distributor up to 30%. So if you have a small organization that only wants one machine or two machines, their percentage might be only 12%. Where somebody that comes on board and they have more than 100 members, they get the all 10 machines, you know, that might be the max 30%. But figuring this out, you should only figure on the 30 and the 1%. The 20% is purely optional by the organization. So what they have to abide by or have to pay out is 31%, and then they keep the rest.
Thank you for that clarity. Any other questions on this section? Moving right along, Ms. Olson, we are now going to get to records and reports. Section 11, page 5.
So section 11, section 1839, this applies to all records and reports under the Games of Chance statute chapter. And so some of the changes in this section will apply to current licensees or registrants. And these changes were provided by the Gambling Control Unit. And my understanding is to address some of the concerns that were brought forward during the public hearing about revenue reporting and auditing. And then I stuck a few or conducted in there because really the chapter has operation and conduct, to operate and to conduct as the method. So I think that that's a technical change. But the provision in 1 is to add, so currently revenue from more than one game may be entered into one account, so you don't have to have separate accounts. And the director had asked to have included and was included in the amendment, the provision that you may do that as long as the revenue from each game operated or conducted by a licensee or registrant is deposited into the account in a separate transaction and recorded separately from other game revenue. So you can have the one account, but when it comes to depositing that revenue and accounting for it in your bookkeeping, you need to clearly identify which games it's coming from. Is it coming from your paper sealed ticket? Is it coming from your electronic sealed ticket? Is it coming from a bingo game? So that's, I think, the intent.
Yes,
And that is to help with auditing of this particular activity.
absolutely.
Thank you.
And then in addition to that, in subsection 3 regarding the disposition of funds report, it adds or details that when submitting this report, that it includes, rather than receipts and expenditures of the game and the disposition of funds, that it includes gross revenue, each deposit that matches the total gross revenue and any allowable expenses under the chapter for the game. This provision is set up for reporting within 10 business days after the conclusion of each licensed game, or the last day, it looks better phrasing there, but because the way that other games are, they're not offered continuously. And so at the conclusion of the game, whether that's a bingo night or a card tournament or the end of the sealed sealed ticket game, and you're licensed for the game, not a period of time, then you would submit your report. In this case, these terminals will operate, will be in place and can be played sort of continuously. And so you might not have the traditional end of game that you have with other forms of gaming in this chapter. And so the last section provides that for an organization licensed under section for electronic sale ticket games, that you'll file your disposition of funds report monthly. And it's due by the first of the month for the previous month. And then the changes in 4 are, and 5 are technical. So section 12 outlines the requirements for the electronic sealed ticket game system distributors. So they have, subsection 1 is that they have to be licensed. And that if a non-resident manufacturer or distributor of electronic sealed ticket game systems doing business in the state they have to have an agent in the state who is licensed as an electronic sealed ticket game system distributor. This matches the provisions regarding distributors of other gambling apparatus and implements in our state. An applicant for the distributor license, or, if they're a firm, corporation, association, or organization, its resident manager shall file, et cetera, shall file an application with the Gambling Control Unit. And that it allows the Gambling Control Unit to adopt rules regarding the licensing, which are routine technical. It says very clearly that an electronic game system distributor may not lease, market, or otherwise distribute electronic sealed ticket game systems to a person or organization except to one licensed to operate electronic sealed ticket games. Subsection 3 establishes language around the lease agreements. Currently, this is modeled on our current law for distributors of gambling apparatus and implements that allows for sales, service, and lease agreements. It became clear through the stakeholder discussions that that is not the model for electronic sealed ticket game systems, that these systems are leased to the organization, and that's an ongoing contract. You get the physical hardware, but you have an ongoing relationship with the systems and system software management, which can include things like troubleshooting, but will also include reporting information as a part of that, financial reporting information as a part of that agreement. So it says that when a system is leased, the distributor shall forward to the Gambling Control Unit a copy of the lease agreement, shipment approval, any registration or certification information for the terminals, or any other information that's required by the Gambling Control Unit prior to delivery. This is to help track the terminals' movement within the state. Lease agreement shall include all ongoing services provided by the electronic sealed ticket game system distributor to the organization licensed to operate the electronic sealed ticket games. The terms must include, but are not limited to, and well, maybe that phrasing doesn't work right there, but you got to have the name and address of the electronic sealed ticket game system distributor, the organization who's leasing that, a description of the system, including serial numbers and model names and numbers for the terminals, and all prices and payments for the lease and for any ongoing service provided as a part of that lease. And then if there were any change, modification, or alteration to the lease agreement, that has to be reported within 6 days to the Gambling Control Unit, and a lease has to be for a specific period of time. So there's a start and end date to the lease agreement, not to say you can't renew your lease agreement, but the distributors are also required to submit reports, and their reporting is going to be about revenue here. So by the first of each calendar month for the previous month, an electronic sealed ticket game systems distributor would file with the GCU a report for each organization licensed to operate electronic sealed ticket games, with which they have a lease agreement that indicates, and I actually have a few questions to make sure we're really getting what the information we want here, but total amount wagered in the previous month, percentage paid to the distributor under Section 835C subsection 9, that's the up to 30%. And the amount paid to the GCU for administrative expenses, that's the 1%. And the GCU can require any distributor to submit other reports as determined necessary for the purposes of administering and enforcing the chapter or section. I wasn't sure if, when we talked about this, I wasn't sure if total amount wagered was the number we wanted.
Amount to be
To be
paid.
paid.
Yeah.
Yes. Is it the total amount wagered? Is it gross revenue? Is the percentage paid what we want, or is the dollar value of that percentage paid what we want? So I'm not sure if these clearly express the numbers that are intended to be submitted. But I think the intent is there.
So if we were to be more specific to answer your questions, Ms. Olson, number A, 4A would say,
Oh, well, I guess that's a question, and I'm not saying you can't add. So right now it's total amount wagered in the previous month. So total amount wagered is not the same as gross revenue. Gross revenue is the total amount wagered less the prizes. I don't know if you want one or the other or both.
Director, what would be the most appropriate for auditing purposes? Because you'd be comparing the information you're getting from the distributor with the information you're getting from all the licensed operators.
Well, I think as the definition sits under gross revenue, if we say gross revenue, then it would be total wages less prizes paid out. So we'll get two figures.
Okay, so we should make it clear that that's what we want in this report from the distributor. Does that make sense to you, Ms. Olson?
So you want gross revenue.
We want gross revenue.
Gross
And-
revenue in the previous month.
Okay.
Okay,
And do you want that for, a cumulative total for all terminals, or do you want it broken down by terminal?
I would say by organization.
Okay.
Yep.
By
well,
organization
or by terminal.
or by terminal. No, I already asked that. I think he answered that, but an organization could theoretically be they're licensed for the specific premise. So I'm
Mhm.
not sure that I think it would come out in the wash, but that is the intent, right? Is that you would want this reported for each eligible premises.
Well, I think if we just, for A, we just put in, gross revenue in the previous month, then down under C, it says may require, distributors other reports as determined necessary by the unit for the purpose of. So that will give us the ability to, if they send us just the gross revenue with the prizes paid out, and that's all we get, we can ask them to separate it out.
Senator Timberlake?
Yeah, I was following along with that. I was just thinking that you kind of have to have it per organization because you need to know what Hickman's LLC fraternal organization slot machines are when he's doing this, and you need to know. Terminals.
They're not slot machines.
Well, they're
No
the
matter
same thing.
what anyone
Okay.
has said in the audience. they're
That's
not slot
okay.
machines.
We're not gonna argue that
Under the
now.
law.
We'll argue that later, but that's okay. But anyway, you need to know, in my opinion, you need to know how much money he took in and how much money he paid out. And it has to be to every organization. You gotta have the ability to have that. Or you can't keep track of it. And we can't keep track of it as a state. So
And-
that has to be in there, in my opinion.
And as the intro to subsection 4 is that the report is for each organization licensed to operate the games for which the distributor has a lease agreement. So they are reporting by license
And
organization.
so with that, you have to have how much they took in and what their gross take was and what their payout was. So you know how much they made, and so you know if they paid over 20% out to labor, and you know where everything or all the rest of the money's gone. Because you have to keep track of it all. We're seeing it every day now.
Director?
Yeah, and that's what we'd have to do on a monthly basis. If you look at it, the way this is set up is everything is done electronically and sent to us on the 1st. All right, we reconcile what's submitted, okay, against what percentage they're paying out, the 1% to the unit, so forth and so on. And then we know by the 10th what should be deposited. So that's kind of the setup here. It's to get everything electronically, the backup support on the 1st, and then receive payment by the 10th. So that's really what this is. But again, yes, I agree. It's by organization,
That's what it says.
but not also I can ask for by organization in addition to by terminal, in addition to gross, in addition, you know, I can ask for whatever, obviously whatever I want.
Thank you. And for B, Ms. Olson, does that answer this?
Yeah,
wanna-
I mean,
I
you're
only
gonna,
want- go
it's
ahead.
gonna come out in the wash. If you say, what's the percentage that you paid? You
Yep.
could answer with, we paid 12%.
Yeah.
But you could also say, how much did you pay? Which would be, you know, the 12% of your gross revenue might have been $1,200.
Right. And does this,
So-
all of this is covered in this section?
But if, right, but I would say if you are getting gross revenue, then if you're reporting just the percentage paid, which if you're just reporting it as the percentage and not the actual dollar value, that's a number that can be determined. And to Director Champion's point, he could make that through rule more clear.
Representative Boyd.
Thank you, Mr. Chair. Could we just include both? The percentage and
And the amount.
amount, and then no one has to do any math?
We do that
That's my
in
favorite.
another report. We recently added that language to another report to make sure that it's the percentage and the amount without having to do the math. Okay,
Okay. The sale ticket game system distributors must maintain the records for 3 years on the premise of the distributor. And they have to be open for inspection. Which is like, that's the requirement also for other distributors in the chapter. And then the remaining sections are adjustments that are most commonly made when authorizing or expanding forms of gaming in the state. So added in Title 17, 18, at the end of this chapter, that schemes are prohibited. And it's just carving out electronic sealed ticket games in the same way that the electronic video machines were carved out to prevent any. And adds language in the violations section. If you violate, in this case, 1840A subsection 1, which is that reporting the licensing provision, then it's a violation under the chapter. And authorizes electronic sale ticket games in the illegal gaming section. Those are from the original bill as well.
thank you. I know there are going to be a lot of questions because folks have saved them up to this moment. I'm just going to I'm personally going to take a quick break, turn this over to my very capable co-chair to start fielding those questions, and Chair will be right back.
Thank you, Mr. Chair. All right, we have first Senator Timberlake and
I'm ready.
then we have Representative Fredericks.
I'm ready. And Madam Chair, I'll stop between each and every one and ask you permission to continue if you'd like, or I got a numerous ones going on. After,
What I'll ask is that maybe you ask and then or maybe if you don't mind, could we start?
I'd like to stay into somewhat of a, because they're in a sequence and there's a reason I'd like.
Well,
to-
I was gonna say maybe we could start with Representative Fredericks. She has one question, then we can move on to you.
That works perfect for me.
Thank you.
Thank you, Madam Chair. It had been said previously, not today, about fiscal note requiring 1 to 2 inspectors. I just wanted to know the value of that. Is that, I just can't get my hands on it right this second.
The like dollar figures you're looking for, or you just,
Fiscal note,
I don't have the fiscal note in front of me, I'm sorry.
am I correct in saying that if this bill were to pass, you would require 2 inspectors to be added?
One manager and one auditor.
Thank you very much.
And then Senator Timberlake.
Yes. And thank you, Madam Chair. And Director, I think the first question I have, let's see, we can't call them slot machines, we got to call them terminals. So how many terminals do we have in the casinos today, operating today in the two casinos?
Approximately 900 and some at Oxford and 650 some
So
at Hollywood.
approximately 1,600.
Correct.
So as I look at this under the existing law, you said we had how many fraternal organizations and military organizations?
I think the recent figure was like 120, 126.
Because my quick search on the world famous ChatGPT, Google, came out with 590 fraternal organizations in the state of Maine and 373 military organizations in the state of Maine. And the reason I bring that figure up is because, to me, if we make these terminals available to all of these organizations that qualify, they're all going to try to apply for these terminals now that we're just doing the Lucky Sevens, the tabs. I think this is the possibility of increasing the expansion of this is there. Do you disagree with that or agree with that?
I disagree. First
And
of
could
all,
you explain why?
GPT is not always correct.
Well, I understand that,
So.
but if my number's half right,
No, like we've testified before, right now we have roughly about 430 eligible organizations. Of those, there's a certain amount that are currently doing paper raffles. Other organizations don't want to have anything to do with it. Then we went and looked at specifically fraternal, these to drill them down a little bit more. And then also having the space to actually put these devices in. So, you know, realistically, probably 80 of the 120 may be eligible. We'll have to see. We'll have to go out and inspect the facilities and make sure that they have the separations and the capabilities to utilize these devices. But again, there's how many SEAL tickets, organization with SEAL tickets last year? 151. Okay, 151, but that's paper, right? And that also includes fairs and everybody else. So out of those 151, I mean, realistically, we're probably looking at something like 80 organizations.
so if we use your minimal number that you're using, and you and I may agree to disagree on this, that's all right. How many, under the current law that's being proposed here today, how many terminals could you see going out into the field?
Well, it's really hard to predict because we don't necessarily know how many members each one of these organizations have. So, you know, if you want to take a figure of 8 or 7, you know, with all the organizations that we currently have, being that some will only have 3 or 5, some will have 8 or 10. You know, if you want to average that out, there's a possibility there. I don't know how good it would be. Again, there's some organization, we have an organization that sells one SEAL ticket game at a time. So obviously would have no need for anything other than one machine, than one device. You know, and as that goes on and they can explain to me and to obviously to the distributor that those machines are being used during the times that they're open, they're being played for the whole time that the organization's open, then that might justify them having a second machine. So it's really, honestly, it's going to be touch and go. We just don't really know. But a lot of speculation and estimates.
Somewhere in this world, we have to come up with an estimate, because any business plan or any business or any state organization, we have to say there's going to be approximately, and we don't know what the exact number is, but there's going to be approximately 600 machines, 700 machines. I mean, you got to base that on the number of, when you put in the fiscal note on this, how we're going to base it, and what are you going to base that on?
And we have submitted the fiscal note. I don't have it in front of me. I apologize for that, but we do have the note in there that's estimating, I believe, 60 of them to have less than the 10, having the 5, and then more so having the ability to have up to the 10. So I can let my deputy director maybe talk to that a little bit, because him and our charitable auditor were the ones that put together the fiscal note and the estimates for revenue, if you'd like.
So, okay.
Oh,
So if I use your number in my head, we're looking at 500 to 600 terminals at least.
Could be, yes.
Okay, so I'm gonna be honest to the committee. My big concern here is our expansion of gambling in the last year in this state house is very disturbing to me. And this is another expansion of gambling. And I'm having a hard time to get my hands wrapped around this today, but I probably will. But the only way I could possibly get my hands wrapped around this is we'd have to put a notwithstanding language within this bill to go into the existing casino cascades to remove the tribes out of those cascades and take that money that was going to the tribes and move that money to the Maine veterans homes and to the nursing homes in the state of Maine, because they got electronic gambling in that go round, and they're getting more money than they know what to do with. But that is the concern that I have at this point, and that's something that that would be the only way I'd get there. I'd also like to reduce the number to have a maximum number of terminals within the state to some number that we set, that we can't exceed that. If not, we're going to find every fraternal organization in the state of Maine and every place that can find a way to get one of these terminals into their facility, and they're going to be on every street corner and everywhere around. And I don't think that's what we shot for here today. So I just wanted to put out all my concerns. I feel that we have to put notwithstanding language in this bill and turn that money that was going to the tribes, now that they got e-gaming, that can go to our Maine veterans homes and our nursing homes in the state of Maine that are way underfunded. Thank you.
I have Senator Hickman and then Representative Himes.
Thank you. Thank you, Senator Timberlake. I didn't hear all of your questions, but I've heard this last conversation from other people. The chair would say, this is a charitable gaming bill. It is not a commercial gaming bill. It does not have a cascade. So any language regarding what we do with the cascade as it relates to the tribes or anyone else would be not germane to this legislation. And the chair would also say that if this committee wants to, I don't want to use the word, deal with the cascade in regular gaming, commercial gaming, the only vehicle that we would have to do that this session is our budget document, because that kind of change has everything to do with the fiscal impact of those changes on all of the other parts of the cascade, which are not a part of this bill because this bill has no cascade in it. So I just wanted to put that particular concern out there for the committee to address, but not through this vehicle because it's just not germane. And with that, I will yield the floor back to you, Madam Chair.
All right, and then I have Representative Himes and then then I have Representative Himes, Representative Frost, and then Senator Timberlake has a response.
Thank you, Madam Chair. I just have two questions in regards to how this would work, and I'm not going to talk about my concerns until we get to that point. My questions are how does this self-exclusion list feed into this system? The state's gambling self-exclusion list feed into the system?
Currently, it does not. The self-exclusion or something in reference to problem gambling is something that we did through rulemaking a couple of years ago. And what we've asked is, in lieu of some type of self-exclusion, because don't forget now, these organizations, these are not paid employees, like when you go to the casino, right? They're paid to keep people out. These organizations are not necessarily there. They would have to keep up to date with computer transmissions of who's on the current list, who's off the list, because you can self-exclude for 1, 3, 5 years or lifetime. So there's people to come off, there's people to go on, all that sort of thing. So it's very, very hard to do. What we do is we've asked them by rule to offer brochures and information about problem gambling while they're having these games for those people who may think they have a problem with playing bingo or Queen of Hearts or are sitting down and spending a lot of money on sealed tickets. That information is there. So that's the extent of what we have with regards to charitable gaming as far as self-exclusion and problem gambling.
Okay, second question. And second question is, who limits someone sitting down at these terminals for 12 hours a day?
No one does, but they don't do it at a casino either.
Thank you.
Representative Frost?
Thank you, Madam Chair. I just wanted to go back to make sure I'm clear on this. Back to section 7 and who's eligible. And we talked about the fraternal, patriotic, or veteran organizations. And I believe, Rachel, you said not open to agricultural fairs and whatnot. So the testimony that we had received very early on from Maine Association of Agricultural Fairs wouldn't count. It doesn't apply anymore. Same thing for Maine Harness Racing, doesn't apply. And Maine Standard Bred Owners and Breeders Association, none of that applies anymore to them.
Well, I'm not sure. So as I'm gonna answer maybe the question I think you're asking me, which is, no, those entities would not be eligible to operate electronic sealed ticket games.
Yeah.
Thank you, Madam Chair. Second question was, we did receive an email about some problems in a couple states that have gone ahead with this legislation. Kentucky and Indiana, they talked about fraud, phishing mechanisms. I guess maybe that's a term you're familiar with in these machines. I'm curious about, do you have concerns with any of that if we were to enact this legislation?
No, actually, I would say this. Based on my experience and my personal opinion, these devices are going to be offered to members and their guests only during a certain period of time during the day. Obviously, the age issue as well, but these devices are also, for all intents and purposes, terminals. They will basically electronically put into play 2,500 tickets or 25,000 tickets. But during those tickets, the winners have already been established. It's not like going to a slot machine at a casino where the random number generator creates millions of outcomes, kind of like going and buying a Powerball, right? You have a 1 in 3 million chance. This is concentrated to 25,000 tickets or 25,000 outcomes. So all the terminal does is gives a little flair to what the result of that electronic ticket is. So it's all predetermined. This is nothing that's random. So, and from a standpoint of us and what we're seeing in our audits, this is not an expansion. This is a replacement. We need to get rid of the paper. We can't get rid of them totally. Let me make sure of that. But we've got to reduce the amount of human interaction and touching these tickets and taking cash, right? This is a cash business, There's a lot of things that would strike up some interest, laundering money, fraud. Sorry, I know you don't like that, sir. Let's just say misplacement of funds or funds that are unfounded, that sort of thing. So this takes all that and concentrates it and has a little bit better of a control. So that's my opinion.
Senator Timberlake.
Thank you. I think I want to comment on Senator Hickman's comments earlier. He and I are probably going to agree to disagree because we're the legislature and we can do almost anything that we see fit. I served in this place for 16 years also. And if we determine that we want to put notwithstanding language in and we put it on the floor of the Senate and the House and it passes, it becomes law if the governor signs it. So those are all things we can do, in my opinion. And so you asked me what I got to do to be there. Those are just a few of the things that we would need to have a discussion over for this bill to move forward with my support.
All right. Well, thank you very much. I know that there's been a couple of calls for a caucus on this bill and also that we need to take a break before we continue our work. So the committee will be at ease, I would say, for a caucus for, I think, 10 minutes for this bill. Yes.
Whatever you want.
Yeah.
We
And-
don't have a fall with anybody.
So the committee will be at ease until 12:25.
The committee will be in order. Welcome back to the Joint Standing Committee on Veterans and Legal Affairs. We are in a work session on LD 1902 and act to support nonprofit organizations by authorizing the operation of electronic Lucky 7 devices and similar sealed ticket games. We've been on corner caucus breaks to discuss the policy in front of us. And we are now back. Are there any questions for the director based upon your caucus discussions? Are there any questions for anyone based upon your caucus discussions? What is the will of the committee?
Mr. Chair.
Chair recognizes Representative Boyer.
Thank you, Mr. Chair. Been talking with my colleagues and some stakeholders, and there would be some appetite to move forward with some version of this bill that lowered the number of terminals per location, that included a buffer around the brick and mortar casinos of some kind, whether that's a prohibition, or they have to have they can't use the higher number of machines, or do it by rule through the director. And we also had strong feelings about some of this revenue going to Maine veterans homes. We thought that that makes a lot of sense given the direction of the bill and who can participate, and also nursing homes as well, rather. Those were the two places we could hope to see some benefit from enacting a law like this. There is definitely folks in my caucus that are against this for many different reasons. And so that's just putting it all on the table.
Thank you, Representative.
To hash it out, to use a term from next work session.
So Director Champion, having heard that, if there were a buffer, I'll just start with that particular proposal. And we directed you in rule to create one with some guidelines. What would be pragmatic? I know that in one other state, at least on the chart we got in work session, that some states do have sort of these buffers around the radius. You have to be outside of a radius of some other gaming activity. Ms. Olson, do you have that chart that you gave us? I probably have it myself. Let me look. It's blue.
What's up there?
I've got it now.
Nice. It's New York, maybe?
And I think there was only one. Here it is. Yeah, I think you're right. No, it's, yeah, it is New York.
Yes.
It says in the New York law, any authorized organization located, let me see if these are the exceptions. Let me just make sure I'm reading this correctly. New authorized organization may operate a maximum of one machine. Any authorized organization at a premises located within 15 miles of any gaming facility may operate a maximum of one machine, except for gaming facilities located within cities with a population of 1 million or more. Any organization located within 15 to 20 miles from any gaming facility may operate a maximum of 3 machines. So is this, Representative Boyd, what you're kind of talking about when it comes to limiting the amount, the number of terminals that could be near some other gaming activity?
More or less.
Director Champion, have you seen this sheet? And I know this is a policy question that is not necessarily anything that you decide by yourself, but what is your thought about such a thing nonetheless, since I'm asking the question?
I mean, honestly, I think it's irrelevant. Again, like I've testified or mentioned before, you have slot players, table game players, sports wagering players, fantasy players, so forth and so on. The social people that are members of these organizations go there for the social, more so for the social aspect of it, in my view. So they go there and we're there with their fellow members. Members may have a few guests, they get introduced to the guests, that sort of thing. There's more of a connectivity within the organizations versus going to a commercial business. So I don't see it. If you want to, that's fine. But I don't see the relevance myself.
Okay, I appreciate that answer. And the other question is not necessarily germane to the gambling control unit. Is there any other concern that we would like the gambling control unit to address? Because I do have a question for someone from a charitable gaming organization at this point. Seeing none, Chair recognizes Senator Dusan.
Just coming back to your comment that the implementation of these provisions might lead to a reduction in the number of paper-based gaming going on. Is there anything to that either in here or that you anticipate in rules as you lay out this new that would encourage that transition away from paper to the electronic?
I think a lot of the organizations, while we ask them to look at our website to get information and so forth and so on, there might not be a lot of computer persons in these organizations because they may be older and they just don't mess with computers. But I think something like this is going to may start out slow, but I think it's going to be something that's going to catch on, and they're going to see the relevance of this. They don't have to worry about, the conduct of the game, who's playing the game, who's collecting the money, who's making the deposits, all that sort of thing. It'll all be done for them electronically. All they really have to do is take the money out of the machine and put the money into the bank. And all the paperwork, all the reporting, which we know from prior years, they were pushing back on, all the reporting and so forth and so on. And realistically, back then, we were just trying to really educate them to actually sell the entire game and make the full profit of the game. So hopefully that answers your question. But I think it'll probably start out slow, and then eventually, over time, it'll catch on. But you're looking at, if we're estimating 600 to 800 machines, these machines are going to be throughout the entire state. They're not going to be confined to one building. So even if you had to go to a particular organization or you're an invite or whatever, you're going to walk into 3 machines. And if you've got more than 100 members on a Friday or Saturday night, the likelihood of you getting to be able to play one of those machines is probably going to be less than if you go there on a Tuesday night or a Wednesday night, that type of thing.
Any other questions for the director before we move to a vote and a discussion on the motion? Thank you, Director.
Well,
Is there anyone from a charitable gaming organization, and I'm not going to put anyone on the spot, that may want to comment on the requirement that some of the gross revenue from operating these sealed ticket game terminals would be mandatorily submitted to the Veterans Home Stabilization Fund that is in the control of the Bureau of Veteran Services? Again, I'm just asking if anyone would like to comment on that at all. On mic, you may come forward, sir.
Not sure if you folks got a copy of this already.
You sit down, please, sir, and thank you for being here today. And please introduce yourself and which organization you are a part of before we get into the question and answer part. And thank you for
Okay.
being here.
I'm part of the VFW. I'm commander of VFW Post 9935 in Sanford. My name is Arthur Rocray, and I am a resident of Sanford, Maine, and the commander of the VFW Post 9935. I am writing to strongly urge your support for SP 742 LD 1902, which would authorize the operation of sealed ticket games to nonprofit organizations. I've watched with concern in recent years as our state has fallen behind other states in updating our charitable gaming framework. The veteran halls and community groups I partner with are finding it increasingly difficult to keep their doors open and maintain the programs that serve and are vital to our neighbors. These machines will generate revenue, which provides funding for community outreach and allows us to continue to serve our veteran community with hot meals, fuel assistance, outreach for widows, widowers of veterans, and many more opportunities to serve the community. The VFW sponsors yearly scholarships, Patriot Pens, and the Voice of Democracy, as well as school outreach. This legislation is important to me, our post, and our community to better support our veterans. We must access the tools needed to operate more efficiently and generate substantial revenue. SB 742 and LD 1902 authorizes electronic Lucky 7 games, sealed ticket games for charitable organizations, providing them with an accessible new fundraising method that replicates the traditional fun of Lucky 7 games. This bill would directly increase their revenue and capacity to serve Maine communities, which is why the bill is so important for the future of Maine's nonprofits. What I appreciate most about electronic Lucky 7 games is that they preserve everything our communities value in the traditional paper games. It's the same low stakes, the same charitable mission, and the same local focus, but with the added benefit of bringing operational improvements that matter for the future stability of the organizations and the communities they serve. I believe that passing this bill would lead to residents boosting the economy in their own town rather than driving 20 minutes over the border to New Hampshire to enrich theirs. Residents of our city and patrons of our organization have expressed interest in the electronic sealed ticket games being accessible to them without having to drive to another establishment. Thank you for your time and for your dedication to our state. We are a membership of 272 members.
Thank you, Commander. And I appreciate you being here. I have a specific question about a proposal in front of us, and that would be if this bill were to pass, would your organization be okay with a requirement that 5% of your gross revenue from the operation of these games be contributed to the Veterans Home Stabilization Fund, which would help to support.
We already
veterans homes?
donate on our own.
Are there any other questions for the commander from the committee? Seeing none, I appreciate you being here today.
Thank you.
Thank you.
This lady here helped us at the holidays with the Christmas dinner and the Thanksgiving dinner. Her and her husband.
I bet Representative Fredericks is all over the place. Down in Sanford. Thank you. I think the room knows we don't normally do testimony in work session, but there was no way in the world I was going to cut the gentleman off. Just not going to happen. And he answered my question nonetheless. What is the will of the committee? The chair recognizes Representative Hines. Somebody's got to do it.
I'll go ahead and do it. I'm gonna I'm gonna read something into the record and then I'm gonna make my motion. And this is why I'm a no for this, and a hard no. The massive expansion of gambling that's already gone on, this just compounds the issue. But I want to read specifically what this has to deal with. And this is from the National Council of Problem Gambling. And its service members experience gambling addiction at twice the rate of the civilian population. Young male service members 18 to 29 are at the highest risk of developing gambling problems. Military-related risk factors, including high-risk decisions making, guilty, PTSD, depression, and chronic stress. Without treatment, gambling addiction can lead to severe consequences such as financial ruin, relationship breakdown, substance use, and suicide. Veterans with gambling problems are 6 times more likely to experience homelessness, which we just talked about yesterday. An estimated 40% of veterans and service members who seek treatment for gambling addiction report having attempted suicide. The suicide rate among those with a gambling addiction is much more than 15 times higher than among those without the condition. So the reason I'm a hard to no is we're actually taking and expanding gambling, we're putting it right into the population that has a statistical problem with gambling. Whether we give it to the veterans home or not, I think that this committee should be looking at other things on how to fund that. And we've talked about that multiple times in here. I know it's everybody's priority on this committee, but it doesn't seem to leave this committee and be a priority for the rest of the legislature and the governor. So we can look at the cascade on a separate bill or whatever. I don't view them as related issues, but I am completely against expanding this to veterans organizations when they are statistically more likely to develop problems for this. And then next year we're going to have, hey, we have more homeless veterans. We have more gambling addiction. Now we need to fund that and figure it out that when we're just creating a problem right here and we can just stop it here. So I am going to make a motion ought not to pass.
The motion is ought not to pass. It's been made by Representative Himes. Is there a second?
second it.
It's been seconded by Representative Topeka. Is there any discussion of the motion by the committee? Chair recognizes Senator Timberlake.
Thank you, Mr. Chair, and thank you, Representative. After listening to what you just said, I'll be supporting your motion at this time, but I'm going to put forward that I believe that if we really want to help the veterans' homes, we can do what I said earlier, finding another bill, whatever it is we want to do, and go into the existing cascade at the existing casinos and take the money that was been given to the tribes from both casinos and give it to not only the main veterans home and the nursing homes, but we could also in that fund, because there's millions and millions of dollars there, that we could also help fund the veterans organizations out of that cascade. And we could look into that, because we have expanded, as you say, gambling in this state way beyond any comfort zone that I have after helping burying a friend a few years back. And I can't continue to do it. And what you read today, Representative, is heartfelt to me. And so I'll be supporting your motion.
Chair recognizes Representative Fredericks.
Thank you, Mr. Chair. I want it to be known that certainly in the area of Sanford, we have many groups, veteran groups that have the pull tabs, the Elks pull tabs. And I do see there to be a valuable need in going electronic with this, getting away from the pull tabs so that the automation helps with the financial audits and tabulation, et cetera. I thought the sponsor was gracious in allowing for the buffer zone to be created, limiting the machines down to 1 or 2, and additionally directing the funds to veterans homes. I thought that was wonderful. It's a tough one. Gambling's a tough one. Certainly there's plenty of addictions, alcohol addictions, drug addictions, video gaming addictions, gambling addictions, sex addictions. I wish we could control them all, stop eating potato chips, for example. But anyways, I do think that automation is the way of the future. We just approved iGaming. So in the pocket of this veteran, he's able to iGame and he's sitting in a VFW and having to do pull tabs. That audience is gonna walk out from the VFW instead of walking into the VFW. So I'm not gonna support the motion. I do think that the bill, as it is before us, needs a little more adjusting. And I just wanted to let my position known on the record.
Thank you, Representative Fredericks. Any other comments on the motion ought not to pass? Senator Dusan.
I'll be voting no on the ought not to pass. I interact regularly with the charitable and veterans organizations in my service district. I think these organizations are more likely to offer a safe, welcoming haven for veterans, and the ability to offer gambling through these electronic things is a source of funds to support those very services for veterans in my community through their organizations. So I think, yes, I would agree. There could be more work on the original bill. I'd love to see there be some language that would encourage the move away from paper to electronic so that we're not necessarily expanding, but we're upgrading. But I think it's an important source of funds for charitable organizations. And so I'll be not voting for ought not to pass.
Senator Dusan, may I ask you a question about
Yes, sir.
something you said in your comments, and thank you for them. Would you like to see in an amendment to a ought not to pass report that we put some unallocated language in to direct the director of the Gambling Control Unit to, in some reasonable time frame, begin to work with the licensed operators to move toward only this at some point in the future? Senator?
I thank you, Mr. Chair. I would love to see something like that. I think that from the office itself, there's the opportunity to assist the organizations with the transition to the electronic system and away from the paper, so that it's a hand to help modernize versus another area to penalize.
Director, can you please come back? Is he still here? There he is. Yeah, no. I just wanted to ask you a question about that. If we were to direct you to work with licensed operators to move toward, should the bill pass, fully electronic, what time frame do you think you could work with organizations to do that? Or is this a complete non-starter for the Gambling Control Unit?
Essentially, you'd like me to hold a couple of public hearings and describe to them what the transition would look like? Or are you asking that if this passes, what that transition would look like?
If we were to put language in a bill that passed,
Okay.
unallocated language, directing the Gambling Control Unit at Senator Dusan's request to work with licensed organizations to move away from paper to fully electronic Lucky 7 sealed ticket game operations for the purposes of auditing and regulatory tightness. What time frame do you think these organizations would need if we were to direct you to do that? Would it be 6 months? Would it be 2 years? Would it be 18 months? What would it look like to make it pragmatic for the Gambling Control Unit to work with these organizations to transition to? So I know there's a member of our committee who was not here, and that member would like no more paper at all for Lucky 7. But we know that that can't happen overnight. So the question is, if we directed you to transition in either in rule or in some other way, whether you hold public hearings about that or not is up to the agency if this were to pass. What time frame would work?
Well, I've done 48 rulemaking packages since 2016, and I can say the average one is probably 8 months to a year. So if it involved rulemaking, I would say at least 8 months. And so the entire transition with public hearings and all that sort of thing, maybe providing some training in advance so they know what it's all about before they even make the next step. I think we could all do it in an 8-month period.
Chair recognizes Senator Dusan, and then I will call on Representative Frost and Representative Boyer.
Thank you, Mr. Chair. Thank you, Mr. Director. I just want to put out there that I had the opportunity to attend one of your regional trainings in Portland. It was very well done, very well received, and was very much the attitude of how can we help you comply. So thank you very much.
Chair recognizes Representative Frost. Oh, I'm sorry, please defer.
No, that,
You sure, Ms. Olsen? Okay, because we may have an idea about what I'm asking the director, but Representative Frost, you may proceed.
I guess I just, I don't know, I guess I have a bit of a problem with that. I mean, what if the organization just doesn't want to take on the electronic devices? I don't think it's fair to make that a rule, or, I just don't think it's fair.
Thank you, Representative. Ms. Olsen.
sounds okay. Two things. First, as drafted in the proposal, only a subset of those organizations eligible to offer paper sealed ticket devices. would be eligible to offer the electronic sealed ticket games. And so even if you were to require organizations who offer electronic sealed ticket games to, within a certain period of time, cease operating paper tickets, you would still have, I mean, if the numbers that Director Champion indicated, more than 50% of eligible organizations offering paper. So you would still have this dual system in the statewide. I think also if the intent was to essentially require these organizations to, at some point in the future, cease using paper tickets, that would need to be explicit in statute and not left up to rule, because they are different licenses. And so I think you'd actually have to prohibit them in some way down the road. So I think those are your two considerations, to the extent that you can direct the unit to offer education or other types of information that would encourage or support the transition. I think you could include that, but I don't think it would rise to the level of ultimately requiring it. This was something that came up during the stakeholder conversations related to the systems. And I don't know if anyone who was a part of that would want to discuss those things that came up during those meetings.
Director?
Yeah, well, I would just add that as far as I understand, this bill is not requiring the replacement.
Correct.
And this is not saying whether you're 100 members under or over, you have to have these devices. This is not what it's saying. And it's saying up to 30% to pay the distributor for the devices and the supporting hardware, software, and that sort of thing. So again, I don't know if this is going to come out with a big bang and we're going to be running all over the place installing these machines. I think it's going to be a gradual thing that, quite frankly, if you want to put in, I'll come back next year, the next session, and give you the update on how many are installations and how's it's going and all that sort of thing.
Yeah. And
I don't think you need to require that. I can do that for you.
You do that in
anytime,
in your report for sure. And I do believe that if we were to prohibit paper versions of this, that would require a public hearing, a different vehicle, a bill, so that people could tell us no. Because not every organization would even be eligible for these terminals if this bill were to pass. So we wouldn't want to take away some form of people earning some income for their charitable organizations through something that they already do. And it could also be that we look in a future session at a way of tightening up that program, even if this passes or doesn't pass, because we clearly saw evidence that there's some things unaccounted for in the current system. Chair recognizes Representative Boyer.
Thank you, Mr. Chair. I feel like I do recall some members of these organizations saying, don't take away our mechanical pull tabs. So I don't know that that's something I'm interested in, but some education by the department is reasonable. I don't know that we need to add language because they'll probably do some PSAs if this does go through.
Thank you. Any other comments on the motion ought not to pass? That is the motion. The chair would say that I voted against my own legislation today and in previous work sessions, and I'm not prepared to go with the ought not to pass motion on this, but I want to be fully transparent. The stakeholder group that worked on this language for hour upon hour with Ms. Olson in a couple of different Zoom meetings are Jeremy Payne, Director Champion and Matt Motti from the Gambling Control Unit, Cheryl Timberlake, Matt Marks, Eddie Duguay, Darcy DaCosta, Meredith McLaughlin. And some of these people represent the distributors of these machines, these terminals that go across the country to allow veteran service organizations to raise money in this way. And so those were the people who were involved. And in the interest of more full transparency, Aero International has contributed to my leadership pack. I say that because it doesn't matter. I'm not doing this for Aero International. I'm doing this for the veteran service organizations who would like to modernize the way in which they raise money. And Aero International happens to be a distributor of the devices that some of these organizations use. And so the fact that Aero International has contributed to my leadership pack way past the point of me putting this bill in had actually more to do with the activities that I was engaged in November of this year, feeding people who were hungry in my community and knowing that I was using some of my leadership pack funds to do that because it is expensive to feed people in an expensive economy. I'm putting that into record so that if anybody wants to talk about that here or out in the world, they will know that that is the truth of all of this. But I will be opposing the motion because I believe, campaign contributions or not, that the director has made an argument that a more regulated version of charitable gaming for these organizations playing sealed ticket games electronically is necessary. The organizations have made it clear that they would like this opportunity to raise more revenue for their organizations. And so I'm going to vote against the motion and figure out some amendment that may or may not get more than my vote, but that's okay. Any other comments on the motion ought not to pass? I'll say that if I'm comfortable with the bill as drafted, the amendment as drafted, clarifying that there needs to be background investigations on the distributors. The chair is comfortable with a reduction to 4 and 8 machines in the 4A and B on page 3 of the yellow amendment. No more than 4 electronic sealed ticket games for a licensed organization with up to 100 members. No more than 8 for ticket terminals for a licensed organization with 100 or more. And I don't know if anyone will join this and what the director even thinks about this. I don't know if we need to allow for any additional games based upon benchmarks established by rule. I don't know why we would need to allow for more at this point in time. I suppose we could revisit that language if this were to pass, and we would see who's doing what, where, how. The other part gets more complicated. I would be open to limiting the number of machines in organizations that are within. Representative Boyer, I'm calling on you now, whether you support what I'm saying or not, but did you say 15 to 25 miles as is in this document on page 3? Or did you have a specific number in mind for limiting these machines to some radius of a casino?
Thank you, Mr. Chair. Maybe Ms. Olson can remind the committee what the OTB radius is?
I can
Maybe she can.
not confirm that right off the top of my head.
Or
And
director, if he
there-
doesn't know.
That's under harness.
It's under harness racing.
I think it's
and,
30.
What title? Is it 18? No. Does anyone who is an expert on gaming in the room know the answer to the question before I try to look it up? Did you say it's
It's either title or
8? Okay, it might be amusements.
It doesn't even know I was really.
Well, we can say that if we were to include this kind of carve out, it would be based on that number and we could get that number in the language review. The question though is it the same amount or is it some different amount if you are within that radius? Is it none or is it 1 or 2 or 3 as is proposed in New York?
I'd I'm open to what my colleagues think. I think Googling, whatever that's worth, it says 50 miles. And so I think that might be a little onerous. But if we did like 15 miles, one machine.
An authorized organization located with 15 to 20 miles from a gaming facility may operate a maximum of 3 machines. The chair recognizes Senator Timberlake. You may put
Yes,
this into the
Mr.
mic.
Chair, I'd like to ask Peter Cornell if he could come up and help answer this question.
Very short answer.
Mr. Cannell, please introduce
Oh, I'm
yourself
sorry.
first. That's okay.
Yes, I'm Pete Cornell and I represent Pioneer Gaming, which has 2 OTBs in Maine as well as the Highness Sportsman's Association. And then the number for OTBs, between OTBs, is 35 miles.
Thank you. And thank you very much for that.
Sure.
And Representative Boyer, would that feel too onerous to you, or would you like to keep it at 15 to 25 miles in that range? If you were to join a report that was not on not to pass.
I think, given the OTB mile radius, using that number, but then restricting it to the minimum amount of 4.
Okay.
I do have a concern, Mr. Chair, of with these members, I think there'll be a push to add new members to their club and, what's it cost to become a member or, so I feel like there could be some gaming there. So that's some of the heartburn I have.
Okay, fair enough. But the maximum would be the minimum if they were in this radius. Is that what I heard you say, Representative Boyer? That the maximum amount would be the minimum amount for everyone outside of that radius? Ms. Olson, do you understand what we're saying here? If this were to become an amendment?
Yes, and you're talking about a radius within the distance of a casino.
Yes, that is correct. Representative Frost.
Thanks, Mr. Chair. Boy, this is one of the toughest bills we've had this year, but apparently this is tough bill day. I just want to say that I definitely came into this having some concerns about increased gambling and the effects of that. But I just want to say that Representative Himes, your speech was really affected me, and it was I do feel that you having experience in the military like you do, I feel that you are very in touch with people around you who served, and your concerns are my concerns. So I'm going to support the motion.
Thank you, Representative. Any other thoughts on the motion? Is the committee ready for the question? The motion is ought not to pass. It's been made by Representative Himes. It's been seconded by Representative Frost. I'm sorry, Representative Topeka. What did you have Topeka down on your sheet for the second? I thought Frost beat Topeka to it, but it doesn't really matter. That was the last vote. Great. Madam Clerk, please call the roll. The motion is ought not to pass on LD 1902.
Thank you. Senator Doosan.
I vote no on ought not to pass.
Senator Doosan votes no. Senator Hickman.
No.
Senator Hickman votes no. Senator Timberlake.
Yes.
Senator Timberlake votes yes. Representative Graham.
Yes.
Representative Graham votes yes. Representative Terry.
Yes.
Representative Terry votes yes. Representative Frost.
Yes.
Representative Frost votes yes. Representative Chapman absent. Representative Boyer.
No.
Representative Boyer votes no. Representative Supeka.
Yes.
Representative Supeka votes yes. Representative Himes.
Yes.
Representative Himes votes yes. Representative Frederick.
No.
Representative Fredericks votes no. Representative Fairclough.
Yes.
Representative Fairclough votes yes, and Representative Mallon.
Yes.
Representative Mallon votes yes.
8 members voting in favor of the motion, 4 members opposed to the motion with 1 member absent. The motion prevails. Absent members will have until Friday at noon to cast their vote in absentia. So we're not going to take another motion. We are going to simply read a minority report into the record. So far, Ms. Olson, you've heard everything that I have outlined for a report. I'll stand by all of that. do we need to add, Representative Boyer, if you're gonna join this report or have your own, I don't know, the 5% to veterans homes? 5% to veterans homes gross revenue for the organizations that operate?
Stabilization. Clarifying that's the stabilization fund.
To the Veterans Home Stabilization Fund under the Bureau of Veteran Services. Thank you, Representative Boyer. And I believe that is all that the chair is comfortable with on his report. I won't go any further than that. Senator Dusan, are you okay with that? Representative Fredericks?
Thank you, Mr. Chair. What happened to the buffer zone?
Can we, yeah, let's
Oh,
go, let's go over it.
Let's go over it. We're gonna go
So,
over it. So she
okay.
understands what we are agreeing to or not.
Right, okay. So first and foremost, to add in the clarifying language that requires background investigations for the distributors.
Yes.
To reduce the maximum allowable number of terminals to 4 and 8 respectively.
Yes.
Are you, I wasn't sure if you included this. Did you want to remove the language that allows the director to authorize additional
Yes.
terminals? Okay. And then I wasn't sure I followed this. So the buffer zone would be, was it 35 miles?
Yes.
Of a casino. If the licensed organization is within 35 miles of a casino, they may operate no more than 4.
Correct. Chair recognizes Representative Boyer.
Is there a standard on how we determine radiuses in law? If not, then as the crow flies.
Good for everyone? Okay. And
Yes.
yeah, there is not. We actually do have sort of 2. I think the provision for OTBs is 1, and the provision around additional casinos or slot machine facilities is a different way of measuring. So here, we do not have a standard. So by as the court flies.
Yes.
Which is probably not the word we use in statute.
Of course it isn't, but you get the point.
Maybe I'll add it. Okay, no more than 4. And then the last part you added just here at the end was related to the sending of revenue to the main veterans
Home Stabilization Fund. Yes. 5%.
Of the gross revenue.
Yes.
I think there was one additional technical point that around the records that the distributor sends. It was brought to my attention that the distributor might not be able to, they may not know the amount that was sent to the gambling control unit for administrative expenses.
Okay.
So the licensed organization can report that information.
But
and
not the
then they
distributor.
can- But, right, but not the distributor, and then, but the gambling control unit could then use the data that is provided in the report by the distributor about total gross revenue to verify that that is the accurate 1%. So I think that closes the loop, but I just, that provision might not be able to continue to be included, and I can just, I'll follow up on that.
That would be
In the
4C.
reporting, yes.
In the
4C.
reporting that we
And
would,
just to make sure that there's the corresponding one from the licensee that they are reporting that as well. And then I'm bringing this up especially because with the 5% transfer of gross revenue to the main Veterans Home Stabilization Fund, that's another thing that the distributor may not know and could not necessarily report. But we'd want to make sure to capture in the reports of the licensed organization.
yes. So those 2 technical changes around reporting that amount should be included in the Minority Reports Amendment.
And then finally, the director did bring up the idea of reporting about the type of gaming to the committee. We don't really receive specific reports on charitable gaming. We have a lot of required reporting. I'm just mentioning that because it did come up. So if with this new form, with a lot of additional reporting, if the committee,
Yeah.
legislature wanted to specifically get a report, an annual report regarding
This,
the revenue or the operation of charitable games.
we can require that in a section where report to the legislature from the gambling control unit.
Yes.
Should
And
be,
you could include it in some other report that they already give us.
and if there is another report that they give to us, and they do, that this needs to be included in that report, and we can make that clear wherever, in whatever section, new section you need to add to this to make that report to the legislature clear.
If that is something that the members on this report wanted.
Senator Dusan, report to the legislature about the operations of electronic Lucky 7 sealed ticket.
Sounds like an exciting idea.
Okay. Representative.
Riveting.
Yes.
I think we're getting hangry. Any other points of clarity for the minority report, Ms. Olson?
Could include it into the casino one, let's do March 15th.
Okay, I think I have everything I need, and everyone who did not vote in favor of the motion is on that report. Yes.
Yes.
Thank you.
Great. The chair will close the work session on LD 1902. So it is 1:35. We will be taking up LD 1847 after a lunch break. What I would like to do, however, before lunch break is I'm going to open up the work session. And the reason I'm going to open up the work session before the lunch break is so that our analysts can distribute the sorry. You're having trouble hearing? Yeah, I'm just going to open up the work session on LD 1847 and act to institute testing and tracking of medical use cannabis and cannabis products similar to adult use cannabis and cannabis products, dedicate a portion of the adult use cannabis sales and excise tax to medical use cannabis programs, and create a study group presented by Representative Graham of our committee. The work session is open so that Ms. Olson can distribute the amendment that she has worked on until a very long time. So when that happens, people can have an opportunity to take the amendment with them on lunch. It will be available for interested parties over here. And we will, Ms. Olson, how long would you like for lunch? I'm asking you. 2:30?
It's 1:40 now.
That's more than I.
It's more than you need? Then we will come back at, we'll come,
I'm okay with. Whatever, but you guys can figure.
Representative Safika?
Well, I think she says a half hour, but I think she can maybe a little.
What would you like?
Well, I mean, if.
When would you like to come back, Representative Speaker?
Let's give her 45 minutes.
2:15. The committee will be at ease until 2:15.
Oh, and there are two amendments coming around for 1847.
Thank you. The committee will be in order. Welcome back to the Joint Standing Committee on Veterans and Legal Affairs. We are in a work session on LD 1847. I will not repeat the title. So the process by which we're going to work today is we know we have a deadline. So today is pretty much our day to get this work done. And as I promised at the outset, we were going to do the work. So in order to expedite this part of the work, we have a Buff Amendment and we have a Canary Amendment, or however you want to talk about these. And our analyst worked very hard on all of this at the request of those who asked her to put these amendments in. And in fact, what we're calling a tentatively consensus industry amendment was worked on the same day of our last work session until midnight. And then there was a Zoom town hall to discuss it, I believe, sometime over the weekend with about 25 participants. And Ms. Olson, who's been working meticulously on all of our bills and all of our amendments to all of our language, was able to get this particular final draft of the second amendment in front of us into my inbox. I'll just say in the wee hours of the morning, which means we have all been working hard to meet a deadline. And yes, I wish we could have done this work months ago, but here we are today. So the goal for today is for the analysts to walk through each amendment. We never finished going through Representative Graham's amendment, and to just outline what's in them. I may be able to compare and contrast, but what I would ask for the committee to do is to take notes on the questions that you may have on each provision that you would like to ask questions about, because we're not going to ask them as we go unless there's just, I didn't understand what you said kind of a question. And then we can have questions asked and answered after that from anyone who needs to have questions asked. I'm going to also ask the committee not to just invite people up to talk. That is prerogative of the chair. And if you would like for someone specific to ask a question, that's fine. I still may say no. We want to make sure that we're not arguing the policy until there's a motion and a debate. What we want to just do is get information about what's in each version of the bill, okay? So if we can all agree to sort of those ground rules loosely, I think we can get through both of these amendments in an efficient amount of time, and then there'll be plenty of time for questions and debate and the department and anyone else that needs to provide information to the committee before we make a decision about how to move forward on LD 1847. So with that, Ms. Olson, the floor is yours.
Okay. Thinking a little bit about the best way to do this. You have two amendments to 1847 before you. They have some elements that are similar, and they also have different proposals, particularly regarding testing, mandatory testing of contaminants, and tracking. So I'm going to start there, and then I'll do a little bit more of a detailed sort of walkthrough. And if representatives who put forward these proposals believe that I have mischaracterized something, I will take no offense and would be happy to be corrected. So let's start with Representative Graham's proposed amendment. This one is on, this is gold, in case you're curious. I went with different versions of yellow as we had a couple of different versions of this. And they all had the same general cover page, so I didn't want it to be confusing, and color is a little easier than the date. So this proposal, it does a number of things. As it relates to mandatory contaminant testing, it establishes a program for mandatory contaminant testing for cannabis and harvested cannabis. And I'll take a moment there to just note that currently Title 22, Chapter 558C, the medical use program statute, doesn't have a definition of cannabis. And I don't mean that to say that it needs one or doesn't need one. Just identifying that, that it doesn't have a definition of cannabis, and so this adds cannabis. As a definition, it uses the definition for cannabis from the adult use program, leaves, stems, flowers, and seeds of the cannabis plant, whether growing or not, doesn't include concentrate, doesn't include hemp. Sorry, does include concentrate, does not include hemp, excuse me. The current chapter 558C has a definition of cannabis plant. It has a definition of cannabis product, edible cannabis product, but the sort of predominant term in the medical use program that is used when referring to the cannabis that is offered or sold to qualifying patients that would be a part of this program is harvested cannabis. And harvested cannabis includes cannabis concentrate. Hold on, I'm gonna have to look at that because I've read it too many times. It also includes cannabis product. So that's like the encapsulating term. I have the chapters that I can verify in a second. So it establishes a mandatory contaminant testing program. And this is done through a matrix. And matrix is defined, that is true of both bills, both proposals. It establishes both programs do have mandatory testing for contaminants using the matrix. And a matrix is defined, but what we really mean by matrix is the form that it is in when it is subject to that testing. And it provides 3 categories: cannabis flower and cannabis trim, including pre-rolled cannabis cigarettes, which is not defined. And the Senator Hickman's proposal actually provides a definition for cannabis pre-rolls, but meaning the same thing. Cannabis concentrate, including concentrates extracted using solvents, as well as solventless extraction methods, and then cannabis product. I'm going to go back to mandatory contaminant testing in a moment. It does add a couple of other definitions. It also changes the definition, both change the definition for cannabis testing facility to be a facility that's either licensed in the adult use program or registered in the medical use program, and they have the same requirements. One thing that Representative Graham's proposal does that is not included in Senator Hickman's proposal has to do with the provisions that, I know you can't see that very clearly, but on page 3 of Representative Graham's amendment, and actually it might technically start at the bottom of 2, throughout the authorized conduct sections in the medical use statute, I mentioned this at the last time we worked together, there's authorization for different registrants to conduct testing. So this Representative Graham's amendment removes those, that authorized conduct, because testing will now only be authorized to be conducted by the registered cannabis testing facilities. And that those repeals are not included in Senator Hickman's bill proposal. That's one area that there is a difference. When it comes to the testing program, which I'm referring to the paragraph in section A15 and Representative Graham's amendment. And on page 3, thank you. And also page 3, Senator Hickman's amendment, which is section 814. So both of these sections establish a testing program. The biggest difference is in the rules. And so in Representative Graham's amendment, it says that the office would would adopt rules establishing a testing program, and those rules would identify the types of contaminants that are injurious to health for which cannabis and harvested cannabis must be tested, and rules regarding the maximum level of allowable contamination for each contaminant, that the office may adopt rules establishing testing and maximum level parameters for speciation testing of harmful yeasts and molds. I believe that means speciation means to test for the types of species of yeast and molds, because those are broader categories. There are different types of yeasts and molds that you might test for, different species. Including a range for allowing speciation tests for flower and trim, using evidence-based practices, and establishing rules for testing for protocols and consistency, and accurate reporting. And in the gold proposal, these rules are routine technical, and I believe I think every rulemaking provision in this version is a routine technical rule, whereas in the yellow Senator Hickman version, all of the proposed rulemaking is major substantive, which we will revisit. But just as a reminder, major substantive rules take time and require a specific procedure and authorization by the legislature through this committee. Senator Hickman's version for the adoption of rules also requires the adoption of rules establishing a testing program, but those rules would include a preliminary testing limit for total yeast and mold contamination of 100,000 colony forming units per gram, and must provide that harvested cannabis that tests above the preliminary testing limit for total yeast and mold contamination does not fail testing, but must undergo additional testing for mycotoxin produced by penicillin and Aspergillus SPP. How did I do? I think I said those both correctly. And the rules must provide that if harvested cannabis tests positive for mycotoxin produced by penicillin, it must be labeled, this product may contain the mycotoxin produced by penicillin and may therefore be harmful to people who are allergic to or have sensitivities to the mycotoxin produced by penicillin. And that if it tested positive for Aspergillus SPP, it must be labeled as this product may contain Aspergillus SPP and may be harmful to immunocompromised people. So those are the specific requirements that must be in the rules adopted by the office when adopting rules establishing a testing program, which are major substantive. And before I move much further, I will note, because I kind of went down the path and then veered off and forgot to go back. Senator Hickman's version only relies on the term harvested cannabis and does not include the definition of cannabis or and doesn't therefore use it when talking about testing. And I will, for the sake of before we go down too far the path, harvested cannabis means the plant material harvested from a mature cannabis plant, except the stalks, leaves, and roots of the plant that are not used for qualifying patients' medical use. Harvested cannabis includes cannabis concentrate and cannabis products. So that's the term that is used to kind of encapsulate all of the types of cannabis provided to qualifying patients. Okay. I believe that the requirements for cannabis testing facilities in both versions are the same. I will admit to have not done a close line by line comparison of the two. So I would ask that those who worked on, not necessarily at this time, but those that worked on the Senator Hickman proposal could verify that it is the same and didn't change, or if it did change, in what way. Other than that, I went through and deleted all the words cannabis, or at least I hope I did. I intended to.
I do not believe that there is any change other than the term.
And rulemaking. So,
And
yes,
rulemaking,
and
yes.
rulemaking. So this also has, I made some other notes over here that I should be following along with. I did come prepared to do this. I know it doesn't always seem that way. Yes, the rulemaking is also different. So in Representative Graham's amendment, it says that the office shall, and sorry, please interrupt me to point you to the right page if you're not following along. It's page 5 on the gold,
Yes.
also page 5 on the yellow. Near the top of both. So Representative Graham's amendment for rules for the are that the office shall, to the extent practicable, establish pass and fail requirements for cannabis testing in accordance with the applicable national and international quality standards established for botanical ingredients, such as the American Herbal Pharmacopoeia, the United States Pharmacopoeia, and the European Pharmacopoeia. No, there's a lot. That's a lot. And British Pharmacopoeia. Okay. All right. Rules are routine technical. So that is, again, the one big difference. And that the office, this also allows in Representative Graham's amendment for the office to alternatively require that cannabis testing facilities registered under the medical use program comply with any rules and standards established for testing facilities in the adult use program that already exist. And in Senator Hickman's proposed amendment, the office may adopt rules regarding registration, certification, accreditation, and operation of cannabis testing facilities, including but not limited to acceptable testing practices, including not limited to provisions related to testing practices, methods and standards, remediation and retesting procedures, quality control analysis, equipment certification and calibration, chemical identification, record keeping, documentation, and business practices, disposal of used, unused, and waste harvested cannabis, and reporting of test results. And again, these would be major substantive rules. Both versions bring the cannabis testing facilities within the registration certificate process that currently exists. So that's in A16, 17, and 18 on page 5 and 6 of Senator Hickman's, and a 17, 18, and 19 on pages 5 and 6 of Representative Graham's. So now we kind of get into a couple of the other big changes. So Representative Graham's amendment includes changes regarding packaging for edible cannabis products, I believe. Yes. 20, page 6. And it is a 21, 22, and 23. I know I have too many versions of this also, so with different versions of notes. So let me just go to the. So 2429A is packaging and labeling requirements. And it is adding packaging requirements, for, harvested cannabis sold in a retail transaction. That they have to be packaged in a manner that does not introduce harmful contaminants to the harvested cannabis after it has passed mandatory testing required under the chapter. And for labels. And it includes it removes. Then I'm looking at this language. Those are all technical. Oh, it removes that it doesn't apply if there are no cannabis testing facilities. So it's mostly technical there. Okay. Now, in the current version of Representative Graham's amendment, it also includes for edible cannabis products the ability to include cannabinoid potency on the labels. Packaging. And this has changed since we last saw this. So it provides that for edible cannabis products to be sold or offered for sale in a retail transaction, may, except as provided in 2A, which is gone. Yeah, sorry. So that actually should be said. So it just may have the amount or potency of cannabinoids calculated using an allowable variance rate of 10%. And in that calculation, the amount or potency is allowed of cannabinoids allowed under the subsection. The allowable variance rate for cannabis testing facilities is allowed. You can use that calculation. So I'm just going to go ahead and just go to that. Okay. That provision is similar to the provision in Senator Hickman's amendment.
Which is on page 6.
Which is on page 6 of both versions. Section A19 on Senator Hickman's and A24 in Representative Graham's. Representative Graham's version has removed the except that the allowable variance may not be less than 0.6 milligrams or greater than 5 milligrams. Senator Hickman's amendment contains the part that allows the except allowable variance may not be less than 0.6, but has also removed the or greater portion of that sentence. Okay. And that is the difference between those two sections. Okay. You can see that Representative Graham removed the THC potency provision from her proposal. Okay. So now we have some more differences coming up. So Representative Graham's proposal includes provisions about the use of funds for studying public health impacts. It's the medical use of cannabis fund. It's adding studying for public health impacts to the allowable activities for the use of funds and for the grant research program that already exists in statute. Those provisions are not contained in Senator Hickman's amendment. And trying to think of where I want to go, how I want to go next. Okay. So I'm gonna talk about tracks. We're going to talk about tracking and how they do it differently in each proposal. So in the yellow amendment, Senator Hickman's, you're going to want to be on page 8 in section A22. And in Representative Graham's amendment, you will also want to be on page 8. It's section A28. That one starts at the top of the page on that. Okay. So Representative Graham's amendment is establishing the use of a statewide inventory tracking system. And it is based on the current provisions for the tracking of adult use cannabis. So in this, there's a couple of changes at the top, but the department will implement and administer a statewide inventory tracking system where registrants shall submit to the office electronic records. The responsibility to pay for the costs and fees associated with the use of that tracking system and other associated record keeping requirements would be that of the registrant. And it does say that any record in the inventory tracking system would keep the identifying information about a qualifying patient. It wouldn't be contained there. So they may not require records in that system to contain identifying information for qualifying patients or their medical providers. That's something that would be unique to the medical program that wouldn't apply in the adult use program. And so for record keeping, all cannabis plants and harvested cannabis from the immature cannabis plant to the point of sale or transfer to a qualifying patient, the return, disposal, or destruction would need to be recorded. It expands the amount of time that records must be kept from 4 years to 6. These are very different provisions, but just as a straight match, the proposal about record keeping in Senator Hickman's amendment reduces them from 4 to 2. It removes the required labeling provision that currently exists because it's going to establish the use of the inventory tracking system. And you have to track. You have to submit information by 11:59 p.m. at the end of every day. Yeah.
Clarifying question, Representative Graham? Yes.
Yeah, and multiple areas have been deleted. Is that correct? Under the required records on my bill. All this.
Are you talking about on page 8, Representative Graham? The required
Yes.
label? Yeah, that whole section is deleted because that's being replaced by metric.
Yes.
Thank you. I just wanted to make
Yep.
sure that was clear.
Yes.
Yep.
So when you have to have a complete inventory of your cannabis plants and harvested cannabis. You have to have a record of all transfers to or from the registrant, and those include at a minimum the person transferring the cannabis plants or harvested cannabis, including the person's registry identification number, the person receiving the cannabis plants or harvested cannabis, also including the person's registry identification number, or they're not required to register a unique identifier assigned to the person. a description of cannabis plants or harvested cannabis being transferred, including the amount and form, date and time of transfer, destination of the cannabis plants or harvested cannabis, and a record of all mandatory test results for each batch of cannabis and harvested cannabis offered to qualifying patients. It allows the office to adopt rules to implement the section, including but not limited to rules regarding the process and content of records to be submitted, frequency of submission, as well as rules regarding enforcement of the inventory tracking requirements. This establishes that those are routine technical rules. And then it includes, this is language that was different from a previous version, that starting January 1 of 27 and ending January 1 of 29, that the office shall provide quarterly reports to the committee, this committee, on implementation and administration of the statewide tracking system. And that the office shall research options for developing an electronic portal for inventory tracking purposes and report back to the committee, this committee, about the process and estimated cost of doing so no later than March 1st of 2027. So that is the proposal for tracking in Representative Graham's.
I have a question about, I just have a clarifying question about, because there's a definition in the Graham proposal that defines cannabis as the leaves, stem, flowers, and seeds of a plant, whether growing or not, and harvested cannabis. This is, I'm talking about what is in the required information, tracking information. So I'm on page 9. It says a description of the cannabis plants or harvested cannabis being transferred. It says, then C, sorry, I'm on the wrong part. A record of all mandatory test results for each batch of cannabis and harvested cannabis offered to qualifying patients. So the definition of cannabis includes leaves, stems, flowers, and seeds. Harvested cannabis includes concentrate and cannabis products. And cannabis products includes edibles, I believe. So the question is, does this proposal require a registrant to track the leaves and stems and seeds of a plant, to test the leaves and stems and seeds of a plant, because it says mandatory test results for each batch of cannabis and harvested cannabis? Do you understand the question, Ms. Olson?
I do.
And I'm wondering if there's mandatory testing for leaves, stems, flowers. I know there's flowers and seeds of a cannabis plant.
There isn't in the language regarding mandatory contaminant testing. The definition of batch is a specific quantity of cannabis flower, cannabis trim, cannabis concentrate, or cannabis products harvested or manufactured at the same time under the same conditions. I don't think that is, I don't want to speak for the people behind the bill. I don't think that was the intent. But we could get clarification on the intent.
Yeah, we'll come back to that when someone can answer it, but that's the question for the atmosphere for now. Representative Boyd, did you have a question for the atmosphere? Not for anyone in particular, but just a question about the language.
Sure. Thank you, Mr. Chair. Just maybe I'm conflating it myself, but Representative Graham's version is contemplating metric as the tracking. And then, but I see the language towards the end on page 9 that says the office shall research options for developing an electronic portal for inventory tracking purposes and report back to VLA no later than March 1st, 2027. I just don't understand why that's in there, I guess, if we're using metric in this bill.
Again, I won't speak for the sponsor, but there's nothing in the language and statute that says that it must be metric. It establishes an inventory tracking system that is an electronic system.
Yep.
I believe that similar to the process in adult use, that the office would look for an entity who could provide those services through a contracting process. I don't know if, I think if this were to pass and there was an interest and medical needed to be brought into the inventory tracking system, that would expand the scope of the current contract for Metric with the state. So I think it would be either, and again, I'm not sure what the process would have to be in terms of the sort of contracting or bidding process, but it would be different than what is currently authorized in the contract, would be my understanding. So there would, I think they would have to go through a bidding process, which could include, Metric bidding and it end up being an expansion or an addendum to the current contract. But that would all be a part of that process in the same way that the adult use contract was done. So therefore, it doesn't have to be, according to the statute, the current state provider. And I think that this is contemplating the option of the state developing its own electric portal for this purpose. I think that's what it's contemplating. It wants information on.
Yeah, Representative Mallon had his hand up first. You may proceed.
Thank you. I will start by saying I am authorized to speak on behalf of the bill sponsor here. We worked with this in tandem. And I'll also note as well, whenever the appropriate time is, I will list out what some tweaks to this proposal are so that everyone can have a clear understanding of what is going to be on the table from at least mine and Representative Graham's perspective. But I'll just note, to add some clarification to Representative Boyer's question, there's going to be a couple of things here. We want OCP to do the research on what it would take, including the costs, functionality, so on and so forth, to develop a state-based and state-run portal and report that back to us so that we know. There's been a lot of assertions made about it and we want to know. The other thing that's not in here yet is that.
I don't want to.
Yeah.
I do want to interrupt to
Right.
make sure I understand what you just said. You want the state to research options for the electronic portal that are in current Maine law under the medical program for reporting information. There's language in current law that says they shall establish a portal, and you are saying that they should research what that looks like.
What I'm saying actually, and what I'm going to do is what I'm going to do is propose to move this section that, starting January 1st, 2027 on page 9 and the paragraph right underneath it to unallocated language directing OCP to do these things. And when it comes, and there'll be specific direction on their work with Maine IT to develop the estimate for what that would look like. And in addition to that, I will be including a direction, unallocated language to OCP, directing them to both do this and to put the program out to bid as well. So that is not a fait accompli, that it would just be Metric assuming the medical program.
Okay.
That makes sense.
And one final question on what you just said, Representative Mallon.
Yep.
So does that mean, 'cause the bill would take effect January 1st, 2027?
Mhm.
So from January 1st, 2027 to January 1st, 2029, what tracking system would medical registrants be required to use, if any?
That language is going to look a little different. So if you want me to say what I have for the unallocated language, I'm happy to do that and read that into the record, or I'm happy to do that at a later time, whatever makes more sense.
I just wanted to know if, because of what you just said, when I read these two paragraphs going into unallocated language, it's not clear to me that when this bill takes effect, if medical registrants would need to use the current statewide tracking system in order to report their electronic records to the state. That's the question that I have for you, since
It would not be immediate as of January 1st, 2027, because I'm going to change this paragraph to direct them to go out to bid. So this would be, if we need to, when the time comes, we can ask OCP to clarify some of this, but we're going to be directing them to put it out to bid. we're going to direct them to tell us what it would take to create a state-based system and allow that to inform us about how feasible it would be or not be. And we're also going to direct them to send us the monthly and quarterly reports that are currently required under the adult use contract that was just signed with Metric. So that. because
Okay,
we
we'll
should
come,
receive
we'll
those.
come back
So,
to
yeah.
the devil in the detail on this. Thank you for that clarity. Ms. Olson, you may proceed.
Okay, so Senator Hickman's amendment, page 8. So the this has for required records, subsection 1. This maintains keeping a record of all transfers of cannabis plants and harvested cannabis in paragraph A. It adds paragraph A1 to require that a facility shall keep a record. Sorry, not a facility. All of those listed people, registrant, shall keep a record of each unique batch number assigned to a batch of harvested cannabis, including batches made by combining or blending multiple batches of harvested cannabis. So it's going to do record keeping and inventory tracking at the batch level. And as I already mentioned, it reduces the record keeping time period for all batches of harvested cannabis from 4 to 2 years. The stakeholders are aware of this. I sort of flagged the information in paragraph D to develop and maintain standard operating procedures for a recall and be able to conduct a recall in the event a batch is found to be contaminated. Doesn't actually really fit in this section, so I know that I just wanted to identify that that's an intent, and an intent behind record keeping is to be able to conduct a recall if a batch is found to be contaminated. So I do think there's a few technical things that might need to be kind of worked out there. But substantively, the intent there is for that purpose. And a desire to have standard procedure connected to records and record keeping in order to be able to conduct a recall. This has the office developing, implementing, and administering a statewide electronic portal that registrants shall submit to the office the electronic records that are required in page of the chapter. I'm on 8 still. And same thing about not requiring the information about qualifying patients or medical providers. So then starting on page 9 and going all the way to the very top of page 11, paragraph O there kind of got carried over, are the requirements for the inventory tracking information. And each paragraph is sort of broken out by the type of registrant or the type of activity that the registrant is doing. So 2A is for cultivating registrants. 2B is manufacturing facilities engaged in extraction. 2C are manufacturing facilities manufacturing edible cannabis products. 2D are registrants receiving wholesale transfers. So it's possible a registrant does more than one of these things. We've definitely heard that. But depending on, what you're doing, cultivating, manufacturing with extraction, manufacturing edibles, you'd be required for this to report through the electronic portal. The following information, the time frame for that reporting is within 14 days of a batch of the appropriate form of cannabis. So the 2A for cultivating registrants cannabis flower reaching its final form. For manufacturing facilities engaged in extraction, that is cannabis concentrate. And then, edible cannabis products. It's a little more self-explanatory, and then wholesale, is receiving cannabis plants and harvesting cannabis at wholesale. And they are a little bit different. Each list is a little different, but generally you have your registration number, the date of, that is sort of the appropriate activity, harvest, extraction, batch weight, batch numbers associated, weight. Yeah, I mean, we can kind of go down there, not, they are supposed to be tailored to the product.
The product,
To the
yes.
final form, or to the form.
And if I may,
yeah.
Ms. Olson, I'll just add that on page 19 of the draft in part C of the bill, I just wanted committee members and interested parties to see that C2, similar to what Representative Mallon said, what he might suggest later is that this bill has a unallocated language section in it. It's not complete, but it says that DAFs should develop and implement an online trip ticket for registrants to use when transporting plants and harvesting cannabis by July 1st, 2027. And that would also include the development of the portal, so that the trip ticket and the portal would work together on the back end as well. So I just wanted to point that out since it's related to this part of the law proposal.
You mean the portal that's, we're talking about?
Correct. Correct.
I'll admit, trip ticket, I don't know if that's actually in statute, but it was late, so we
It's
all
the
know what
it's
we're
actually
talking
the
about.
required label. It's just called a trip
so-
ticket, so it's
I was-
different.
I didn't have the break capacity to go
Yeah.
get the right language. You all knew what I meant.
Yeah.
And then, there's no the required label is in subsection 2 on 11. No change there to current law.
It's current law, but it
This is
probably
current law.
it would need to change based on 2A, 2B, 2C, and 2D. But again, that's for later. If we were to vote this out, we would address that section of law of the proposal and the section of law that would need to be amended there.
Okay, so those are the differences with track,
Right. Yeah.
different ways, different proposals for track.
Yep.
So I think we're going to talk about mandatory testing next.
Yep.
Trying to decide if it makes more sense to
That
do
makes
anything
sense.
else, but. Yeah, okay,
Can I-
mandatory, oh, I'm sorry.
Representative Graham?
I have something, somewhat urgent to speak to the chairs about. I know I'm sorry to interrupt, but I
Committee
really
will be-
need to speak to them.
Committee will be in order. I'll remind people in the audience, there is something on the door that we do not enforce unless it's not on the door any longer. But it says no use of electronic devices in the room. The chair has never enforced that in this committee. What I will ask members of the audience to do, I can't control where people's eyes go, but do not record on your telephones or take pictures of these proceedings because it's all recorded right there for us to see. It will be online, and it is not necessary to record and live stream what we're doing from the audience because that's already happening. So I will just ask people to not do that. And if I see you doing that, I'm just going to ask you to leave the room. Thank you. Ms. Olson, you may proceed.
Okay.
Mandatory testing, page 9 of Representative Graham's amendment and page 11.
Yes.
of mine.
Okay. Representative Graham's amendment outlines mandatory testing for contaminants. This is mandatory testing, excuse me, that registrants must conduct on any cannabis or harvested cannabis that is going to be sold or offered to qualifying patient. The opening paragraph of the section 2430P also allows the office to require testing for some analytes in some matrices before the cannabis or harvested cannabis is further processed, manufactured, or combined to ensure that contaminants don't contaminate other batches. And that all cannabis concentrates used to manufacture cannabis products must be tested in accordance with subsections 3 or 4 prior to being used to manufacture a cannabis product or pre-rolled cannabis cigarette infused with cannabis concentrate. And so those beginnings are kind of similar. Both of them also allow the office to temporarily waive mandatory testing requirements under the section. For contaminants, the office has determined that there really is no facility capable of performing the test. The Senator Hickman's amendment does not include the information about testing for analytes in some matrices before being used in other batches. So that language is not included there. As we go through the matrices, they're very similar, but there are differences. But I also want to note, because one of the big differences between the two proposals is that on page 11, section 823 of Senator Hickman's amendment, you'll notice that the first introductory phrase is except as provided in section 2430S. So Senator Hickman's proposal establishes an audit testing program so that if a registrant meets the criteria for the audit testing program, which we'll discuss in a moment, they can request to basically move into that program. And when they do that, they would no longer be required to conduct the mandatory testing under this section as long as they continue to meet the guidelines of the audit testing program. So it's mandatory testing, but not in every instance for everyone. Because there's the establishment of an audit testing program. We've had a similar proposal before us last session about audit testing, but in the adult use program, it's a very similar proposal in Senator Hickman's amendment. When we will get to that, but first let's just talk about the mandatory testing. Because at least to some extent at first, all registrants would be conducting this mandatory testing. So subsection 1 in both here, so page 11 on Senator Hickman's and using your 10 on Representative Graham's. Has the scope of mandatory testing generally. And this is for cannabis, okay, with the exception that the difference between cannabis and harvested cannabis, right? I've already talked about that, but that this is referring to harvested cannabis would include, both versions include residual solvents, poisons, and toxins. Both include metals. When it comes to molds, paragraph C, Representative Graham's amendment proposes dangerous molds and mildew, including but not limited to Aspergillus, SPP, and mycotoxins as applicable. Whereas Senator Hickman's version is specific to Aspergillus, SPP, and the mycotoxin produced by penicillin. So it would look at only those contaminants.
And you are in the scope of mandatory testing generally?
Yes.
Okay.
And the provisions previously discussed regarding testing under the rulemaking for those would apply. That 100,000 total yeasts, and then if you have, you would do testing for these. That actually may be a technical conflict there if the general testing doesn't include total yeast and mold, but the rules said total yeast and mold. And then if you had it over 100,000 colony forming units, you would, per gram, you would do further testing for these two. So I think that there is a technical issue that would need to be addressed in Senator Hickman's amendment regarding that. Representative Graham's that includes harmful microbes, including but not limited to E. coli and Salmonella, which are not included in the general testing in Senator Hickman's version. Pesticides, fungicides, and insecticides is true in both. Representative Graham's also includes water activity for harvested cannabis, except cannabis concentrate, which is not in Senator Hickman's version. And then they both require THC potency and homogeneity, but Representative Graham's also has cannabinoid profiles.
So this is where I'll ask my question on the definition. Well, cannabis is listed in mandatory testing of cannabis and harvested cannabis in Representative Graham's amendment under scope of mandatory testing generally. Does that mean then that all seeds have to pass mandatory testing because they are in the definition of cannabis?
Possibly as written, that is what it would mean. I do not know. I would ask that we get clarification from those who drafted it, if that is the intent of including cannabis there and not some other terms such as cannabis plants or just using harvested cannabis.
Thank you. You may proceed.
So, I mean, you do have the ability at this point, that this gets really into the weeds if I kind of read through these, so you can put these next to each other and do sort of a comparison. So for each subsection 2, for cannabis flower and cannabis trim, in each of these, this matrix, this one includes the plurals. Both of them include cannabis, pre-rolled cannabis cigarettes or cannabis pre-rolls that have been mixed with cannabis concentrate. There is Representative Graham's includes, I have started, why have I started? It's new language, it's different language. It's different language. There's an exception as provided in 2430S subsection 1.
Representative Graham. You may proceed.
Oh, prior testing, yes.
Yes, harvested, is sufficient. We can strike cannabis. It's set apart by itself, so saying harvested is fine.
Okay, so then no seeds. Thank you.
I'm just writing a note.
Yep.
Um, there is a provision about prior testing here. That's why the accept, so 2430S, would have, so if they meet that prior testing provision there, then they wouldn't be, subject to this additional testing here. There is obviously a difference, between, these. This one's, again, includes the Representative Grams includes the dangerous molds and mildew provision, including the two, species. Whereas Senator Hickman's version is only those two species specifically. Representative Grams includes harmful microbes, water activity, and THC potency and cannabinoid profiles, and those are not included in Senator Hickman's. The next section, subsection 3, this is cannabis concentrate extracted using solvents other than water. These are the same, except, wait, no, they're not, hold on. I had 2 pages going. Okay. Representative Grams specifically includes the mycotoxins, whereas Senator Hickman's is that and the aspergillus. And again, Representative Grams has the THC potency, homogeneity, and cannabinoid profiles. 4 is cannabis concentrate extracted without the use of without the use of solvents other than water. Again, the dangerous molds and mildews bit is different. The harmful microbes and the potency, homogeneity, and cannabinoid profiles. 5 are edible cannabis products. Again, these are testing for slightly different things. Representative Grams does not include residual solvents, poisons, and toxins, or metals. Her version includes dangerous molds and mildew, including the 2 identified types, and some information about the requirement if a batch failed for mandatory testing. Whereas Senator Hickman's is again the specific 2 species. Representative Grams includes harmful microbes like E. coli and salmonella, which are not included in Senator Hickman's. It also includes water activity, except for those preserved by refrigeration, and cannabinoid profiles, whereas Senator Hickman's has pesticide, fungicide, and insecticides, which are not in Representative Grams. And they both include potency and homogeneity. And I'm not a scientist, so I won't explain to you why they're, especially in that category, why they might be so different. So we can leave that to the people who follow me. Representative Grams' proposal includes record keeping, a record keeping provision. And this is record keeping that's with the inventory tracking requirements. And that those are not required in the tracking proposed in Senator Hickman's bill through the portal. And the there is a difference between sample collection, testing process protocols, and standards. And I didn't closely examine these provisions, so actually, other than the fact that they are different, I can't eloquently tell you in what way.
I think that Representative Grams sets the allowable rates in the rules. There are rules in that section. I don't see any rules in section 6 of the yellow amendment, the allowable variance rate is just set in statute in that section. That's just the difference that I see generally. It's similar to the other difference where one establishes everything in rules and the other puts those variance rates in statute.
Yes, and Representative Graham's, when allowing for these rules, relies on that same type of language about relying on international and other pharmacopoeia standards. And again, routine technical rules in that version. And can also comply with rules for testing already established under the adult use cannabis program. Okay. Both versions include this exception for mandatory testing. Yes, we are on page 12 of the gold paper. Representative Graham's, yep, 12 gold
13 yellow.
and 13 yellow. So both versions provide an exemption from mandatory testing for harvested cannabis cultivated by a registered caregiver who meets the following requirements. There is a slight difference between the two. But the registered caregiver's cultivation area has to be located at the registered caregiver's primary residence. The registered caregiver does not have a second cultivation area located on property that is not their primary residence. The registered caregiver's cultivation area does not exceed 500 square feet of mature plant canopy or 30 mature plants. Those are all the same. That there are no other registered caregivers with a cultivation area on the property where the registered caregiver's cultivation area is located, with the exception of family who share a primary residence. And there's combined cultivation area can't exceed 1,000 square feet or 60 mature plants. And that the registered caregiver or any other family or household member who cultivates the primary residence does not engage in wholesale transactions. Senator Hickman's amendment also adds that the registered caregiver or any family or household member who cultivates at the primary residence does not engage in retail sales at a retail store or office that is not located at the primary residence of the registered caregiver. So paragraph F in the yellow is different, and I understand I didn't fix the ands there.
It's okay. It's really okay.
And I believe that the provision about adopting rules for certifying these caregivers are the same. And that the requirement of the warning statement is the same. Should have put these in the same font. Or slightly different. Sorry, slightly different. Based on the requirements for testing. So very similar exemptions to consider with slight variation and then adjusted for the type of testing. Representative Graham's amendment has added to from a previous version, a maximum batch size for mandatory testing. That does not exist in Senator Hickman's version. For the purpose of sampling and mandatory testing, a batch may not exceed 44 pounds by net weight, regardless of matrix. And that for flower, trim, and pre-rolls, the 44-pound limit applies to the combined net weight of flower, trim, harvested or manufactured at the same time, under the same conditions and using the same process or procedure.
And are you saying that this is new from a previous version of this proposed amendment?
That is my understanding.
Okay, I think it is. I just wanted to make
Okay.
sure that.
And then has cannabis concentrate and products, how you get to the 44-pound limit, and allows the office to adopt rules for sampling to ensure representative sampling within that 44-pound maximum. Okay. Notification requirements are page 13 on gold and 13 over to
13
14.
and 13,
Yeah.
13 gold and 13 yellow. Gold in the middle top, yellow bottom. Notification requirements.
And
I'm not sure these
I
are all
think-
that different.
these are other than the difference between the harvested cannabis. I think these are substantively the same.
Yep.
Yeah.
Yep.
I didn't flag it, but. So. What next? Samples. Sample collection for testing, I believe is also substantively the same.
Except the rules.
I would probably ask those who put forward the proposal to verify if they changed anything from.
The rules.
From that, yes, the rules.
Yeah.
Sort of want that to be, that's true of everywhere.
That's true. I
basically.
think you
So-
mentioned that already,
So
but
I
I
kind of
think
wanted
the
to cover
rest
that
is
with a blanket
the
statement.
same
Um,
from what I'm seeing. But I'll just put a question mark around that for now.
So. Representative Graham then has her amendments after that. A section on page 15,
Mhm.
section A32. This is, establishing provisions for when additional testing is not required. And on the gold copy, I think I boxed, what is new from a previous version. Otherwise, you've seen this before.
Okay.
And this is not in Senator Hickman's amendment.
Okay.
And then to close out Representative Graham's amendment as it relates to the medical program. It also includes on page 16 at the top, a requirement for educational materials for qualifying patients at the time of sale in printed or electronic form. That includes information about dosing, delayed onset and duration, risks of overconsumption and impairment, considerations for those who are inexperienced or at risk for psychiatric problems, safe storage, and to make publicly available the office minimum content requirements for those educational materials. And that they would work with the Maine CDC and Northern New England Poison Center in doing that. And that is not in Senator Hickman's version. So one, as I mentioned, one of the biggest differences as it relates to contaminant testing.
And Ms. Olson, I'm
Oh,
sorry
sorry.
to interrupt. That is new in Representative Graham's bill, correct? The
Yes.
patient
Yes.
education material.
Yes.
Okay, thank you.
Yes. Yes, from a previous version. to
Yep,
The
new
extent
from
that
a
you may
previous
have
version. Yep,
been
yep, yep.
reading them all.
That's what the stars mean. I
Yes,
suppose.
that's what the stars mean
Got
because,
it. It took me a minute.
because I can't provide it to you in color.
Okay,
Okay.
almost there, everyone, at least to the end of these drafts.
So as I mentioned, one of the biggest differences as it relates to the contaminant testing is that Senator Hickman's amendment proposes an audit testing program, and that you can see starts at the bottom of page 15 on the yellow paper. So this allows the office to establish a program for conducting audit testing of harvested cannabis of of registrants determined eligible for audit testing. A registrant is eligible for audit testing if they've met certain criteria, which include that the registrant conducts 3 consecutive and separate mandatory tests of different batches of the registrant's harvested cannabis pursuant to the mandatory testing section. And that the results of the tests demonstrate that the harvested cannabis in each batch does not exceed the maximum level of allowable contamination for any contaminant that's injurious to health, for which testing is required. If the registrant believes they're eligible for audit testing, they would submit a request to the office, as well as the results of the testing on which the request is based. And upon receipt of that request and corresponding test results, the office would verify eligibility for audit testing and notify the registrant in writing as to whether they were eligible. That if they are eligible, they're not required to then do the mandatory testing in the mandatory testing section. But if they, when the office conducts an audit test under this program, if they identify an exceedance of the maximum level of allowable contamination, then the registrant must resume mandatory testing of the registrant's harvested cannabis under the mandatory testing section. But actually, it's really a but it's may subsequently be determined eligible. So just because you've dropped out of the program doesn't mean you can't eventually come back in. And then again, the office would adopt rules to implement the section, and those would be major substantive rules. There's probably a little bit of confusion. I think there could be confusion because there is audit testing already. We've sort of used that term, and then this is introducing the audit testing program. So to the extent that might be slightly confusing, this would be audit testing that is different or distinct from the other authorized types of audit testing that they can already do in the medical program. That office can already do in the medical program. But now that I've read this, this kind of provides, there's mandatory testing, but you can opt out. And then there's a unallocated section that's connected to this on page 19, which is part C, C1. And the unallocated language says that it's sort of like a retroactivity clause kind of for this, if you will, that a registrant may submit the results of any testing completed within the 90 days prior to the effective date of this act. That includes the result of testing that is described in the mandatory testing section, in order to determine eligibility for audit testing that's provided in the bill. So
it's a way of saying for people in the medical program who have been doing extensive testing already, that they would be able to perhaps qualify for audit testing based upon results that were completed within 90 days of the bill taking effect.
yes.
So as not to quote unquote penalize them with more mandatory testing, even though they've already done it voluntarily, so long as it passes according to what's in the bill.
So I would like to draw your attention back to page 6 and 7 of the yellow amendment, Senator Hickman's. I skipped this because I wanted to talk about the audit testing first. Sort of first and maybe unrelated, but I just decided to wait. Section 820 on page 6. This is not in Representative Graham's amendment, but this does establish a registration violation. In this case, a major registration violation affecting public safety. And it adds intentionally or knowingly failing to conduct a recall of harvested cannabis or cannabis products when ordered to do so by the office. It's not quite related to the audit testing. I just didn't talk about it before. But section A21 on page 7. This is adding an administrative penalty for failure of audit testing. And I know that the people who worked on the on the language are aware that I am not sure I understand how this works. But, so it is establishing an administrative penalty. And so it's saying that the department shall notify a registrant within 1 business day after the department discovers, and those all should probably read office, but, discovers that a registrant failed an audit test. And then it's requiring, this part I think I got, that's requiring that both the registrant who is subject to the audit test and the registrant from which the batch of harvested cannabis that failed the audit test, from which it originated, if applicable or as applicable, could be held responsible. And then it lays out sort of the procedures in paragraphs A, B, C, and D. This is where I don't really understand how the provisions in ABC connect to the provisions in the audit testing program, where they say if they discover in an audit test that you're exceeding the limits, you go back to the mandatory testing, because I think this is a little bit contradictory to that. So this is something that would need to be sorted out. It's saying that upon the failure of the audit test, that the responsible registrants, which is how I'm going to refer to that phrase here, may be subject to an administrative penalty for a minor registration violation. Those are outlined, the different types of registration violations. And that the registrant subject to the audit test and all other responsible registrants may also be subject to up to 6 additional audit tests at the expense of the registrant. What I think is a little unclear to me as it goes is that my understanding of the audit testing program would be that if you fail an audit test, you go back to mandatory testing. And this is implying you wouldn't, that there would be more additional audits testing afterwards. So that's unclear to me. And then it's this sort of is a ladder. If you fail the additional test under paragraph A, then you might be subject to an administrative penalty for a major registration violation, so climbing the ladder. And may also be subject to 6 more tests, audit tests. And then if you fail that level, then you might be subject to suspension or revocation of your registry identification card or certificate, because a major registration violation. So it's climbing the ladder, which is why it also includes D. At any time, the registrant may surrender or destroy the harvested cannabis or cannabis product that has failed an audit test. It also allows in the first block paragraph that the registrant may have a sample from the same batch that failed an audit test retested within the same matrix by a cannabis testing lab of the registrant's choosing and at the expense of the registrant. And they may use that test in place of a failed audit test conducted by the office. I mean, they're not the ones doing the test, but and you can only retest a failed audit test within the same matrix once. And you're subject to those penalties, whether it was you or your registrant agent, the registrant or the registrant, and they're cumulative. This is
contradictory.
It's contradictory, and it's not clear to me yet how the stakeholders want to see these provisions align. Okay, those are the adult use provisions. I don't know if people want to take a minute.
Medical provision.
So before we talk about the far fewer changes in the adult use program.
I think we're almost there, and the provisions in the adult use, I think in both proposals, it's substantive but short. So the reason why I like to finish is because I know Representative Mallon and Representative Graham are representing the Graham Amendment and can confer about who is going to answer what questions that the committee has. And the same for the stakeholders. They need to just confer about who's going to answer what questions, because I'm not calling everybody up. to answer questions. So people can confer about who's going to answer specific questions. And also because the analyst has drawn some contradictions out and some things that are unclear, what those solutions are, if any. So let's just finish this before we take that break. Thank you, Ms. Olson.
Okay. So, Representative, okay, so now we're in the adult use program.
Yes.
Okay, everyone ready? Ready to
Yes.
go title 28B. Okay, it is page 16 on the gold and also on the yellow. So Representative Graham's amendment includes a revision, an amendment to the definition of cannabis flower in the adult use program to include pre-rolled cannabis cigarettes. There are no changes to the definition of cannabis flower in Senator Hickman's amendment. What I do need to note for the committee is that for the purposes of taxation, particularly excise tax, the definition for cannabis flower in the adult use program is what is used in Title 36 regarding taxation. So you should be aware that if you change the definition of cannabis flower for the adult use program, it impacts or could impact what is taxed in which way.
Yeah.
And the question of pre-rolled cannabis cigarettes and taxation is one the committee has wrestled with before. So if you're not sure if everyone was around for that, but I'm flagging that as something for the committee to be aware of. So Senator Hickman's definition, proposal includes a definition for cannabis pre-roll. Its inclusion here doesn't directly impact taxation. It is not referenced because it's new. It's not referenced in Title 36 for the purposes of taxation. But it's being included here. They do mention it is included in the matrix. The definition as proposed is to call it a cannabis pre-roll, to mean cannabis flower, cannabis trim, or a combination of cannabis flower and cannabis trim that is rolled in rolling papers, cigarette papers, or wraps with or without a cardboard filter, sealed and packaged for smoking. A cannabis pre-roll may be infused with cannabis concentrate. The rolled in rolling papers, cigarette papers, or wraps comes from the definition of cannabis paraphernalia. Yeah, 60. No, it's okay. 60. Thank you. And that phrase is based off of the phrase from the cannabis paraphernalia section. And my understanding is a cannabis pre-roll, of course, is written, may be infused with cannabis concentrate. It's possible it may be infused with other things. So that to the extent that we might want to either say that or allude to that, you might want to work on that definition. Okay, matrix is included here. It's new in both. And we're now talking about adult use cannabis or adult use cannabis products. That's the phraseology in the adult use program. Matrix includes cannabis flower, cannabis trim, and cannabis pre-rolls. However you'd like to, whatever way you want to refer to that. Cannabis concentrate, and cannabis products. So matrix is the same in both proposals in the adult use program, as is the revised definition for testing facility.
Yep.
And that's bringing in those that may be registered in accordance with Chapter 5 of DAC, the medical program. Page 17, Representative Graham's amendment, and also 17 on the yellow paper. I actually think these are the same.
I think so.
I think so.
Yep.
I think those provisions are the same. And So it sets up essentially the same matrix as we talked about in the medical program. There's the scope of mandatory testings, that's the general testing. And then breaks it out to include cannabis flower and cannabis trim, which includes the cannabis pre-rolls, concentrate using solvents other than water, concentrate without the use of solvents other than water, cannabis products. Those are true in Senator Hickman's amendment as well, in terms of the matrix.
Yeah, I think that these,
And then
I
these
think these are
are
virtually the same.
virtually the same, actually, yes, and I'm just doing a quick scan.
And
The Representative Graham's amendment includes in section B6, bottom of page 17.
Yep.
It refers to except as provided in section 605 subsection 1A, which I think is the no additional testing required section. I think, and I can look, but so that's not in Senator Hickman's version, I don't think, unless I've.
no, I
No,
don't think,
it's not included there.
I don't think that this version was seen when this version was worked on, because I
Yes.
think these are new to Representative Graham's amendment. I think that's why they're not here. We were
Yes,
trying,
that was new. Yes.
the
you are
stakeholders were trying to
correct.
copy these two sections pretty much the same.
Yes.
But the new provisions in Representative Graham's bill didn't make it into the yellow copy because
Yes.
they just didn't.
Okay, and I think for everyone's sanity, I won't read through the difference of the required testing. You can place them side by side to make sure that they're how they're different. They're different.
And then section B10
section-
again, in Representative Graham's amendment,
Yes,
was new to this version. And
yes,
therefore was not in the yellow version.
okay. And yes, and I believe that is the maximum batch size is the
Yep.
same as
44.5.
for the medical use.
Yep.
Purpose, so I've already gone through it. And then it includes the exemptions from final form testing that is
Right.
referred to in what I mentioned before.
Yep. Representative Graham?
Thank you, Ms. Olson. I hope everybody has an understanding of all this. If I may, first, comment that I have never in my 4 legislative sessions worked harder on a bill and worked really, really hard to compromise, to come to agreement, to listen to everyone. There are a few tweaks that we'd like to make to my amendment. And I say we because Representative Mallon has been instrumental in helping me put this together.
Of course. We
So-
combined those two bills. I mean,
Right,
for
right.
lack of a better term.
Essentially.
Yeah, it's like,
So with that, Mr. Chair, I wondered if I could ask Representative Mallon to kind of go through those for us, kind of handing the ball to him. So there are several tweaks in my amendment.
so we'll go through the tweaks. We'll hear from Representative Mallon. And then if folks have questions they've been taking notes on, we're gonna take a brief break after we hear the tweaks so that people can be prepared to answer those questions. And so we'll just put them out into the atmosphere so everybody knows what they are. And then we'll take a break. Representative Mallon, the floor is yours.
Thank you, Mr. Chair, and I want to reiterate my gratitude for Ms. Olson. She has gone above and beyond for us, and I'm not sure we deserve it, but any of us. But these are the tweaks using this amendment in the gold as the base, and I'll be prepared to put this in the form of a motion at some point. I will not do that right now. What we will do is using this as the base, one, as was noted earlier, we will stick with harvested cannabis, as opposed to cannabis. That, I believe that's the intrograph in sub one. And if we have to address that anywhere else, trust Ms. Olson to identify that for me. So we'll make that change. That was not intentional in this draft. Two, and I'm gonna go sequentially through the bill, for I think that's the easiest way to do it. So two, if you look at page 6, A24, kind of in the middle, lower middle. There was a technical change recommended to strike except as provided in subsection 2A. So it would just be may have the amount or potency of cannabinoids. Okay, since this, so that's that.
Yep.
Next up on page 9. Strike the new language that is bracketed out and starred by Ms. Olson here. That's starting January 1st, 2027, and then the paragraph underneath that. Strike those. That's going to be addressed in unallocated language later. Working sequentially though.
Yep.
Strike the page 9, strike the part that's bracketed and starred by Ms. Olson, those 2 paragraphs there on page 9.
Starting January 1st
Yep.
and ending March 1st.
Exactly.
Those 2 paragraphs.
Exactly. Then if you go to the next page, page 10, there was a small bit of new language that was underlined and starred here by Ms. Olson on part 2 of page 10, except as provided in section 2430-S subsection 1. Strike that. I'm going to address this in another way later.
Okay.
Then we go to
Section 1.
then we go to page 15. On page 15, if you see in the middle of page 15, the part that's bracketed and starred by Ms. Olson again.
Hold on one second.
Yep.
I want to just look at what you are taking care of in a different way before I lose my thought. Okay, go ahead. Page 15.
Page 15, yep. The part that is bracketed and starred by Ms. Olson,
Yep.
again, those sentences. I propose, I would like to strike those sentences
Yep.
and replace those sentences with the following. For the purposes of this subsection, further processing, manufacturing, or alteration does not include the use of cannabis concentrate in the creation of an edible cannabis product, comma, except for testing under section 2430-2430-P, subsection 5, paragraph D. And Ms. Olson, I can provide that to you in my very messy page here.
And can you tell me what that does?
What we are doing there, and we will address it later, this is about pre-rolls. What we are doing there, and we will do it again in the section under adult use to match it up, is we are not going to, excuse me, we are not going to waive the requirement for final form testing on the pre-rolls, but we want what we intend to do is to have it so that people don't need to test twice. But we want that test to be closer to the point of sale, which is why final form is there. There is also in the other section a relation to LD 1488, the language in that bill, which made it to the governor's desk and then was recalled around edibles in particular. And we're trying to mirror the language that was in the majority report for that. And we could ask Ms. Pierce to clarify that further, but the actual changes to the amendment are right there. And if I could go continue going through it.
Yeah, no,
I'm probably
keep
not being
going.
as articulate as I
No, no,
can be.
keep going.
So next we go to page 16. And this was something we discussed very recently. In the middle there, part 12, where it says cannabis flower includes pre-rolled cannabis cigarettes. Let's remove that addition. I want to remove that
So
addition.
section B1 goes away.
Just that the addition, which is the line cannabis flower includes
I
pre-rolled
know, but that
cannabis
means that
cigarettes.
section goes away because that's the only change.
Right,
in
exactly.
that section.
You're
So section B1
you are
goes
correct.
away. Yeah.
You're correct, Mr. Chair. So that is that. We're gonna take that out. Next up, 7 here. All right. On page 19. This is the other part of the pre-roll issue. Page 19, B11.
Yep.
Strike that whole paragraph. And what we want to do instead is in this section of law, which is section 605 subsection 4, add the language, quote, and I'll again provide this to Ms. Olson. Further processing, manufacturing, or alteration does not include the use of cannabis concentrate in the creation of an edible cannabis product, except for testing under section 602, subsection 1E, paragraph D. So that is that. I'm almost done, I promise. Then 3 bullets that will be unallocated language.
Yep.
First up, and this is connected with the recent contract that was signed between OCP and Metric, requiring OCP to provide this committee with monthly and quarterly updates in writing about Metric's performance on the contract that went into effect last week for the adult use program, having those reports begin to come to us on July 1st, 2026, and for the duration of the contract. That's one. Second bit of unallocated language. Require OCP to conduct an RFP in order to select the vendor to provide inventory tracking services for the medical cannabis program. And this should begin, this shouldn't wait until January 1st, 2027. This should begin 90 days after adjournment, should the bill pass, so that they can get this RFP started. And if we need to tweak the effective date of the legislation to make that work, I'm open to whatever ideas are necessary to that, but I want OCP to get started putting this out to bid and going through a competitive bidding process. That's part 2. The final bit of unallocated language, the final bit of unallocated language is directing OCP to work with Maine IT to develop an estimate of the development and maintenance costs and functionality of an inventory tracking system developed and maintained by the state that meets the requirements of this law, and to provide that estimate to the committee no later than March 1st, 2027. Those are the bits of unallocated language. That is everything in the amendment that if I were making a motion now, I would include. I'm not making a motion at the moment.
I appreciate that. 2 questions.
Yep.
For you, sir. And they don't have to be answered right now because we're gonna let everybody else put some questions into the atmosphere as
Totally.
well. Again, what requirements for tracking of medical cannabis would go into effect when the bill went into effect, notwithstanding the unallocated language? And the second question that I have is regarding page 7 of the bill of the amendment.
Yep. So it's page 7. Got it.
Where the medical use of cannabis fund is being amended to do something other than what is currently in statute. Are you married to page 7, both sections?
I am not.
826 and 827.
I am not married to it. I am not prepared to say definitively that I would support removing or keeping it. I will say I am personally not married to it. My co-sponsor might have an opinion on this as
Representative
well.
Graham?
Yeah, I'm quite committed to
Okay,
the educational chair.
that's good.
So I'm married to it.
Okay, so now I'll take questions from the committee that you want someone who is not in the room, I mean, at the Horseshoe or our analyst to answer based on what we've already talked about. So who wants to go first? And if you have more than one question, by all means, ask it. Chair recognizes Senator Timberlake.
Thank you, Mr. Chair. And I don't know as I want to, I guess I want to pose a question through you at the moment.
Okay.
I would like at some point, before we get too far into it, I guess I'd call it a 10,000-foot view of this, and I don't know. I guess I'd like to have maybe Gabby from OCP come forward and give us her feeling of what I'm not asking her what her opinion of each bill is, but what she sees as the major differences of the two proposals that are before us, and what, I don't know, as I listened to, and Miss Olson, you did a fantastic job. I mean, I can tell you, it's crackerjack, top of the line. But whenever you think that's necessary, I'm looking for that 10,000
Got
foot
it.
view from the department.
Okay. Any other questions that people would like to have answered? Representative Fredericks, followed by Representative Faircloth.
Let's see, the 44-pound batch limit. So I wondered, how did that get determined? 44, not 45, 46, 50? What happens to those batches that exceed that amount? Is that another batch number for the excess of the 44? So I don't know who answers that. Oh, I just lost the second question.
We can come back around.
Thank you very much.
Representative Faircloth.
Thank you, Mr. Chair. Senator Timberlake beat me to the punch on part one, my question, but the same request from Maine Public Health Association or Maine Medical Association with their commentary.
Which question?
To get an
the
over-
10,000 square foot.
Yeah,
Okay,
yeah.
thank you. Any other questions, Representative Boyd?
Thank you, Mr. Chair. I like how you said square foot.
Who knows? I haven't slept all night.
Canopy on the mind.
So go on. 10,000 square foot. Oh, I got it.
Similar to Senator Timberlake's question, but maybe for Representative Mallon and Representative Graham as to their thoughts on the Hickman Amendment and where there is common ground. I think we could get to a unanimous report. I don't think these two are too far away from each other. Optimistic. But I would also like to recognize the industry has put forth a good faith effort of mandatory track and testing. And they are conceding considerable time and treasure to implement this if it were to go through. And so I guess I just wonder where the Venn diagram is, and want to recognize the industry for I mean, they're not getting anything in this bill other than more regulations. So I appreciate that they've tried to step out into the moment and come up with something that legitimately does track and test medical cannabis in a mandatory fashion.
Representative Fredericks.
Thank you, Mr. Chair. It came back to me, the research component of this. It was my understanding that we could have commenced research using cannabis dollars back in 18 or 20. So I wondered if this was additionally, or we just asking the department to do what they they're permitted to do. So that's that question. And then about required educational content. I am aware that the Maine CDC does have a patient education on edibles currently. And I wonder if the committee is aware of that, what content is on it in regards to, preventing children and animals from exposure. But that may be something that's worthy of being discussed, just to
Yeah.
share it.
Representative Graham, I just want to get questions out. We're going to take a break, and so that's all. I know that people want to defend positions, but this isn't what this is for exactly at this moment.
I appreciate it. Great.
Any other questions that people need to have answered by someone? Representative Frost.
Yes, thank you, Mr. Chair. In your amendment, the mention of the portal.
Mhm.
And who is funding that, like the creation of the portal? How are we funding the creation of the portal?
The medical use of cannabis fund, but any other questions? The question that I have for the industry is to address the contradiction that Ms. Olson brought up between the audit testing failures that exists in the proposal. And did I have another question for the industry? At the moment, no. Any other questions before we take a break? Senator Timberlake?
Yes, I'm trying to figure out what time to tell my wife to have my supper ready.
I'm not getting between you and your wife. Any
No,
other
it's you.
questions?
You're the problem.
Representative Fredericks?
Thank you, Mr. Chair. Just because they're different, one has record keeping for 4 years, the other is for 2 years, and just,
What's the difference?
what's the rationale?
Yep. Record keeping rationale. Okay, Representative Boyer?
Thank you, Mr. Chair. I'd be interested in members of the industry weighing in on the two kind of amendments as is and the costs that they see that they would incur, the time and treasure that they would incur on both of them. If they could contextualize that for us.
Okay, you mean the medical industry or both? Well,
Medical.
Medical, okay, thank you. Yes, ma'am. Representative Fredericks?
Sorry, just go. So the question is to whomever, why aren't we calling pre-rolls instead of cannabis cigarettes? Because I fear about taxation, the implication on taxation or other. So in the bodies of these things, one calls cannabis cigarettes, one calls cannabis pre-rolls. Why not pre-rolls?
Okay, that is the question for those who call it cigarettes, I guess. Any other questions before we take a bathroom break for everyone in the room, including the chair? Seeing none, the committee will be at ease. Everyone determine who is best to answer these questions. If it's the department knows who's best to answer the questions. For the industry, you all know who's best to answer questions. Get your answers together. We'll be back. The committee will be in order. The chair has failed to recognize that we have a member with us who's been online for a while now, even though I forgot to mention, Representative Quentin Chapman has been with us for a while now, and I don't know if he's with us now, but if he is with us now and can hear me, he can turn on his camera. If you don't turn on your camera and you are participating via Zoom, the chairs will not know that you are here, or may forget that you are here if you don't show up at least once to introduce yourself. So I don't see him turning on his camera, which means he's probably not in front of his computer at the moment, but I'll ask him to do that. The committee will be in order. Thank you. So we are left with a bunch of questions that we would like to have people answer. And so I don't know where Senator Timberlake is, but oh well. I'm going to ask first Gabby Bearby Pierce to come forward to give her 10,000 square foot view of what the senator has requested of the Office of Cannabis Policy. And any specific questions that I know Gabby or her colleagues in the Office of Cannabis Policy will be able to answer, more specific than the 10,000 square foot view. We'll get to those while she's here. We'll follow that up with the public health 10,000 square foot view. And then we'll get into some other specifics around public health. And then we'll hear from industry participants who worked on the amendment and some who did not actually work on the amendment, but have something to say to the committee to answer Representative Boyer's questions about cost. So Senator Timberlake is here. Please introduce yourself.
Good evening.
It is evening.
I'm Gabrielle Bearby Pierce. I'm the Policy Director for the Office of Cannabis Policy, and I thank Senator Timberlake for the question. And just to reiterate, the question was the Office of Cannabis Policy's 10,000 foot view on both amendments.
My question is, 10,000 foot view on what the difference of these two amendments are.
10,000 square foot view.
Yeah, not square foot. We're
I
not
keep
talking
saying square
canopy.
foot.
We're doing
I'm a
acreage?
pilot.
What are we doing? Okay, great.
No, sorry.
We may have to bring it down to 5,000 because it's getting late
Okay.
and the skies are cloudy.
So my impression between the two bills is that while they appear in some places to be similarly situated, the effect of the two bills, the two proposals, is very different. And so what is implemented in the Graham amendment is something that it is a mandatory testing program that requires testing of medical cannabis before it is transferred to a qualifying patient. It requires same day inventory tracking, so the office is aware of where all the regulated cannabis is in the state at any given time. Oh, sorry.
I want to follow up on that. So you say that one does that, and the yellow one, whatever you want to call this color.
Would you like me to bounce back and forth as I go through?
I'd like to know why you think this one, the testing is better than because this one has testing in it too, and what is the difference in the testing?
Absolutely. Okay, so when we look at the testing required by Representative Graham's bill is mandatory. The testing required by this amendment would end up being audit testing is something that has been tried in other states that has been administratively nearly impossible to administer, and it tends to favor multi-state operators and large-scale operators who are doing a lot more volume. And so our expectation would be that because of the way the audit program is set up, it is pretty easy to make sure you get a passing test when you are submitting your audit samples. You're going to sample the batches that you know have, because you've done R&D testing, you know are going to come back clean for the analytes. And it does have some concerns because we don't have a lot of clarity around who should be doing the sampling, what kind of chain of custody would be required for those audit samples. And
you mean the mandatory samples?
The audit samples.
Okay.
The audit testing samples. There are concerns around just So that's all related to just kind of the design of the program. And then I will say what is tested for is also concerning. So we're not testing for E. coli and salmonella under the butter color. In the Hickman amendment, let's see. We are not in section 5. Oh, sorry. Oh, wait, no, sorry. I'm looking in the wrong section. Let's go back to part A.
But as you continue to look through the 10,000-foot view.
Well, I think we're getting a little
I know.
narrow here.
I think the intention, and the industry can correct me if I have their intent wrong, is that the audit testing, the samples are supposed to be collected by the agency.
Okay, that's all right.
Just, that might not be clear, but that's the intent. And so if that were to move forward, that would be clarified. So continue.
So if I can I back up just a
Yes.
bit? All right, so I would like to take this back to 10,000 feet. Great. The Butter Amendment, the Hickman Amendment appears to not learn the lessons from Colorado about audit testing, or the lessons from Washington State around inventory tracking that we have been shown in sharp relief over the last few years. Colorado has what is called reduced allowance testing. And I think I've talked to some of you, so forgive me if I am repeating myself, but Colorado has implemented reduced allowance testing, which is similar to the audit program that is conceptualized in this bill. It is difficult to administer. It is very hard to know what categories of products, if you've got vertically integrated operators like we do in our medical cannabis program, which categories of products should or should not be exempt from testing. Now, it appears that here you pass 3 tests, and regardless of how many products you're making or how many strains you're growing, you're exempt from testing until such time as you fail another test. And so that is a little bit more simplistic than what Colorado is doing. But overall, when you have an audit test system like this, or a reduced testing allowance system like Colorado has, you end up really reducing consumer confidence, patient confidence in testing, because you are ending up doing huge recalls anytime you have an audit test spike, because you essentially have to go back through your supply chain and say, everything since they last had an audit test could be contaminated. And so in order to provide the information the public needs to understand the risks associated with their consumption, Colorado ends up doing very, very wide scale recalls related to this reduced testing allowance requirement. I believe Michigan has also implemented something similar to this that is so administratively burdensome that they can barely administer it. So I know I've talked to this committee about those 2 examples in the past, and they have not gotten any better. Washington State, I think at the beginning of last session, the beginning of this session last year, we provided you with a report from the Washington State Auditor that was a follow-up report to their initial report on the disastrous implementation of their state-built tracking system and the various iterations, the various things they have tried to do to get out from underneath that quagmire. And one of the determinations of the state auditor's report from last year, from 2024, I should say, was that they will not be in a position to really have clarity around their inventory, their cannabis inventory in their state until 2031. So what I see in the Hickman Amendment are some concerning policies that really veer right into disasters we have seen other states do. So that is kind of the highest level I could say there. To get back, and again, like, I don't want to get too far into what we are subjecting the matrices to for testing in the medical program, but I think the thing that really caught my eye, pardon me, is that in 2430P. Yep, page 11. For medical cannabis, we do not have required microbial testing. So we do not, whereas in the adult use program in Part B of this, you do have testing for microbials, E. coli and salmonella. You do not see that same language in subsection 1 under 2430P. It appears that what you are testing for in terms of yeast and mold, and again, I think the analyst might have flagged that you have rulemaking that directs one thing around yeast and mold, and then here you have a different kind of matrix set up there for yeast and mold. So that is certainly a conflict that would need to be clarified. So that's overall, we have serious concerns about this because we see a lot of the policies that have been implemented. We see a couple of policies that have been implemented to very costly effect in other states that have not worked well. So that's what we see.
Costly to who?
Costly to the state and costly to the industry, because in the Washington State example, the manual data entry and then the manual data cleanup necessary to get any information out of the state system is incredibly burdensome for both industry and state regulators.
Chairman, just to
Senator
follow
Timberlake.
up. When I heard you say that the recall could be big, when I think in the adult use industry, I would say the recall could be big, but this is my thought process, and take it for what it's worth. And it's worth exactly what you paid me for it, nothing. But the medical industry I see is they deal with smaller batches, smaller things. I wouldn't think the recall would be anywhere near as big, because I'm just, it's in my head, I think of, the adult industry is putting out, and I don't know what the number is, but let's say 10 pounds a week, and the medical industry's person's putting out a half a pound a week. So I would think the recall, I think is bigger than I would think it would be in the way you're talking. So can you explain how that would be so big?
Yeah, so I know a lot of times we talk about apples and cannabis in here, and we talk about them as similar agricultural products. The thing about cannabis that makes it a relatively unique, well, there's two things actually, a relatively unique product. One, there's an illicit market for cannabis. Two, cannabis changes form from the time it's harvested to the time it gets to a patient. That can mean the combination of multiple batches. So you might have a combination of multiple strains of cannabis that you would use to then make some pre-rolls. You might take some of that as well and turn it into a cannabis concentrate, or you might combine multiple batches into a cannabis concentrate. And so every time you have one of those combination events, or every time, yeah, I would say when you're having those combination events, that's certainly a place where your chain of custody gets more complicated, and the scope of your recall. Again, if the last time I tested a batch through audit testing was last October, and tomorrow we have a failed audit test, we have to be suspicious of all of the inventory produced by that particular cultivator or manufacturer during that period in between the last pass test and the first failed test.
I don't want too many back and forths because we have more. Okay, Senator Timberlake.
So wouldn't it be up to the medical, because this testing thing is.
You wanted this though, so let's just kind of stay up here.
Well, I know, but somehow I gotta get answers, and you've kept me here to this hour. But wouldn't it be up to the medical supplier to make sure that they don't get out that far? If they get out that far, shame on them versus, with their testing. They could test more often if they wanted, if they was doing a lot of business. It just doesn't make sense. Okay, I won't leave it alone.
Thank you, Senator Timberlake.
If I may just respond to that, I would say that the the level of detail required in the records, the timing of the records, testing and tracking really go hand in hand. And so we don't have a good sense, given that there's a 14-day delay in reporting records, given that there are, what, come again? I'm sorry.
No, just continue.
Okay, given that the report, the combination of those things will also be on a 14-day delay, we do, and because there's not a lot, we are seeing a fair amount of contamination in the medical market when there is not a mandate for testing, and that audit requirement would remove the mandate for testing during that period. They are covered by the audit exemption. And so I am skeptical that there would be a lot of additional non-mandatory testing for those who are not subject to that during that time period. The only other thing I want to say is the Butter Amendment does not, there is nothing in that amendment that will do anything to curb the illicit markets that we have right now. So I want to point that out because I expect that will be a follow-up question at some point. So any other questions related to that?
I just thank you, Ms. Pierce, for the 10,000 square foot view from the Office of Cannabis Policy's perspective. Are there any questions about that specific point of view from the committee? Because we're going to go back and forth a bit. Representative Fairclough, you may proceed.
Thank you, Mr. Chair. Just because if I understand correctly, you mentioned Michigan and Colorado and Washington State as being rubrics that maybe have challenges, have problems. And whether it's states that are comparable that would be consistent with the Graham Amendment, are there states that say, yes, this contrastingly works in a way that's effective for proper testing?
I would say that the Graham Amendment looks a lot more like testing and tracking in medical cannabis programs across the country.
You named examples
Mhm.
of ones that did not. Would you care to name examples where you say, yes, this is analogous to states that have been successful?
Yes, I have an entire spreadsheet that has
Okay,
all the testing
all right.
requirements. So I can tell you, for instance, oh, goodness me. Connecticut would be one that kind of jumps out right off the top of my head. They have, yeah, I'm so sorry. I can certainly, if you want to call me back up in a minute, I can look at my.
Yeah, I was going to say, and
But I do want to.
that was what I was going to suggest, because he is asking for examples of states that have a similar tracking program to this that you consider successful.
Mhm.
And then there could be questions about what that actually means, what does success mean in those states?
Mhm.
So let's do that, not in this moment, because you're going to get that together. I'm going to ask whoever the industry representative who worked on this is to give us their 10,000 square foot view of these amendments. And then we'll continue through the list of questions that we got from the committee earlier. Representative Frost.
Thanks, Mr. Chair. Thanks for being here, Ms. Pierce. This is another question that I don't expect answered right away, but it's a very general, very broad question. The main concern I have is the affordability issue for the testing for this industry. Is there any wiggle room? Can we get the prices down on this at all? That is a question I've had for a long time.
If I can respond to that, and I will say it is something that we are very concerned about, or not, we have concerns about in the Graham Amendment, is the 44-pound batch size. And so that is, my impression is that is aimed at reducing the number of smaller test batches you need to break a larger test batch into. And because you had asked the question, 44 pounds is 20 kilograms. So, and right now the limit in the adult use program for a batch is 10 kilograms. So that's 22 pounds as opposed to 44 pounds. And so it is my impression that the 44-pound limit or batch size that is in Representative Graham's bill would reduce the number of batches that would need to be submitted for testing. Batches, and again, the batches, same time, same it was cultivated at the same time, same place, same strain, that sort of thing. So the definition of what is a batch becomes very important there. And our concern around the expansion of that batch size is that a batch that big, it is very difficult to pull a representative sample from 44 pounds of cannabis. So.
Thank you, Ms. Pierce. If you could trade out your seat for 1 minute, you'll be back. Oh, I'm sorry. Representative Boyer has a question before you go. Go ahead.
Thank you, Mr. Chair. Two questions. One, what is the northernmost lab location?
Gardner?
Okay. And thank you, Ms. Pierce. And then you assert that the Hickman Amendment would do nothing to curb the illicit market and to curb inversion into our medical program. Is that right?
That is correct.
I guess I would say and ask for your opinion, if we're putting in testing requirements, mandatory or even audit, that they'd be responsible for if we go to audits, similar to what Senator Timberlake was saying with you're exposing yourself to more risk by not internally policing yourself. With that in mind, wouldn't there be a really, there'd be a disincentive to buy potentially dirty weed from illegal growers because you bring that into your shop, now it's subject to testing. And so I guess I'm trying to understand how, we're putting in real penalties and risking, losing your right to operate in this industry if you have these major violations. So it seems like there's big reasons not to buy dirty, cheap weed.
And that doesn't have to be answered, and I appreciate you putting it out there. We're still in this part of our conversation, so I don't want to be too argumentative or defend points. Ms. Pierce, you'll be back. You can consider that. Representative Graham has one before you go away and come back. Go ahead, Representative Graham.
Thank you, and you can come back with this if you'd like. As you look at the Hickman Amendment and then you compare it to my amendment, I'm concerned about what type of fiscal note we might be seeing with the note. I know my amendment, we worked really, really hard not to have any fiscal note. We dropped several things that to kind of answer the question about education. We're not going to put that there, that the department already has an ability to educate. So could you help me understand what type of fiscal note you might see with the Hickman Amendment?
And I'm sorry, Senator Hickman, did you say that the audit costs were to be paid for by the registrant or the office?
The mandatory testing costs, I think, are considered, now I'm going to ask someone who worked on this to clarify, will be paid for by the registrant. And the audit testing would be paid for by the agency as it currently exists in the adult use program. But this is why I'm asking someone from this amendment to give us their 10,000 square foot view on the same thing and respond to anything that you have said that is not argumentative. So thank you, and you'll be back. Ms. McCarrier, are you here, Mr. McCarrier? I would like, unless you have designated Mr. McMahon, there's only room for one of you. So Mr. McCarrier or Mr. McMahon, I want the 10,000 square foot view of these two amendments as you understand them, and even though they all need work, as we have heard from the supporters of these amendments so far. Please introduce yourself.
Good evening, Senator Hickman, Representative Speaker, and honorable BLA members. My name is Alex McMahon. I've got my high level that I want to lay out for you as far as for the tracking and as far as for the testing. So as far as for tracking, so for one, as many of you on the committee know, I also have a grocery market. I deal with thousands of SKUs that are not cannabis, including beer, wine, liquor, apples, produce, meat, all, regular grocery items. There are sensible ways to track inventory, and there are ways that get into around that, in my personal opinion, is outside of sensible. So when it comes to the high level of what this proposes, It is not tagging every plant of an agricultural product. I understand that's an agricultural product that has effects, but it's not tagging every plant. It's not tracking every gram or fraction of gram. When we're talking about tracking 100 milligram edibles, that is 1/10 of a gram of THC. The last OCP director, this is a concept that he understood well and actually advocated that, we are not trying to track grams and fractions of grams. We're trying to see if 100 pounds is extra here or if 100 pounds is missing here. It was the prior director's belief that that is what a tracking system should accomplish. I agree with that belief. So for the portal as it's proposed, so it does not come with a device that the office can wave around and automatically collect all the inventory that's in the room. It does not include tagging every plant and tracking every fraction of a gram to the sale to the end consumer. However, what it does do is it collects enough information so that the regulatory body can look in and see, okay, this caregiver, CGR 420, claims they harvested 1,000 pounds in the year 2026. I can look at other information that was entered and see that 980 pounds of that ended up making it to a final destination. Okay, that caregiver's operating above board. Probably sell the next 20 pounds in 2027. I can then look at CGR 421. This caregiver claims that they entered into the portal that they harvested 1,000 pounds and 100 pounds ended up making it to an end user. That would be cause for an investigation. And potentially that caregiver just isn't too great a job. He's sitting on 900 pounds right there. OCP comes and clarifies it and OCP is on their way. Let's say there's a caregiver for CGR 422. They claim they harvested 100 pounds in a year and 1,000 pounds ended up making it to retail store. That's probably inversion. So it doesn't track individual plants, fractions of grams, but what it does is it does high level tracking and it tells OCP, and again, it actually doesn't tell them that because they would have to sort through the data, which I understand is work. But realistically, if I feel like anyone in this room could sit with that data that was inputted through the portal and see, obvious inversion and obvious diversion. It's enough data to where that should be easy enough to at least catch flags. And, they can develop their own internal processes to help them with those flags. So that's the high level on the tracking portion, that it's really to catch major inversion, major diversion, not track plants, not track fractions of grams. When it comes to, and also just one little note, you can buy, there's tons of online auctions right now for cannabis from all over the country that they actually advertise the metric tags when they're auctioning off this stuff. So it's not, there is no bulletproof way to prevent inversion or diversion regardless. When it comes to testing, so the high level differences are that we aren't including the microbial tests. These testing conversations and tracking conversations have been going on within the industry for years now. I've tried to be a part of all the conversations. I've tried to listen to every perspective, including I've had conversations now with all of the testing labs, except for I believe one who generally doesn't, they do other things, so they don't end up coming to all the industry-wide discussions. When it comes to the microbial tests, which is the aerobic plate count tests and the E. coli tests and the salmonella tests, for one, cannabis doesn't produce E. coli or salmonella. That comes from extremely dirty processes. The labs say that it's a non-existent problem in Maine, E. coli and salmonella in cannabis. And so those aren't included in our version because we're trying to not solve problems that aren't problems. When it comes to the microbial, the aerobic plate count, that is the test that is catching all of the beneficial microbials, which a lot of growers use intentionally because, as the name implies, they're beneficial. It also catches a lot of the inert microbials. And for all the conversations, and I'm not saying I've, fully have heard every argument on this topic, but from all the conversations that I've been a part of that include the testing facilities, I haven't been able to have even the testing facilities point to a harmful microbial that's popping up, that's actually showing up in Maine on those tests. So those aren't included. And again, it's because, there isn't sufficient problem in Maine or sufficient evidence in Maine to suggest that they need to be included. When it comes to the total yeast and mold panel, so again, in the Representative Graham's amendment, it proposes, still it's tests for the harmful yeasts and mold, including but not limited to, and that leaves the door open to it's essentially the blanket tests, and it could be whatever tests, whatever things are, being caught in that blanket test at the moment. But what I've heard from all the labs repeatedly, that the things that they are concerned with that are actually an issue in Maine are the mycotoxin produced by penicillin, which can be harmful for people that are allergic to or sensitive to penicillin, and for aspergillus, which can be harmful for people that are immunocompromised. So again, our version limits it to that. So the big, to zoom out even further there. So that's what, a lot of the beneficial microbials or inert microbials or the other things that are in the blanket TYM panel are what's causing a lot of the failures in adult use now. Our stance as an industry is that there's not sufficient evidence that those tests should be blanket tests, and that there isn't sufficient evidence that that's only capturing things that are harmful. So then if the testing protocol looks like that, I understand that there are issues in other states. So in Colorado, for one, if they're getting bigger recalls, there are much bigger batches. They have a massive tourism industry, and particularly they have big tourism that's centered around cannabis. For Michigan, they have, if they're having administrative issues, well, they have 8 times our population, and they have only 3 times the amount of staff in their cannabis regulatory agency. So one would, extrapolate that potentially, an office that is much better staffed per population would be able to deal with slightly additional administrative tasks. The mandatory tests that we're calling process tests in the bill, they're the mandatory tests. It is essentially to prove your processes. So for the things that we are testing for now, with getting the aerobic plant count out of the window, salmonella out of the window, E. coli out of the window, and the blanket TYM. So now we're left with pesticides, residual solvents, metals, toxins, poisons, and then we're also testing for the homogeneity and for edibles for the potency. So those are, with the other tests not being in our version of the bill, those are things that logically you can prove your processes on. Like, I know that anything I cultivate is going to test negative for pesticides because I don't use pesticides. And, if an operator is an extraction lab and they are producing concentrate that doesn't have residual solvent, which most labs who are doing that these days, it's the industry has progressed a lot over the years. It's a process-based thing. It would be impossible for me to have a test that fails for pesticides. It would be for any lab that's got solid processes, they're not going to fail for residual solvents. So that is why it's the process testing on these things, because since we've limited the scope, they're all things that logically apply to the processes. For the audit testing, so again, with the limited panel, the audit tests should be a representation of the processes performed by the operator. And if you fail an audit test, that means you started using pesticides for whatever reason. You did something that was, different from your process that you initially passed the process testing for, the mandatory testing for. So in that instance, that's why we have very clear, escalated enforcement on what to do there. There's no need to be, suspicious of a failed audit test, what there is a need to do is to then follow the process. So there's no need to be suspicious. There's just a need to then conduct the additional process, the additional audit testing that would be mandated by statute. So from there, it does progress pretty rapidly. So if an operator fails an audit test, so that's, let's say that it was I am trying to stay kind of high level here, but there's a lot, so I'm trying to move as quickly as I can. But let's say there's an operator that got a complaint, and so OCP does an audit test for them. They failed the audit test. Okay, so we're kind of already there was one potential bad product that raised the complaint. Then there was the audit test, and so that was confirmed bad product. So then, and we're, a couple of days in at this point. OCP submitted the test to the sample to the testing lab. They probably have their results within a couple days. So then they go to the operator and say, hey, we're pulling 6 additional tests for audit testing. Send those off to the lab, get those results back within a couple days. So this is still a very rapid process. If you've failed that process, then you're in hot water, because essentially, you proved your processes and then you've deviated from your processes. So in that instance where you failed that next round of audit testing, it does become, there are serious consequences. So then if you fail the next round, it's revocation or suspension, which is why we put in there that the operator would have the opportunity to pause all transfers to patients and to other registrants, thereby freezing their portion of the supply chain. And they can take whatever time they need, because again, no transfers are happening, and they can go through their inventory however they need to, whether it's, I got this from this caregiver and he's the one that made me fail, I'm going to get rid of, or either destroy or remediate or return all that product, or I'm going to send off R&D testing of my own and test everything that I have, send it off the lab, find out what's good, what's not. You have the time to take a moment and reset. We also have in there that you can remediate or destroy any product that fails. And then, because once you then say, okay, I'm ready for the next round of audit testing, which you would have to do to be able to make transfers again to patients and to registrants, is OCP is going to come in and pick 6 more. And if one of those fails, then it's up to OCP's discretion as to whether they want to revoke or suspend your registration.
So I want to stop you there, Mr. McMahon. Thank you very much. Any specific questions about what he said? Because I'm going to ask the representative from Public Health to come up and give their high-level view of these, because that is what Representative Fairclough would like to hear, and others may as well. Representative Frost.
Thanks, Mr. Chair. Thanks so much for being here. I guess I'm just concerned with these repeated, OCP comes in, tests again, tests again. This is costly, isn't it? I mean, all these tests are very costly, and I'm just wondering what's the fiscal note?
I've got a great, sorry, thank you for the question. So we actually did, so the senator's got a lot going on and misquoted this one part, which I'm sure he doesn't mind me correcting. So the initial audit tests we have in the bill, that's to be paid for by the department. That's the one which they already do audit testing to some degree. So it's already worked into their budget to some degree. After failing that, it's the operators paying for it. So the next batch of 6 operators paying for it. If they fail that next batch of 6, the operator is paying for it. So I appreciate you asking that question, because that needed to be clarified.
Thank you. Representative Boyer.
Thank you, Mr. Chair. In regards to costs, what's the level of testing between the Graham Amendment and the Hickman Amendment, and who would bear those costs?
So thank you for the question. So the costs on the Graham Amendment are huge. It's batch testing. So it's every batch of product. As we all know, and as Senator Timberlake brought up earlier, a lot of the med operators are operating at a smaller scale. That means smaller batches. So requiring mandatory batch testing on every batch of that product is hugely cost prohibitive. I know that there was one gummies manufacturer who's actually a very beloved brand in the state that explained that if he had to do, he does somewhere around a dozen tests or batches per day. And if he had to do mandatory testing on all those batches, out of business, no question about it. And he's, like I said, a beloved, brand. He's involved, he does everything right. He does periodic R&D testing, and the patients love his brand. He makes an excellent product. So I think for a lot of the smaller operators, they are, there is no feasible way for them to carry the burden of mandatory batch testing.
The
Now,
committee
for
has
the-
received an email from the person that you are talking about, I believe. His name is Paul. We got that email. We can see how he broke down what this would mean for his business. Any other quick questions
Yeah.
for Mr. McMahon before I call
Thank you, Mr. Chair.
Public Health?
And I believe it came from Mighty Viking Company, not his name, so colleagues are looking for it. It's Mighty Viking. Can you opine briefly on your thoughts on the Hickman Amendment as it relates to illicit cannabis coming into the medical regulated market?
Yes, thank you for the question. So that is, again, what I was laying out as far as in the portal, you should be able to see if there's an extra 1,000 pounds here, extra 100 pounds here. So that is the portion that's designed to catch inversion. So again, it's not a, automated thing. There does have to be someone actually looking at the data, but as long as there's someone looking at the data, there is enough information required through the portal that it should be clear if there is any inversion, because essentially there's a caregiver that's selling it to stores that it never got produced in Maine. So that should be
And also in just regards to testing and how the Hickman testing regime would affect inversion.
Sorry, could you rephrase the question?
How do you think Senator Hickman's amendment regarding testing regulations would deter or not deter medical operators from buying illegal cannabis?
Great question. So I think that one thing that this bill does implement is we all have a moral responsibility to only offer clean products to our patients, but this implements a financial responsibility to do that. Because if you are just buying whatever product is coming in that failed whatever tests and wherever they're coming from, or if you're buying from, operators that have, poor practices and are doing so to get just cheap cannabis out the door, you are opening yourself up to that liability. And so it introduces the financial, reality that if you're failing for stuff that you're carrying on your products or on your shelves, or you're transferring to someone else, that could be very costly for you, both financially and as far as it could cost you your license.
Thank you. Representative Fairclough.
Thank you, Mr. Chair. First of all, I was a government major and went to law school, and I just find a lot of this challenging, all the scientific lingo. And I got to say, you make a strong presentation, even if some of it I still find challenging to go through, regardless of who's discussing it. But when you mention in discussion, particularly the medical market, just I get big picture that a lot of states, or at least arguably a lot of states, because it is medical, follow a very rigorous, potentially costly rubric. And I'm just curious about what your thoughts are on that in Maine, contrasting with potentially other states.
Thank you very much for the question. That's a great question. So, there are a couple of realities that we live with here in Maine. So we are a smaller population state. We also are a lower income state comparatively. So not necessarily everything that works for every state is going to work in Maine. There's the reality that the industry came forth out of essentially cottage industry. And then there's the reality that, our patients and consumers are financially limited, and that in a lot of areas in the state, you'll see that if you change prices by $1, it's enough to drive people back to, if you change prices in adult use, it's enough to drive people back into med. And if you change prices enough in med, it's enough to drive people back into the illicit market. And I think that has been one of the larger, focuses of the legislature, of the industry, of the office. It's been one of our, kind of shared goals, is to bring sales and bring the consumers into the regulated market. So I think that just in the realities that we live with, there's, we're not operating in a vacuum. There is an active illicit market. Additionally, as far as the background for, you mentioned some of the different rubrics that different states are using. So really the history of that is, this isn't a spot on history. This is my high level understanding of it, but it's been states copying other states from, basically if you trace it far enough, it was just come up with arbitrarily. So, we are operating in a system that is fairly arbitrary, and the industry has been maturing, and, there probably is enough time to try something very different that has the potential to work before going drastically, in this direction, which I will say both amendments go in this direction towards more regulation. So the Representative Graham's amendment, might take it 1,500 miles this way. We're at starting point A. Senator Hickman's amendment still takes it 1,000 miles. It's still far more regulation than the medical industry has ever had in the state of Maine. So, it's not like oftentimes there's a proposal that takes things this way and there's a proposal that takes things this way. We are heading in the same direction. It's just not quite as drastic, but I think that given the reality of our industry right now and the dynamics of the market, then I feel like it is appropriate to take that, more calculated approach forward instead of going fully to where adult use is. And, the legislature will be back in session after session after session. And, if we start there, there's no chance we're gonna get here versus if we start here, we could see how it goes. And I think that honestly, it is a tight program. It is a well-contained closed loop system. And I think that the industry will be better off and the state will be better off.
Thank you, Mr. McMahon. Public Health Representative, please come forward and take the seat that Mr. McMahon has. And as others have done, give us your high-level view of what's in front of us today, knowing that you've just seen some of it today for the first time, but everyone is doing the same thing and very well, I might add. So please introduce yourself.
Thank you. Good evening. My name is Becca Bolas. I'm the Executive Director of Maine Public Health Association. I had to type this out.
That's perfectly fine.
Sorry, I'm reading off my laptop. So I think the first point that I want to make about really Representative Graham's bill, because I'm the most familiar with that,
Of course.
is that the framework for her bill is evidence-based, and the standards for it are based on a risk-based assessment of how you're being exposed to cannabis. So whether you're smoking it or you're eating it. And so the reference standards for the test are based on that modality. Her bill references international scientific bodies, the British Pharmacopoeia, all the ones that Rachel listed off, the US Pharmacopoeia. And the nice thing about that is that those are research organizations, they're scientific organizations. And so that as the science changes, the standards may adjust, but they're tied to data in the real world with scientists. The second is that we've been working on this bill for about a year. And I want to echo what you said earlier about this being one of the bills that I've worked also the hardest on as a public health advocate. LD 40 may be competing with that from last session, but we did work a lot on this bill. And I would say that our stakeholder engagement was very broad. We met with patients, with people in the medical program, the adult use program, public safety, medical care providers that treat kids who have developed psychosis. We've met with just so many different people. And a lot of parts of her bill, and the reason that you've gotten so many amendments on it is because we've listened to people, we've made changes. The carve-outs that are in there for industry, whether it's medical or adult use, came from those respective bodies. And I really want to hammer that out, that this has been almost a year of work on this bill with a lot of different conversations, a lot of different people. Her bill, implements mandatory tracking and mandatory testing and tracking, which are really the gold standards or best practices. And there were a couple of things that Alex said, and he and I have talked about this separately, but I just want to offer a different perspective, which is that my background is really also in food food supply chains, and it is standard to track in the food supply chain. Whether you're tracking spinach or you're tracking beef, you will have to know if there's an outbreak where that started from. So if you look at the front of a package with that UPC code, you can look up online and see where those cows were. You can know what plant those came from. And the same thing true is when you see, like, if you were at Hannaford and you bought spinach from this brand on these days, they're able to do that because of tracking. It is entirely standard to do this in other industries. And I've heard a lot said that this is a crop, an agricultural product, which it is. So just drawing on that is common. The other thing that I'd say is that we also talked with labs. Those were in our stakeholder group 2, and we heard something different about the E. coli testing in particular, that there were actually many positive tests for different types of E. coli. And so that's why we included that in our bill, or in Representative Graham's bill. And then the one thing I've been spending time back here trying to compare and contrast these different bills, like kind of line by line. In addition to what you heard earlier from Gabby, which I share what she said, the one section that I'm very concerned about in your amendment, Senator Hickman, is on it's section 814, page 3. And it's the part that talks about if a product tests positive, I think it's for aspergillus, is in there, that it's still allowed to be sold. And I really do worry about us allowing in law selling a product that we know is going to harm a patient. So I would just encourage consideration for not allowing that. And that actually, if they do fail those tests, that it's not allowed to be sold. I don't know if that's the high level you were looking for, but that's where I'm at right now. And I'm also happy to answer any questions.
I appreciate it. With to trying to get the high level perspective of everyone who has worked hard on this in whatever capacity for the committee members to digest. In your stakeholder outreach, were you able to engage with parents of pediatric medical cannabis patients?
Yeah, I think you'd asked me that the other day. We did not
Okay.
talk to
I wasn't sure that I
parents.
did,
Yeah,
but
no, we did not. I did not personally.
Okay, thank you. Any other questions? These are high level, no arguments, please. We'll argue amongst ourselves. Representative Graham.
Thank you. You all did receive an email from a physician in the Portland area whose adolescent child is undergoing chemotherapy.
Yep, I got that.
And I just wanted to note that. Thank you.
Yep, I definitely spoke with that person or responded to that person. Yes.
Thank you.
Any other questions? Representative Boyd.
Thank you, Mr. Chair. Thank you, Ms. Bullios. Do you know of any, I'm gonna ask a series of questions and they'll be brief. Has anyone died from medical cannabis or cannabis in Maine?
I don't believe anyone has died from cannabis in Maine associated directly with that cause.
Thank you. Hospitalizations have been on the rise. I think it was 83 in 2025 from Maine Health.
Mhm.
If we assume all 83 of those folks consumed medical cannabis, would you consider, get the decimals here, right? Would you consider 0.00083 as statistically significant and a good reason to have a big policy change?
I wouldn't attribute the bill just to those rising cases. But I also wouldn't just assume I knew where they came from. So I have a hard time answering your question.
Thank you. Representative Fairclough.
Thank you, Mr. Chair. It's been referenced by both about comparisons to other state, and I'm curious as to your response when comparing these two different proposed amendments, the similarity and dissimilarity as to public health in comparison to sort of the spectrum of what other states have.
Yeah,
law.
thank you. I sort of agree. I mean, I do somewhat agree with Alex that states are just copying states, which may not always be the best thing to do. And I don't think that that's unique to cannabis. I think that's true in other policy areas as well. So,
Unfortunately.
I'm sorry?
No, I just said unfortunately.
Yeah, unfortunately,
With some
right.
other
Yeah,
policy
yeah,
areas
yeah.
in
So
particular.
I don't think I think that happens. I understand why it happens. I just
Yep.
don't think that that's uncommon. So the framework for this really came from Canada, where cannabis is legal, and so they are able to conduct research. And over the summer, I spoke with regulators from Canada about their program, and was able to get feedback and get some questions answered. And so that's more where this was, as opposed to looking at other states. And I was trying not to just, when we were discussing what type of framework this would be, definitely heard at the public hearing that the medical program did not just want taking the adult use program and just kind of stamping that on their program. Made a lot of sense. The carve out considerations made a lot of sense. So really it was kind of taking a step back and thinking about, well, what would work, what does make sense? And that's really where it came from. Does that answer what you were asking?
Thank you. Representative Fairclough, one follow-up, please.
Thank you. That's informative, and I won't expect a long discursive answer now, but I'd be curious about how, for example, you found, as it happens to be another nation, to be persuasive as this is the, most effective way to address these issues versus
Yep.
say, the multiplicity of states that have laws.
It was the matrix model, so it makes sense to me from a public health perspective that the way you're being exposed to cannabis, whether, like I said, you're smoking it or you're eating it or whatever, that your risk would change for these different potential contaminants. Like that makes sense to me. And it also makes sense to look to scientific bodies for what those standards should be, which is what they do. Yep.
And for a future answer.
Yeah.
Can you let me know if in the research you found that they're finding actual harm to patients versus the potential for harm because of what it is? Because I still haven't seen that, and I'm wondering if in those other places, they have evidence of actual harm, not just risk.
Sure. Yep.
Appreciate that very
Yep.
much. Any other questions quickly? Seeing none, we appreciate
Thank
you
you very
being here.
much.
You'll be back. I'm gonna call one other person up for, this isn't a high level review, the chair will be honest. I want to hear from someone. Mr. McMahon worked on this amendment, of course. And full disclosure, Mr. McMahon cultivates in the medical program, but in the adult use program is only a retail operator, is that correct? And I'm not going to ask anyone else from the adult use industry to give us a view, but I am going to invite Christy Shaw, who sent us an email the other day, to come forward and give us a answer to Representative Boyer's question that he asked before break to someone who has said her business model is such that the proposals, probably both of them, would not actually work very well. And so I want to hear from someone who's not necessarily interested in any of this and maybe has something else to say. Please introduce yourself.
Hi, I'm Christy Shaw. I am from Hamden. I'm a cultivator with my husband. We grow and have been caregivers since 2016. I'm also the chair or the vice chair of MMCM and founder of the Maine Women's Cannabis Council. So I talk to a lot of caregivers. I guess the question was, how would it work for me?
Either amendment, both amendments.
Yeah.
Cost.
The cost. So the cost that I laid out specifically was for Metric.
Okay.
Metric would decimate my business and most anyone in this room that's a small cultivator and not vertically integrated.
And just for people who may not know what vertically integrated means, can you say what that actually means?
That means, like as a grower, we just grow and then we sell. But like if you're vertically integrated, you grow, you manufacture, you maybe make some edibles, and then you sell it at your store. So we don't have that. And part of the reason why we don't have that is because our town is not opted in. So that makes it harder for the small rural. I am up north, so it makes it a lot harder for the small rural growers to be able to vertically integrate at all.
So can you tell us based on your business model, and this will be my last detailed question for you. What would it cost to comply with Metric in your business model?
For Metric, I had estimated the cost to be, I think it was $500 a month, and it would be in excess of $6,000 a year. And as of right now, I mean, we're barely able to pay our $2,000 to $4,000 electric bill and all these other things. So it would put me out of business, and it would put most of the home-based caregivers out of business that I know.
And what about the mandatory testing that is proposed in either bill? What would that do to your cost?
It's hard to say. I think that if I was just required, so I actually went and got the tests for the pesticide, the molds, and the heavy metals the other day. It cost me $255 to get that test. I usually do that test about once a year, just to make sure everything's straight. And that's doable. A lot of caregivers do test at least once a year. But to do every batch, every harvest, everything that goes out, I mean, there's no way we can compete. We would be out of business for sure.
Senator Timberlake, you had a question for Ms. Shaw?
Yes, I do. And Senator, you basically asked, part of the question was, how much did you figure Metrics was going to cost you? And can you give me a little bit of a breakdown of how you get to that number per month?
The majority of it will be time. If I were to just the base, I think the system itself is like $45 a month. The tags are, I do believe it's 26 cents a tag. And that for outgoing products, so if I were to break it into eighths, it would be a tag for each of those. And then the plant tag, I think, are 46 cents a piece.
And you put this in an email for us.
I did
you
put
not?
it in an
Yeah.
email for you. I'm sorry. I am just calculating, so numbers just kind of
It's
fly
really-
around in
No,
my
that's
head.
fine.
So I'm doing this.
I'm not a good email person, let's
Yeah.
be honest.
Okay.
Better than I am.
Yep.
Yeah, I just.
Well, I'm happy to
again,
talk
I'll
to you
find
about
it then.
Yeah, we do have an email from Ms. Shaw. I just wanted her to put into
Yeah.
the record her experience with what is going on in of these proposed amendments. Thank you very much for being here.
Yep.
I'm gonna call one other person forward, and then the committee is going to maybe have some discussion, and dinner is on the way. So I know that there's a person in the room, Lizzie Hayes, please come forward, who has worked with both the bill sponsor and has worked with the industry on a consensus amendment, and frankly does not agree with any of it. And I want her to explain why she doesn't agree with any of it and what is an alternative path forward from her point of view. And we can ask her questions as well. And then that will be enough back and forth with stakeholders, and the committee is going to have to decide about how to approach the rest of our week if we need to do that. So Ms. Hayes, please introduce yourself.
My name is Lizzie Hayes. I am a organic outdoor farmer. My products are certified by the Maine Organic Farmers and Gardeners Association, and I also grow organic garlic and organic hemp. I'm gonna try to be succinct in what I
Yes,
say.
succinct is what we're looking for at 6 o'clock.
Yeah.
Thank you.
So, the amendment proposed by Representative Graham would cost my business an additional $60,000 a year, which is more than I make from that business each year. The testing aspect of that would be $54,000 because we do a lot of different seed batches. So we have 129. Last year we produced 129 batches. And so that would sort of cut out the R&D possibility for my business. Whereas the other amendment in terms of costs would be more like it's hard to know the costs. When I reached out to the lab, I was getting different numbers, but it would be around $3,000 for me to get through those audit tests so that I could or the process testing for the two different scopes that we make on my farm, which is flour and concentrates, and then move to the audit testing. I think that from my experience in the organic program, I know that every system, we're all well aware of the problems with metric and that you can still be inverting and diverting within those program rules. And I think in every regulated space, there are going to be people that are not following the rules. But I think that the people who do follow the rules are the ones that we want to keep in the space. And the smallest operators are the ones that I see being the greatest value to Maine's medical program. They are the ones who pull together donations for very sick patients. And I think that, you know, a bill that imposes metric and mandatory testing is going to remove the people from the program who provide the greatest value to patients through donations, home visits, and personal relationships. And it's going to favor larger, more corporate structured businesses. The places that I have found no disagreement is that we all agree that we would like to see pesticides tested for. We don't believe that people using pesticides belong in the medical program. Prohibited pesticides, and there is a lot of debate about thresholds for contaminants. And I know that last year, Representative Osher was talking about what her colleague in California had said is there is no real scientific consensus, but there is clear consensus that prohibited pesticides are a violation of state and federal law. And so I think the case for pesticides is very clear. So everyone that I've spoken to in the program believes that we should be audit testing as described in the program rule currently. If the program rule that already exists were implemented, that would be a huge step towards protecting patients, and it theoretically wouldn't cost anything because it's already part of the program. And it would target pesticide use because I believe that in the medical program currently, that's the only thing that you could have a consequence for exceeding a threshold of would be these prohibited pesticides, which is a major violation affecting public health and safety. And then the other consensus point is that there should not be residual solvents in concentrates. And so those two things, I think there's complete support for testing those things. And seeing the audit testing that's designed in the program already executed, and then an increase in the record keeping requirements because in the organic program, I am required to keep records in order to have the inspector walk through my records with me and do a mass balance, which would identify diversion or inversion, or do a traceback audit to show that I am able to recall a product. And that's something that can happen during an annual inspection. That's when I do that with my my organic auditor. And if I could just read what those requirements are in the National Organic Standards, they are to maintain records concerning the production, harvesting, and handling. Such records must be adapted to the particular business that the certified operation is conducting. Fully disclose all activities and transactions of the registered operation in sufficient detail as to be readily understood and audited. Records must span the time of purchase or acquisition through production or sale or transport and be traceable back to the last registered operation. They must include audit trail documentation for products handled or produced by the registered operation. Each product received should either have a lot number with it or should be assigned a lot number. Anytime harvested materials are combined or blended, a lot number must be assigned to the finished product. If a product is purchased from several sources, a production batch or record should list the sources and lot number of each product, and they should be sufficient to conduct a recall. So that sort of covers all those bases of, I think, what is in the Senator Hickman's amendment as well for record keeping requirements. And then the other thing that has come up as a consensus that we all feel is important is that on the trip ticket or your transfer log to identify where that material originally came from, because there should be transparency to where that source material initially was harvested from. That would also help identify inversion. If there was a certain registration number that seemed to have all the material attributed or quite a lot more than would be able to be produced under a caregiver license, that could identify that. And I've heard from patients as well that sometimes they purchase products that are white labeled and they want to have more transparency about where did that product initially.
White labeled?
Where someone would buy material and then put their own labels, like a storefront maybe buys it from somebody that we hope would be a registrant in the program, but maybe there's concern that they wouldn't be. And they put their own product packaging on it and sell it. And a patient would want to know, well, who grew that? And if that's on the trip ticket, then that store operator could say, oh, maybe we'll find out where we got the material from. This is where that material was produced. So they could trace it back to the original cultivator and harvest person. who
And
harvested
you are
it.
inspected how often for your organic?
Annually.
And how long is an inspection based upon what you just said you have to keep records of?
It depends on the size of your business. So when I was just certifying a small hemp crop, it took about an hour. Now my audit involves the medical cannabis operation, so it ends up taking about 3 hours.
And when you are inspected by the Office of Cannabis Policy for your caregiver business, how long does that inspection take?
That takes about 25 minutes. And there's not the same sort of walking through of records or inspection of my pesticides cabinet. And like MOFCA will take photos of the different amendments. We have to, go through everything that we apply, partially because they are making sure that we adhere to organic standards, which is outside of the scope of chain of custody.
And trip tickets, you keep those?
Yes.
And those are inspected by the office?
Yeah.
Okay. Any questions for Ms. Hayes from the committee? Seeing, well, there was one hand.
Well, I don't want to dig into particular.
We don't want, yeah, but we're kind of, this is more mid-level than high, but are there any questions? Seeing none, thank you very much for being. So, committee. We've heard a lot, we've seen a lot, we've read a lot, we still have more questions. Is that correct? Chair recognizes Representative Speaker? No? It was a general question to the committee. Find the chair. My phone is ringing. What I'm thinking is it's 6:10. We could take a break for dinner and possibly fall asleep on our way back in.
No, I'm moving on.
The chair would suggest, in order to meet our deadline, that we return on Friday afternoon. Look,
We're already coming back from.
Vote on that?
we can absolutely vote on that. And if we don't do it today or Friday, excuse me, we'd have to wait until next week, and we don't have permission to discuss this legislation next week. I guess the other thing we could possibly try to get permission for would be to meet tomorrow after session in order to meet the deadline that we have for this particular piece of legislation. And that just came to me right this minute. And because we're on a deadline and did not poll the committee to find out if we would have a quorum tomorrow after session. But that is another possibility that we would have to get permission to do. So Representative Fredericks, what do you want to say?
Mr. Chair, I guess I'll throw out this. Is there an opportunity to have a straw poll to see where we're sitting? Are we striving for just a unanimous vote, or if we're gonna, if we're gonna have a divided report, that's a reality that may not be overcome. But if there's an appetite to get to an achievable bill that the industry, both the industry and the department can swallow, I mean, I'll stay till midnight I'll stay till the morning to make that happen.
Okay, Representative Fairclough.
Thank you, Mr. Chair. First of all, I share that viewpoint and I was ready. I understand there's differences of opinion and I respect those differences of opinion, but I was ready to move the goldenrod amendment and let us proceed. And I, for one, would be willing to stick here late tonight to achieve if there's more that needs to be achieved before a vote. But I'm ready to make that motion if it's acceptable.
Senator Timberlake.
Thank you, Mr. Chair. Number one, I'm not ready to stay later. I started 2 o'clock this morning. My disposition's gone. I'm right on the edge. I'm right on the edge of losing. Okay, but with that being said, I've sat on committees with Senator Hickman now for probably 6 or 7 years between ag and everything else. And he's always worked pretty hard over my time here. I hate to give him credit for something, but it's gonna hurt. But at trying to get a consensus on a bill. I've tried to try to find a consensus on a bill. I'm not convinced that if we want to, now, if you don't want to, if it's in your mind that you want to pass the Graham amendment, then so be it, and we go ahead and we'll have a divided report and we'll move on. But I have talked to a lot of these folks out here in the crowd, and they'll look at you and nod and agree that I've been trying to work at finding something that'll be, because I'll tell you what, I'm watching the marijuana industry, and I don't smoke marijuana. I don't use marijuana. I won't say I never have because I'm not Bill Clinton, but it was back in the 70s. But what I'm saying is that if we don't do something to figure this out and figure it out right, the illicit market is going to drive the adult market out of business because they're going to pass a referendum. And if we don't figure a way to take these two bills that ain't that very stinking far apart and find a play to make them work, and these guys are going to have to give and take, and ladies and gentlemen, then we can get there. But if we don't want to do it, then we'll just pass it. We'll go to the floor. We'll make a fight, and that's where it'll be. And it'll probably die somewhere in between because the governor probably won't sign it, or something will happen, and that's where it'll be. And then we destroy their industry. I'm not looking to destroy their industry. We need to pass something that's going to pass. And we need to figure it out. And I think it's our job. And I'm sorry for ranting, but Senator Hickman, but we have worked hard on a lot of different bills that we thought we would never get there. And we get there. And this is part of the problem that I hate in this building right now, is we've stopped trying to work together from both sides. I'm not blaming one side over the other, from both sides. Now, we can either step forward as a committee and try to make this work, or we can go our separate ways. And I'll play the game either way because I'm good at it.
Thank you for that sentiment, and I'm happy to, if people want to keep talking, but I would want to keep talking. I agree with Representative Fredericks tonight.
Thank you, Mr. Chair. I appreciate what Senator Timberlake said. I don't quite agree with all of it, but I agree with what he's getting at. And I mean, we got to put all our cards on the table and figure out where the heck we are. Like, quit the BS. What's the red lines? What's the breaking points? Where does the rubber meet the road? Do we want to work together to get something passed, or do we want a divided report? And we might still have a divided report. I completely acknowledge that. Again, I believe the Hickman Amendment is a good faith step forward in mandatory tracking and testing. They are receiving nothing for conceding money and time and regulations in the hope, one, that we can, I think there is a hope that this would help the illicit market, a genuine hope from the people that wrote the Hickman Amendment. But they're also scared shitless about metric, and they're scared of losing their business. So they're ready to concede a lot of stuff in this Hickman Amendment so they don't lose their business. And I take Representative Graham at her word when she says she doesn't want anyone to go out of business and that she agrees that metric is flawed. So if that's the case, let's work together and split the difference. Thank you.
Chair recognizes Member Speaker.
Thank you. We also do other work besides cannabis here, and we have other bills that we didn't get to today that we are going to have to come back and work, and this week. And we're not going to be able to work them tonight. And this is the short session. So we're going to have to come back at some point. And so I get it, the grumbling. I'm grumbling too. I'm internally all the time. And I share some of the sentiments that I've heard before, and I just, this is part of doing the work, is coming back over and over again. And I've also been in this committee when we've tried to make laws late at night and it gets loopy and it gets messy and we make some wackadoodle, we get really we get wackadoodle. And let's not forget the nonpartisan staff who has to sit here as well. And I just, and see, I'm already getting tired and forgetting what to say. To respect you, if you're committed to the gold amendment, then come help us with a quorum and go ahead and walk away, and then come back when you want to vote, take care of your body, go do what you need to do, don't feel like you have to be stuck here, go, like, that's normal. But part of doing the work is having to come in, on many days. And just because it says to be determined, that didn't mean that you're not going to come in. It just means we don't know exactly what bills we're going to be doing on that day. And I'm also fine with staying later on Thursday as well. So that's just kind of part of what we're doing when we signed up to become legislators, is this erratic schedule. And that's why I don't even really have a job right now, because it's hard to wait tables and be a legislator. So this is part of the job. I'm sorry, I'm getting a little testy right now.
Representative Graham.
Thank you, Mr. Chair. Thank you for everyone's hard work. Many of you know that I started Common Ground Caucus. I actually started that when I was here before in 2012. I work as hard as I possibly can to bring people together, to come to some sense of common ground. As I said before, it's the hardest bill I've ever worked on. Worked on it for a year, not the last few days. And I know I have support from leadership on my bill. And I would love to see a unanimous report, but I don't think that's probably going to happen. What I do request is that we try to do this tomorrow after session, and that we come in ready to vote. I think we all are pretty sure where we're at in relation to my amendment and Senator Hickman's amendment. And I appreciate the hard work, and I hear the voices. I've said this before, I am not here. This bill is not here to put anyone out of business. Excuse me, not appropriate.
Please, y'all. I know it's tough. And I'm only going to interrupt for this second so that you can finish your thought.
Thank you.
I know it's tough for people who are in the medical cannabis program, who are facing demise.
Mm-hmm. Yep.
And so when you're in the room and you want to emote, I get it. I really do.
Yeah.
And it's late and people are tired and you're scared. So be human and just remember to be respectful. Representative Grant, please proceed.
Thank you, Mr. Chair. I really appreciate that. I really appreciate that. Again, my goal is to make this industry, medical cannabis, safe for all patients. That's my goal, period. So with that, I request that we can ask the presiding officers if we can do this tomorrow after session so that we don't have to come back again on Friday. I appreciate Representative Faircloth's motion, but I also agree with Chair Supika that we're tired This has been a long time and we worked so hard. And again, I want to thank you all and I want to thank everyone who's put so much into this. So, you know, that's my request. Please come back in tomorrow afternoon and be ready to vote. Thank you.
Representative Frost. I saw your hand.
Yeah, thank you, Mr. Chair. I guess I like the idea of coming back in fresh because I don't think legislating late and overtired is good for anybody. I also like, I like Senator Timberlake's thoughts about how this is our job to try to come to some consensus. I also want to say, nobody wants to see the industry, the cottage industry go out of business, of course, but we do have to take into account, public health and the safety of people of Maine. So it's a lot to try to figure out, especially if we don't have, a ton of expertise in cannabis. I was going to close with one more thing. I guess I like the idea of coming in tomorrow, just after session, and I know what I was going to say. I think the biggest piece to try to figure out is the finances, to me, that's because it's a financial problem for the industry. And I don't know whether appropriations is going to come along with us on this. I guess that's the biggest problem, I think, is the finances at this point.
As we know in this committee, unless there's a preliminary fiscal impact, which on a bill like this is almost impossible, we won't see a fiscal note on either report until something is voted on, if these are the reports that are voted on. So I can only say that without getting into something else I want to say in a minute, but I'm going to take some more comment. I have to ask Ms. Olson a question first. Ms. Olson. Who's also tired, because I think it might be true that we might have both been up all night in our separate spaces. The question, see, my mind is not really clicking. Is it possible for your schedule, if we were to get permission from the presiding officers, to have a work session tomorrow after session? Because I don't know your schedule, and I know you are our principal analyst, but I can't commit you to something that you might not be here to do.
Yes, I am available. I would direct the committee to the time because you're asking to meet tomorrow after session. I do not know if it would get in front of the POs before tomorrow morning and how quickly they may or may not authorize it. And I am always surprised by what's approved or not approved, but Thursday is not an authorized committee day and Friday is.
Yep.
That may factor into a decision.
Yep. Thank you. I know tomorrow is also the state of judiciary, but that's a joint convention in the daytime, correct? Yeah, it's not an evening session. Representative Boyer, Representative Faircloth.
Thank you, Mr. Chair. I don't see the logic in meeting tomorrow just to vote. If it would make sense to meet tomorrow and work, but at this point, let's just vote. It doesn't sound like the people that are supportive of Ann Graham's bill will yield at all. So let's vote. Let's let people go home and figure out what they're going to do with their cannabis business and figure out a different line of work.
Representative Faircloth, Ms. Olson next.
Well, after hearing for us, I was okay with attempting tomorrow if it's logistically possible. Ms. Olson has raised whether, it's logistically possible or not. But that's fine with me. I want to follow, what Senator Timberlake said. If there's some way to get there, let's get there for some compromise. But I also am somewhat dubious that we will get there but I'm happy to stick around tomorrow, whenever.
And Friday afternoon, since that is our authorized day and we are on the schedule to meet to be determined. Thank you all for weighing in on the conundrum, I suppose, that we face. The chair is not, I don't have all my questions answered, even on the amendment that I am the vessel for. And I will say to Representative Graham, honestly, I have no idea how I'm voting on even this. Okay, so I'm not set on this or something else or nothing at all. Oh, Ms. Olson,
We have birdies listening to us.
we have what?
Birdies, birds.
Oh, birds, okay.
There are people who are listening to us in my office who have called when they heard me make my comment on Mike. Michelle was going to relay the message.
Thank you, Madam Clerk.
Thank you, Mr. Chair. I just received a call from Rachel's boss, Danielle, and she is ready to make a call to the providing officers tonight. And we might possibly be able to meet tomorrow, but it's very wide range. She's going to attempt to make the call.
Okay, great. Thank you very much for that message.
choose.
If we so, right, authorization doesn't require us to meet tomorrow. It would allow us to meet tomorrow, should we decide to try to do that. So thank you, Madam Clerk. And just to finish my thought, and I'll try to be brief, because I know Senator Timberlake is about to get really upset with me if I talk too long.
Just going.
Obviously, working hard as a lawmaker is what we do if we take our job seriously. And I certainly work hard on everything that I do in life, including this job. And I know that on issues that I'm really passionate about, it might take 7 years for something to pass. The Maine Food Sovereignty Act took forever. Timberlake never agreed with it. Right to food took forever. I'm not sure that Timberlake even agrees with that. The point is that the work I've been doing on cannabis since I started in the legislature came in one of the very first bills I put in, and the industry on the medical side has matured, but not necessarily in a way that I would have liked to see, because there was an agency that didn't enforce anything and allowed, in a lot of ways, the medical cannabis community to be the thing that they called it. The WWW. I won't say it because I don't like to use that term, but you know what I mean. And that meant that even before the Office of Cannabis Policy was created by the Marijuana Legalization Implementation Act, there were provisions that the HHS committee, under their purview, put into statute that the department at the time never even bothered to enforce or develop or implement. And one of those things was the research program, which has been in statute for a really long time. And in the last 3 sessions as a state senator, I have tried to get the new Office of Cannabis Policy to write those routine technical rules before 2021 to implement that research program. And I believe it could have provided a lot of information about how cannabis is actually effective or not effective in people's bodies and on their skin and for their health. And so all of that is to say, this moment that we are in is really hard for the chair, because I know everyone doesn't agree out there. And I've been able to facilitate some consensus over the years, and that might not happen here, which I fully understand and will accept. But that doesn't mean it's easy. And I'm not in the business of any of this, nor would I ever be, because even this amendment, this is too much regulation for a guy like me to even want to understand, much less try to run a business around. And so I don't, and I've said this to the stakeholders who worked on this amendment, it's like, y'all put me in a pickle because this is too much. So I don't know what I'm doing either. And what I always say is that no matter what I support or don't support, I want whatever passes to have a chance of working and to be fair to all concerned. That's like the Rotary principle. And I don't think either one of these pieces of legislation is fair to all concerned. And I don't know if we're ever going to get something that is fair to all concerned. And so I guess that means I'd be inclined to just vote no, but I don't want to vote no. I want to vote for something that undergirds and strengthens the medical cannabis industry for patients who have never sat in front of us or stood in front of us and told us that they needed any of this in order to feel confident in the medicine that they received from their respective caregivers across the entire state of Maine. So when I hear people say we have to do this for the patients, we have to do this for the patients haven't said we have to do this for them. That's a fact of my entire experience in the legislature on this subject. And I'm saying that with passion because it's true. The patients have not come to this committee en masse or even in an email and said, you need to do this for me. One or two, yes, but patients, plural, haven't asked for any of it. And so in my humble opinion, much of this is about market share and economics, and it really has secondary to do with public health. And so I don't know what to do. All I do know is that we have a deadline where we have to vote these bills out. It's Friday, close of business. If we can meet tomorrow, I'm happy to work more tomorrow to get some of my questions answered that have been put into the atmosphere that not have yet been answered. And if we can't work tomorrow, I'm perfectly willing to come back on Friday, long weekend and all, and finish the work to make sure that whatever we send forward to the legislature to consider is as fair as it can possibly be, even if it's divided. Representative Sapika.
I just want you to know that House leadership has sent me a message approving tomorrow, and I don't know what the Senate's doing, but House is at least doing their work.
It's okay. So. Okay. So Senator Dusan, would you like to say that into the record or not? It's okay if you don't, but I don't want it. Fine. So the question is, not knowing if we can work tomorrow or not, knowing that we can work on Friday afternoon and knowing that staff and committee members don't necessarily want to all vote or be here today. What are we going to do? Shall we adjourn or shall we take a break for dinner and come back and keep working? That is actually the question that I have, because I'm not ready to vote. So what are we going to do? Representative Boyer.
Thank you, Mr. Chair. I'm happy to stay and do the work, and we just need people to talk.
Okay.
We need people to say what their deal breakers are. We can't just we're just wasting time if we don't talk about what we like, what we don't like, what we need to move forward. Thank you.
Representative Chapman has raised his hand. Thank you, Madam Clerk, for alerting us. So Representative Chapman, please introduce yourself.
Thank you, Chair. Representative Quentin Chapman, District 88, Auburn, Maine. This is one of the rare times when I would say I would like to adjourn. I haven't slept in quite a while either. I've been trying to listen all day, in and out, but I've been sitting here for a few hours anyway. And I would much rather be there than be here trying to participate. And yeah, that's my 2 cents.
Thank you, Representative.
Thank
for
you.
your 2 cents. We'll take it. Senator Dusan.
I'm happy to do what a majority of the committee wants to do. I can stay longer tonight. I can come together with the committee tomorrow, make sure we have a quorum. We do have the State of the Judiciary tomorrow, so we have to factor that in. I think that both sides have worked hard on this. I've watched them work hard. The committee's worked hard. I think we just have to make a decision. And my inclination is the
Gold
amendment. I think there has been a lot of movement in the Gold amendment. And but if by doing another hour's worth of work, we can get to a compromise that, people are nobody's thumbs up or thumbs down, people are kind of sideways on. I'm happy to continue to participate in the process.
Thank you, Senator. So let's do a straw poll or raise hand poll. All those in favor of continuing to work tonight, please indicate in usual manner. Okay, all those who wish to adjourn and come back another day, please indicate in usual manner.
Another day tomorrow.
I said another day. And I see that Quentin Chapman has already said that he would like to adjourn, so I'm counting him in that. So if the majority rules, then it means we are not going to continue working tonight because the majority does rule in that regard. So
Motion to adjourn.
thank you all for your attention and time and reading, and thank Ms. Olson.
Shall I request permission formally? I realize it's been done informally.
I have not adjourned, and I was
Is-
going to ask you
For
to
tomorrow.
request
Okay.
officially on the right paperwork signed and initialed by the chairs that we are able to meet at some point after session tomorrow to continue the work. That's what, yes, please do that, Ms. Olson. And just to everyone on the committee and stakeholders alike, you can see where we are. And as Representative Boyer said, you may want to start putting your lines in the sand so that it becomes very clear where you're not moving and where you might have some wiggle room to move. And then that's what the committee will take up. It'll be our turn to debate each other and with each other. And as we need questions asked and answered from those in the industry who are going to be impacted, the department who has to regulate, if there are questions, obviously we'll call them forward to ask. But it's going to be up to us to convince each other about what we're doing or not doing. So with that, and without objection, the Joint Standing Committee on Veterans and Legal Affairs